We are live.
Okay, thank you, Sandy. All right, good afternoon, everyone, or good morning. Welcome to the Judicial Proceedings Committee. We will start our hearings. Today is Thursday, January 21st. We have 8 bills on the docket today, and I will just briefly list the order, although they are posted on the website and we'll be going in the same order as is listed. So first off, we have Senator Elfreth with Senate Bill 43. Second is Senate Bill 237. Third is Senate Bill 260. Fourth is Senate Bill 178. Fifth is Senate Bill 276. And seventh is Senate Bill 166. Eighth is Senate Bill 71. So without further ado, we'll start off with Senator Elfreth with Senate Bill 43. The floor is yours.
Thank you so much, Mr. Chair, and thank you to the members of the committee. It's exciting to be here, albeit virtually. I'm here to present Senate Bill 43, which is really just an update and expansion to a law this committee and the Senate passed in 2018, providing greater protections for those who interact with our law enforcement officials. This bill passed unanimously in the House last year, came over to the Senate, but we ran out of time with the shortened session. So in brief, the bill would prohibit law enforcement officers from engaging in sexual conduct with a victim, a witness, or a suspect in an investigation in which the officer is involved. Unfortunately, we do have stories, and I believe the panelists will speak to some of those today, that this has occurred in Maryland as in other states. The bill that was passed in 2018 provided protections for those in custody. This just expands those protections for anybody who interacts with law enforcement. I'll be brief, Mr. Chair. We did reach out to a number of stakeholders. The chiefs are not in opposition to this bill. I believe they provided a letter of information today. At the end of the day, we just want to help restore some public trust and faith in our law enforcement officials and make sure that anybody who interacts with them has protections from being harassed, assaulted, coerced into an undue sexual relationship. There is a piece of this bill that does exempt those who already have pre-existing relationships with anybody that a public official interacts with. So we do think it's pretty measured and balanced. And with that, Mr. Chair, I'm happy to take questions or turn it over to the panelists. Ask for a favorable report.
Thank you, Senator Elfreth, and thank you for bringing this bill to us. The format will be that we'll complete the entire senator's presentation and then the entire panel, then we'll do questions. So my apologies for the confusion with that earlier on, but so we'll move on to the panelists. And first up, we have Ms. Jordan. You are up next.
Thank you, Mr. Chair. Good morning, members of the Judicial Proceedings Committee. Thank you, Senator Elfreth and Senator Hettleman, for introducing this important legislation. I'm Lisa Jordan. I'm the director at the Maryland Coalition Against Sexual Assault, here to urge a favorable report on Senate Bill 43. As you know, the Maryland Coalition Against Sexual Assault is the coalition of all of the rape crisis centers across the state of Maryland. We're devoted to ending sexual violence in the state of Maryland and firmly believe that sex trafficking is sexual violence. We have a program called CAST, the Coordinated Action Against Sex Trafficking. We help develop services within the rape crisis centers and other programs to help address this. This bill, however, is not only about human trafficking cases, it's also about all people and their ability to trust law enforcement. Senator Elfreth ably described our current law, which is that you can't have sex with someone in your custody if you are a law enforcement officer. There's no sexual contact, vaginal intercourse, or sexual act. Senate Bill 43 is expanding that prohibition both to people who are involved in an investigation and also those who have requested assistance. I have to say that it's very troubling how many people reach out to our Sexual Assault Legal Institute, our rape crisis centers, saying that they requested assistance from an officer, perhaps broken down at the side of the road with a flat tire, that sort of thing. And they are finding that, unfortunately, those few officers who are not doing what they should be doing are asking for sexual favors. Maryland is not alone in this concern, and you've got examples in my testimony from Kansas and from Hawaii, and also from within our state. You've got a U.S. Department of Justice report on the Baltimore City Police Department detailing some of the activities of officers sexually exploiting sex workers. There are some technical things to note about this bill. As Senator Elfreth already explains, there's an exception for officers who have a prior legal relationship with the other person. So spouses, people with dating relationships. This does not, of course, apply to sextortion or to prostitution. And this provision was placed there after conversations with the chiefs. And we really appreciate that they simply submitted a letter of information. I'll say that we've also heard concerns about undercover sting operations and whether an exception is needed so officers can have sexual contact with victims of sex trafficking during investigations. And there are two things to say in response to that. First, we know from the committee's discussion yesterday that sexual contact is defined in statute. It's in 3301E1. Sexual contact requires the touching of an intimate area for sexual arousal or gratification, or for the abuse of the party. So touching that's necessary for an officer's safety, for the integrity of an investigation, that does not fall under the statute by its terms. But second, and really more importantly, there's really a new wave of law enforcement that are using a much more victim-centered policing approach, and they don't require any sexual contact. They don't require an officer to touch someone during the course of an investigation. And really, the act of sexual contact by a buyer or by an officer pretending to be a buyer is itself degrading and dehumanizing. We should help lead the nation and forbid this sort of sexual activity as part of trafficking stings. Finally, let me say that this bill is part of police reform. The Maryland Coalition Against Sexual Assault is deeply devoted to supporting efforts to reform the criminal justice system, to ending racism, and taking concrete steps to end racism in the criminal justice system. And we know from our work that Black and brown women receive some of the worst responses overall. We also know that 40% of confirmed sex trafficking survivors in the US are Black. This bill will help address that. It is a concrete step you can take to help end racism in the criminal justice system. And it is a concrete step that you can take to help restore trust for all of our people in Maryland so that they know when they ask an officer for help, if they're being investigated, they're not going to be hit on, they're not going to be touched, they're not going to be asked to have any sort of sexual interaction with that officer. For these reasons, the Maryland Coalition Against Sexual Assault strongly urges a favorable report on Senate Bill 43.
Thank you very much, Ms. Jordan. We will now move on to Ms. Siri. Michelle, you're up.
Thank you. Good morning, Mr. Chair, Mr. Vice Chair, members of the Judicial Proceedings Committee. My name is Michelle Siri. I'm the Executive Director of the Women's Law Center of Maryland. And as many of you know, we are a nonprofit statewide law firm, and we primarily represent survivors of domestic violence in immigration, family law, and protective order matters. We also advocate here in Annapolis on a whole host of issues that disproportionately affect women, and I'm here today in full support of SB 43. And I would like to also thank Senator Elfreth and Senator Hedelman for sponsoring this important piece of legislation. So as Lisa mentioned, we have grave concerns regarding the potentiality for law enforcement officers to abuse their authority in the absence of a law like this. Given the positional authority law enforcement officers hold over victims and witnesses and suspects, and the very real possibility of physical violence, retaliation, and abuse of authority, those individuals can easily find themselves in a position where they feel they have no choice but to consent to sexual conduct, which is of course not actual consent. And this is regardless of whether there is any sort of threats of violence or any kind of overt response or requests because of that position of authority. That in and of itself creates that inability to consent. I think it's there is, as Lisa mentioned, a very reasonable exception for law enforcement officers who are in a pre-existing legal sexual relationship with an individual, and the Women's Law Center supported that last year. What's important, though, is that that clause includes two caveats. One, as mentioned, was that sexual conduct can never be condoned if the person is in custody. But secondly, it also ensures that there is an exception, that exception does not apply if there's an active protective order in place. And this is really important because victims of what's known as officer-involved domestic violence are already more susceptible to coercion and to being harmed, frankly. People who are victims of domestic violence at the hands of police officer batterers, they're often in a very unique and particularly vulnerable situation. It's difficult for them to seek help. They often feel that their abusers have more knowledge and more understanding of the legal process, and so that they think that their allegations are not going to be taken seriously. And so for those reasons, we think that sadly this legislation is absolutely necessary to prevent and protect vulnerable individuals from abuse of power, and that victims of officer-involved domestic violence need even more protections. And for all those reasons, the Women's Law Center would urge a favorable report for SB 43. Thank you.
All right, thank you, Ms. Siri. We'll now move on to Ms. Rodriguez. Amanda, you're up next.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Amanda Rodriguez. I'm the Executive Director of Turnaround Incorporated. We are the Rape Crisis Center and a domestic violence service provider in Baltimore County and City. We are also one of the first comprehensive human trafficking service providers in the state. We serve thousands of individuals a year, variety of services. Approximately half of those community members are victims of sexual violence, and about 14% are victims of human trafficking. The trust of law enforcement by those we serve is exceptionally low, especially among human trafficking survivors. Trafficking survivors, in my experience, both as a state prosecutor and as a victim service provider, describe all too often situations in which they're propositioned by law enforcement to get out of charges, or in which law enforcement is part of their regular clientele, which made them feel as though reporting their trafficking to law enforcement was both dangerous and would be in vain. This is not a data point that we collect at Turnaround, so I can't give you the number of instances in which this occurs within our clients, but I can say that it is regularly discussed by human trafficking advocates and is often trained on as part of the training that we provide for other professionals. There's a particular video that most professionals that train on trafficking use that I would recommend watching. It's free, it's on YouTube, and it talks about this instance, this type of occurrence from the perspective of a survivor. It's called Making of a Girl by Rachel Lloyd, and it really is eye-opening so that you can understand from a victim's perspective what this can look like and what it does in terms of what Lisa Jordan previously said is in terms of being dehumanizing and degrading. This law would establish that we do not allow for survivors of trafficking, those that are raped and manipulated and sold day in and day out, or any other victim of crime would feel coerced by law enforcement into sexual activity, or it would allow for law enforcement to engage in sexual harassment. It would create an avenue of protection for those that are the most vulnerable in our community, which is our responsibility to them. Thank you for your time this morning, and Turnaround urges a favorable report for SB 43.
Thank you, Ms. Rodriguez. Next, we'll have Ms. Shapiro. Melanie, you're up next.
Good morning, Mr. Chairman, Mr. Vice Chair, members of the committee. I am Melanie Shapiro, the Public Policy Director with the Maryland Network Against Domestic Violence. MNADV is the state domestic violence coalition that brings together victim service providers, allied professionals, and concerned individuals for the common purpose of reducing intimate partner and family violence and its harmful effects on our citizens. And we urge a favorable report and support SB 43. Police officers who are often in uniform and armed with a gun with the power to arrest wield a tremendous amount of power and control. Police officers should be prohibited from sexual contact with victims, witnesses, and suspects because of this imbalance of power and control. There cannot be true consent. SB 43 contains the reasonable and limited exception if there was a prior existing legal sexual relationship and there is no protective order in effect at the time of the sexual contact in question. The number of incidences of police sexual misconduct are astounding. The 2015 investigation finding that every 5 days a police officer is accused of sexual misconduct. And this only accounts for what is actually reported to the police. Sexual misconduct is said to be the second most common form of police misconduct reported, with excessive force being first. So as Ms. Jordan previously stated, this bill is part of larger police reform, in part because police target people that they think will not be believed if they report the sexual assault, including women of color, teenagers, victims of sex trafficking, people impaired by drugs and alcohol, and survivors of domestic violence. In an investigative report, an officer is quoted as saying, "I would see women that were vulnerable where I could appear as a knight in shining armor." He explained, "I'm going to help this woman who's being abused by her boyfriend, and then I'll ask her for sexual favors." One of the barriers is to whom should the victim of a police officer's sexual misconduct report that sexual misconduct but the police themselves. We need to do more. Domestic violence is already one of the most underreported crimes. In order to begin to end the violence and trauma suffered by survivors of domestic violence, they must feel trust and confidence in the police when calling for help. We also need to prevent any further victimization by the police themselves. SB 43 is an important step in that process, and we urge a favorable report.
All right, thank you, Ms. Shapiro. Looking around the room for questions from committee members. So, Senator Jackson, you are up.
Thank you, Mr. Chairman, and thank you to the panel. Thank you to the senators who sponsored this bill. I enthusiastically supported this bill in the House, with the exception that it's included in the bill this year. Look, having served in this line of work and as well as being responsible for the folks who are out there serving the community, unfortunately, it's a very unfortunate day that we have to implement something like this, but I respect the courage of it being brought forth, and all stakeholders should be enthusiastically supportive of this bill going forward. So just wanted to comment on that, and I think this is a step in the right direction of us reimagining our service. So thank you, sir.
Thank you, Senator Jackson. We'll now move on to Senator Castley.
Thank you, Mr. Chairman. I just sort of technical questions here, maybe sort of to anybody, because they're on the technical side. Not only opposition to the bill and the intent of the bill, but on page 2, line 32, it says a victim. This applies in the case of a victim, witness, or suspect in investigation during the course of an investigation that the law officer is conducting, supervising, or assisting with. I'm just going to be proposing an amendment that says that that the officer, these should be people that the officer knows or reasonably should know. I mean, the cop's not going to. There may be witnesses and victims that he doesn't even know about yet, or she doesn't know about yet. So I think we need to have a knows or reasonably should know that this person is a witness or a suspect in an investigation. The other question I have is on page 3 and line 9, talks about a prior existing legal sexual relationship. I don't know what a legal sexual, I know what illegal, I guess, certainly rape would be an illegal sexual relationship perhaps, but I don't know if this, so you say legal sexual relationships if someone is having an affair with somebody else who's married, is that a legal sexual relationship? I don't know. And I'm not sure what the legal adds into it. Clearly, if the officer's engaging in raping the person or some illegal conduct towards them, that's a whole nother matter. You've already got, there's another crime there, so this one becomes sort of superfluous because you're going to charge them with the illegal sexual relationship. But I'm just feeling that maybe the word legal, I don't understand what that's supposed to mean in this context. So those are my 2 questions that maybe anybody could address them.
Thank you, Senator Castley. I can take a shot at those. I certainly have no objection to the idea that an officer has to know or should have known that someone is a witness or a suspect or a victim in a case, as long as the or should have known is there. I think that that's sufficiently protective.
Okay,
I take your point.
That amendment in the voting session. Thank you.
I take your point regarding the issue on line 9. The history behind that is that originally it was suggested, really, as you say, just a prior existing sexual relationship. And there was deep concern, particularly in the context of sex trafficking, that prior interactions between an officer and a prostitute or a sex worker who there had not been an exchange of money, but that this would somehow accept the officer from that from the law. So there was deep concern about that. I think the underlying spirit of this is that if someone has a dating relationship that's free of coercion, if someone has a marital relationship that's free of coercion, people who are living together, those sorts of things. Certainly there are other ways that this could be phrased, and I would just off the top of my head suggest perhaps a prior existing sexual relationship with the person that is free of coercion or something along those lines.
Or even one that doesn't violate, that's not contrary to the criminal law article. Then we leave out the whole civil side about, well, is an affair illegal? Legal, what does legal mean? I'm not sure. Different things in the criminal and the civil side of stuff, but perhaps just reference it to that a relationship that would not be violative of the criminal law article. Then that brings in all those.
I mean, certainly you're completely correct that we were not after extramarital affairs. This was not the concern. I think the concern, though, is perhaps a bit broader than the criminal code, and so would respectfully suggest the use of coercion or a similar phrase, just to make sure that we are addressing a situation where there was some sort of sexual interaction, perhaps a free gift of oral sex to an officer in recognition of his status, that should not exempt the officer from this statute.
Okay, thank you. No more questions.
Okay, Senator, can we send you some? I understand your concern, and I'm going to work with Lisa to send you some language.
Yeah, sure. No, I'd be happy to work with you all. Just get something and we'll roll with that. Thank you.
No, I appreciate the background, Ms. Jordan, because I think we would have veered on to the consensual. Without that background, we wouldn't have been able to tease that out. I think so. These are kind of parenthetical amendments. They're quick amendments. If you have the opportunity between now and this afternoon to send us some language, but I will have the council now start working on just some quick amendments because it's not something we have to send down to the amendment office. It's very easy to do because they're in line. But if you have language that you could send us over. You realize that this bill is on the voting list for this afternoon, so
we'll get it to you in the next hour.
Appreciate it. Thank you very much. Okay. Looking around the room, any other hands raised? Senator West has a question.
There, I think I'm unmuted. So what? I would assume that it's not totally uncommon for a policeman to, in the course of his or her job, come into contact with people who he or she finds attractive, and at some point starts a dating relationship with them, which might at some point go further than just dating. Would this preclude a law enforcement officer from inviting anyone who he or she met in the course of an investigation from ever inviting that person out on a date to see what might happen in terms of the relationship progressing?
Definitely not, Senator. We are the Coalition Against Sexual Assault, not the Coalition Against Sex. And so they would not be able to have sexual activity with that person they're attracted to while they are on duty. So that would be prohibited. They would not be able to have sex with the person they were attracted to if the person was in their custody, had asked for their assistance while on duty, or was under investigation. But off hours, a voluntary relationship, no need to restrict that.
Okay, I'm glad that you made that point. Thank you.
All right. Seeing no further questions, that concludes the hearing for Senate Bill 43. Thank you, Senator Elfreth, and for the panel.
Thank you, Thank you, committee.
Where am I here? Okay, next we will move on to Senator West, Senate Bill 237. Senator West, you're already unmuted, so floor is yours.
Thank you very much, Mr. Chairman, and it's great to be able to present this bill. This is Senate Bill 237. Which is an omnibus bill and proposes a number of reforms to the practice of policing in Maryland. Last September, the members of this committee spent 3 afternoons hearing testimony on a suite of draft bills purporting to reform policing in Maryland. I fully understood the intent behind these bills and indeed supported many of the provisions in the bills. But at times I felt that the bills went so far as to run the risk of being seriously counterproductive. Legislation that will induce seasoned law enforcement officers to take early retirement, will lead law enforcement officers in the middle of their careers to leave public service for jobs in the private sector, and will discourage young people from seeking careers in the field of public safety in the first place, would inevitably, albeit unintentionally, diminish the expertise and professionalism of our law enforcement agencies. In this regard, I just saw an article in the Chicago Sun-Times this past weekend, which reported that in 2020, last year, 560 Chicago police officers retired. It's 15% higher retirement rate than normal. In New York City, 2,500 cops retired. That's double the number that retired a year earlier. In Minneapolis, 20% of the police department retired or took leaves of absence. What we don't want to do with legislation would be to cause good, seasoned, professional law enforcement officers to leave public service and reduce the effectiveness of the police force. So at just about that time, Baltimore County Councilman Julian Jones introduced a bill in the Baltimore County Council to reform enforcement in Baltimore County. This bill became the subject of a lot of work behind the scenes, and ultimately a compromise bill was passed on October 5th by the Baltimore County Council. The bill had bipartisan support, with 2 of the 3 Republican councilmen and all 4 Democratic councilmen voting for it. The bill was then signed into law by County Executive Johnny Olszewski. On the day the bill passed, Councilman Jones posted a message thanking all the supporters of the bill for their fine work on the bill. It included Jews United for Justice, 1199 SEIU, the Baltimore County NAACP, U.S. Senators Chris Van Hollen and Ben Cardin, Congressman Kwesi Mfume, Speaker of the House Adrian Jones, State Senators Shelley Heddleman, Clarence Lamb, and Charles Sidner, and many others. Intrigued by this bipartisan success, I obtained a copy of the bill and read it. It was an omnibus bill that covered the same ground as some of the bills that we considered in September. I found Councilman Jones's bill to be balanced and reasonable, and so I cannibalized it. And I asked DLS to draft this bill, which takes the reforms enacted in Baltimore County and extends them statewide. Let me summarize the provisions of the bill. First, the bill provides that all future no-knock search warrants must be pre-approved by the applicant's superior as well as by the county state's attorney. Second, the bill provides for annual training regarding interacting with individuals with physical, intellectual, developmental, and psychiatric disabilities. Third, the bill requires annual training regarding anti-discrimination, implicit bias, and use of force de-escalation training. Fourth, the bill states that each law enforcement agency shall establish an early intervention system to identify police officers who are at risk of engaging in excessive force and to provide those officers with training, behavioral interventions, reassignments, and other appropriate responses to reduce the risk of excessive force. Fifth, the bill requires the chief of each Maryland law enforcement agency to adopt certain rules to be followed by all of the agency's law enforcement officers. These rules must include a requirement that each office shall demonstrate the highest regard for the sanctity of human life and the dignity and value of all persons. Also, a rule that an officer may only use objective, reasonable, necessary, and proportional force to accomplish the officer's lawful duties. Also, a requirement that an officer shall, when safe and reasonably possible, use de-escalation techniques to proactively stabilize the situation so that more time, options, and resources can be made available to gain voluntary compliance and reduce or eliminate the need to use force. Sixth, the bill requires officers to intervene to prevent or terminate the use of excessive force by another officer. Seventh, the bill contains an anti-retaliation provision so that an officer may not retaliate against another officer who reports an intervention to prevent or terminate the use of excessive force. Eighth, the bill states that an officer must report any use of physical force or a proactive instrument or a dog. Must report if any person in custody is injured or even complains of pain, and must report if a firearm is discharged other than in training. Ninth, the bill provides that an officer may not use a neck hold or other restraint intended to restrict blood or airflow, except in defense against death or serious bodily injury. The bill contains two additional provisions which were not in the Baltimore County bill. First, the bill turns over control of the Baltimore City Police Department to the City of Baltimore. I note in the fiscal note the fiscal note indicates that the control of the City Police Department was turned over to the state of Maryland in 1860. Since then, nearly all the testimony we heard last September about bad acts committed by law enforcement officers reported on conduct that occurred in Baltimore City. Clearly, the control of Baltimore City Police Department by the state of Maryland hasn't worked very well. All of the other counties, police departments in all of the other counties and municipalities are controlled by those counties and municipalities. Only Baltimore City sticks out as being controlled by the state of Maryland. It seems to me we should give Baltimore City, the mayor and city council of Baltimore City, the right and responsibility to control its own police department. And then finally, the bill provides that on or before October 1st, 2023, each law enforcement agency in Maryland that employs over 20 law enforcement officers shall require the use of body-worn cameras. The cost of the initial equipment for a body-worn camera program shall be equally split between the state and the county or municipality served by the law enforcement agency implementing the program. But from that point on, the ongoing operating costs of the body camera program will be borne solely by the county or municipality. In this regard, I'd make 2 points. Number one, Kevin Kamenetz, who the former and now deceased county executive of Baltimore County, who was well known for his penny pinching attitude. He bellied up to the bar, and let's give him full credit. He decided to implement a body camera program in Baltimore County, and the county taxpayers paid for it. We have had that program for the last several years, and it has worked magnificently. I hope when Scott Schellenberger talks in a few minutes, he will talk about the effectiveness of the Baltimore County program. Secondly, interestingly, earlier this week, I saw an editorial, January 17th, in the Washington Post. The title of the editorial is "The Assault on the Capitol Underscores Why Federal Law Enforcement Should Use Body Cameras." And the point the editorial makes is, if we'd only had body cameras on all the federal law enforcement officers involved in that January 6th insurrection, we would know a lot more information about, number one, how they acted under the circumstances, and B, who was involved on the other side. And the job of law enforcement reining those people up would be far easier. So, taken as a whole, I believe this bill is fair and reasonable and balanced. For these reasons, I ask the committee to vote favorably on Senate Bill 237, and I'm pleased to introduce my 3 witnesses: Baltimore County State's Attorney Scott Schellenberger, the Baltimore County Fraternal Order of Police Lodge Number 4 President David Rose, and Sheriff Darren Popkin of Montgomery County.
Thank you, Senator West, and thank you for your work here. This is great, and I suspect we'll further cannibalize this bill because there are a lot of very, very good provisions here, and just taking a deeper look, I know that we'll probably have some interesting and robust conversations over use of force, the no-knock warrants, and I know that the Baltimore City delegation is working on the BPD solution, which we will certainly entertain what their suggestions are, as they are the duly elected representatives of the city, but I think that they're close to a resolution there. So thank you just very much for this, and I think what this teases out is that, at the end of our work in the interim, there's a lot more commonality in, where we think we are than we realized beforehand. So I really appreciate your work here, and we'll certainly, I'm sure, take a number of these suggestions as we move forward in the weeks to come. So with that, thank you, Senator West. We'll move on. I'm just going to go in order that was suggested here. So we've got the first witness is Mr. Schellenberger. You are up next.
Mr. Chairman, Mr. Vice Chair, members of the committee, thank you so much. Senator West did a great job explaining the history of how we got here. Senate Bill 237, which I support, took Baltimore County's statute that we adopted last year in 2020 that we all worked on together. The chief, the FOP, Johnny O and I, all of us worked on together and got us into a good place on balancing police reform. So let me hit a couple of the highlights. Number one, let's start with body cameras, because I think that's really important. Senator West is correct. Kevin Kamenetz came to me several years ago, and you have all heard me tell his story, where he said, we're going to have body cameras. And I said, no way. I was dead set against them. And I will say one more time, it was the biggest mistake I ever made, because body cameras are the best thing we ever did in Baltimore County, and it needs to happen throughout the state. And the reason it's good is because the video saves a lot of the problems that we have. Our internal affairs complaints that first year of full body cameras dropped in half, because now when people make complaints, either to my office or to internal affairs, the first thing everybody does is say, let's roll the tape. And there is no dispute about what you're seeing on that video. It is a very important facet of police reform, believe it or not, because it captures exactly what happened. Now, please remember, it is incredibly expensive. I am paying $738,000 a year for my employees, or the county's paying for my employees who prepare the videos for court. Last year, we paid $1,476,000 in storage costs. So that part about Senator West coming with money is very important. Startup costs, and then taking into account that there are large costs with it, but it's still the best money we ever spent. The second important thing is no-knock warrants. I know there's a move afoot to get rid of no-knock warrants. No-knock warrants are very important for officer safety and also preservation of evidence. And don't think just in terms of drugs. Think in terms of a murder case where there's clothing that has DNA on it. If we're standing there at the door knocking, that DNA can be thrown into a fireplace and destroyed, and we will lose vital evidence. We agree with this bill that says, okay, let's put in statute that a supervisor has to oversee it. Let's put in that the state's attorney's office has to sign off on it. It's already law that you have to show the probable cause to the judge for why it should be no knock. So now you have three protections that are in the bill on why a no knock is desperately needed for officer safety or preservation of evidence. That is very important. It doesn't completely ban no knocks. It saves a lot. Dave Rose from my FOP will talk about some of the other items. This is a great balance between moving forward with police reform, and it's all in one bill, and it's already working in the third largest county in the state. I'm more than happy to work with all of you on these provisions. Please take a look at my written testimony. I address all issues, and I look forward to all your questions. Please pass Senate Bill 237. Thank you.
Thank you, Mr. Schellenberger. Next, we'll move on to Mr. Rose.
Thanks, Mr. Chairman. Both of them did a great job. I'll try not to cover too much of the same material, but the FOP in Maryland is in support of Bill 237 as written. As Scott mentioned, it's similar to the Smart Policing Act that we passed here in Baltimore County, and did have the input of all the parties, which both of them indicated earlier. It does address the training and policy requirements that the senator spoke about earlier, and it avoids the unnecessary or inappropriate addressing or assigning of a crime to a policy violation. Already there are bills out there right now that actually assign criminal penalties to reporting of the use of force or the failure for the duty to intervene. And those are policies that we're actually assigning crimes to. And these are instances that get reviewed by the state's attorney's office. So if the state's attorney's office decides they rise to a level of criminality, they can institute charges anyway. So we decided in Baltimore County to leave that authority up to the state's attorney's office and not assign crimes to penalties. If we start assigning crimes to penalties, where does it end? if you're late for work 3 times, are we going to, assign a crime to it? We avoided that altogether. We also like the provisions that mandates the assigning of body cameras to officers and other departments over, I think it was 20 members. I know the members of the Baltimore County Police Department, like Scott was talking about earlier, were very apprehensive about going to body cameras several years ago. And although that the use of a body camera requires a lot more extra work than a normal daily work routine with categorizing and labeling videos, our officers would not give up body cameras to this day without a fight. These body cameras protect our officers way more, overwhelmingly more than they do catch an officer doing something wrong. Our officers are now found to be exonerated or unfounded in the overwhelmingly majority of instances and complaints than they used to have that were actually not proven or disproven and ended up being not sustained. So the requirement of body cameras, I think, would be very helpful for everyone involved. And Scott has already explained the, I guess, the assistance that it's given him in the opportunities to fulfill his duties in his office and the use of evidence that the body cameras can provide. So the Maryland State FOP and the Baltimore County FOP would urge for a favorable report on this bill.
Thank you very much, Ms. Rose. And we will now move on to Sheriff Popkin. How are you?
Good, real good. Chairman Smith, Vice Chair Waldstreicher, Senator Lee, members of the committee, it's always great to see you. For the record, my name is Darren Popkin. I am the Sheriff of Montgomery County, and I co-chair the Legislative Committee for the Maryland Chiefs and the Maryland Sheriffs. I want to thank Senator West for his thoughtfulness on submitting Senate Bill 237 as the Chiefs and Sheriffs support this bill with amendments. As you are aware, the Chiefs and Sheriffs have been advising the leadership of both the Senate and the House throughout the summer and fall at hearings on police reform measures that we believe that we have way more in common than we have differences. Although Senate Bill 237 may look somewhat different if amended, we believe that Senator West's framework in Senate Bill 237 will provide the appropriate pathway moving forward in the area of police reform. The Chiefs and Sheriffs have submitted written testimony and appreciate Senator West's efforts to enhance law enforcement transparency, accountability, and community trust. Within the bill, the most critical areas we are in agreement with, but have several technical amendments. For example, under the body-worn camera section, we agree that all law enforcement agencies must initiate a body-worn camera program that should be consistent with the Maryland Police Training and Standards Commission guidelines. But it also would need to have some exceptions for undercover officers. Also, we would suggest that making the effective date of the law enforcement body-worn camera program in Senator West's bill be consistent with the other work groups of the General Assembly. Additionally, under the no-knock search warrant provision, to approve the request, we will believe that supervisory personnel of the law enforcement agency should be of a higher level of authority, and that the state's attorney in each jurisdiction must have a designee in the event that the state's attorney himself is not available. Under the use of force items, the Chiefs and Sheriffs are looking to be consistent with a statewide use of force policy that is promulgated by the Standards Commission with the requirement for all law enforcement agencies to adopt. To conclude, for these reasons and others that are mentioned in the submitted position paper, the Maryland Chiefs and Sheriffs request a favorable report with certain technical amendments. Thank you very much.
Thank you, Sheriff. Always good to see you. And next we'll move on to Mr. Greenberg. How are you?
Chairman, good to see you. Vice Chairman and the rest of the senators. My name is Lawrence Greenberg on behalf of the Maryland Association for Justice, Civil Rights, and Constitutional Law section. We are here to testify favorably to Senate Bill 237. I heard Senator West talk about this omnibus law enforcement reform bill, and I will tell you that specifically with regard to Baltimore City, as a practicing attorney in the city as well as a taxpayer, I welcome the changes that Senator West proposes. You'll recall that the U.S. Department of Justice conducted a detailed investigation into the Baltimore City Police Department in 2016, and it detailed a pattern of routinely violating constitutional rights of citizens, using excessive force, and discriminated against citizens, primarily African Americans. Baltimore City Police Department for years has escaped being held accountable for its misconduct by hiding behind the fact that right now, Baltimore City Police Department is established as an agency and instrumentality of the state. This bill would fix it, and it would return it to local control and to the citizens of Baltimore, and therefore we're requesting a favorable report. Thank you.
All right, fantastic. Thank you, Mr. Greenberg. So with that rounds out the panelists and the testimony. We'll now turn to the committee members for questions. Looking around, Senator Castley has a question.
Am I there? The questions, I guess, for Senator West, really. Just a series of them. I'll turn this up so I can hear you.
I may ask Scott Schellenberger to help me out here.
Phone a friend.
Just kind of going through in order. Look, I'm looking at the bill, so if you want to follow, I'm going to take it as they come in the bill, not as you discuss them.
Yeah.
So on the no-knock warrants, what are there statistics available that say the numbers of these that are issued and the problems that have been encountered? Do we have any data for that?
I don't have any data on the no-knocks.
I mean, I've heard the anecdotal on the national news and the world news, but I'm just looking for, Maryland specific, not necessarily Baltimore County, because this is a statewide bill.
Yeah, well, we also, of course, we all see the horror story that came out of Kentucky.
Senator Castley, I have acquired some. I mean, I know Mr. Schellenberger has some Baltimore County specific information, and because we talked about it like a week ago, but I do have a spreadsheet, some information, Maryland specific data, all 24 jurisdictions from a couple of years ago. So I can, maybe it's 2 years old now, but I can definitely share that with the members of the committee.
Is it just the numbers that are issued, or is it also problems encountered, or both?
I don't think it's as granular as problems encountered, but I think if someone was killed, injured, that type of thing, how many are issued.
As a result of the execution,
Correct.
you mean of the warrant. So
Yes.
numbers of warrants and the number of people that were killed or injured in the execution of the warrants.
Yeah.
Okay. That would be helpful. I mean, we do laws. It's nice to do laws that aren't in response to national news, but actually respond to how the law in Maryland's going through. So that's why I have concerns on that.
To record data, we had a reporting requirement that I think, is that right? Maybe Mr. Schellenberger could shed some light. We did have a statewide reporting requirement that I think sunsetted a couple of years ago. So like the last report was like 2 years, maybe Senator Jackson can shed some light, but I think that the report stopped like 2 years ago.
Okay.
Yeah, yes, Mr. Chairman, there was a reporting on all SWAT team search warrants, and then there was a reporting period, and I think it got extended. I think it sunset, and then it got extended, but I do believe it's sunset. And it included injuries or deaths that occurred.
And the underlying reason for the issue.
Absolutely, and the issuance of it, absolutely.
Yeah, most of them were.
And certainly that seems like a logical addition, Mr. Chair, to this bill, particularly since we will be discussing no-knocks. And that way, moving forward, we could continue to capture data and tweak the law if we need to. I can tell you in Baltimore County, I'll get you the exact numbers, Senator Castley, but of the hundreds and hundreds of search warrants that we did my last data was 2019, we had about 189 no-knocks. And again, in our protocol, it does require a higher level supervisor to approve everything. And I certainly agree with Chief Popkins' concept that can be added, and you all can pick the level at which, with Chief Popkins' input, the level at which that commander needs to be, lieutenant, captain, major, whatever it needs to be. Certainly, that's something we can work on.
Well, and a question back to Mr. Schellenberger, is it necessary to bring the state's attorney on that? If we've got Officer Jones and Officer Smith, they have to apply for it and get the judge, and now we have to have Captain so-and-so signs onto it. Then we got to take it over to Mr. Schellenberger's office and find somebody over there that's going to sign off on it. Is that final step really necessary? Do we need to get the state's attorney involved?
Well, the reason we added that was because I didn't want to ban no-knocks. And I thought one more set of eyes would be important, particularly if that set of eyes comes from an office that is elected by each jurisdiction. I can tell you the idea came also because it is the policy in a number of our counties already that a number of the smaller jurisdictions, the state's attorneys have said to the police department, hey, if you're going to do a no-knock, I want to see it. And so that's why we added that. I certainly agree that it can be an assistant who's designated every week of the year, 24 hours a day. We have a prosecutor who's on call, and they are called a duty prosecutor, and every office does it. And that week, that prosecutor has to be available 24/7. And that's done in almost every jurisdiction. So this would not slow anything down. And I don't think it's a bad provision to put in there. And I certainly think one more set of eyes will, I believe, keep a lot of folks happy about keeping no knocks for certain cases.
My next question is on page 4, line 7. We talk about requiring training at least annually. And one of the areas is implicit bias. And I'm just curious how we're going to define implicit. Is it defined in the statute? What do we mean by implicit bias? What specificity do you have for this? And why are we requiring training on it?
There actually are many trainings that go on right now that deal with the concept of implicit bias. In fact, there are a couple of websites that I was looking at recently that you can actually just go on and watch on your own. In our police academy, they already do some training on implicit bias. And the reason that we put this part in was that it needs to be made a part of in-service training. So many of our officers may not have been to the academy for 10, 15 plus years. And so we added this so that annually there will be implicit bias training. And that term is a well-accepted term in this area.
Well, it's not defined anywhere in statute, is it? I mean, honestly, when I look at it as a legislator, we work as 47 senators, and a lot of us have implicit biases against people on different parts of the General Assembly, but we all work pretty well together, and we overcome those biases. We don't express them. We try, we hold them. And I assume that by an implicit bias, you're something that you don't express, that you don't speak about, that it's implicit, and that's the problem here is what are we requiring training on? You're saying it's well established in this area. I mean, what's it means in Baltimore County may not mean the same thing in another part of the state or other people. So how do we move forward with a mandating training on something that I'm not sure we even know what it is?
Well, maybe the chief and Mr. Rose can help me with this, but implicit bias training is more to educate the person that they may have internal biases that they're not aware of. And it's to educate people so that they recognize that they have to deal with that. And I think Dave Rose may have a couple things he can add.
That pretty much just nailed it right there at the end. It's a training to help a person recognize that while we may not get to the term of where somebody's racist or prejudiced, but everybody has their own biases towards something or someone that they may not be aware that they are they're doing or saying. There are different cultures in the country and in the area that we have a Russian segment of the county, we have a Hispanic segment of the county, and each one of those cultures act in different ways and react differently to seemingly, minor or inconsequential to you might be something to another culture. So, for example, one culture, it might be inappropriate to speak to the woman in the house without first introducing yourself to the male of the house. Some cultures find that disrespectful, and it just educates you on the differences of different cultures and how to navigate through them. And
but that's standard cultural sensitivity training. I mean, if you're policing in an area that's got Thais or Muslims or something, then clearly you're going to need to have some additional, or Hispanics, and you're not of those communities. Clearly, you need to be trained. That's I'm not. It's not necessarily your bias. It's that you don't know their culture. It's not that you're biased against them, that you harbor any dislike or ill will towards them, but certainly you do need to have cultural sensitivity training so you understand what they mean when they do things. But this is a whole nother, doesn't say cultural sensitivity training. It talks about that people are going to be educated on implicit biases. I'm just trying to understand what that means, because I've heard so many different explanations of what it means. And Mr. Schellenberg is saying that it's a bias that you harbor without knowing it. But as long as you don't act upon it, I don't really care what's in your brain. It's your expression of biases that really are problematic when you act upon them. Well, maybe somebody can send me something to explain what.
Senator Castley, this may help just slightly in your question. Right now, there are a number of professional organizations that offer implicit bias training, and Scott, kind of hit that definition somewhat of what these trainings are involving, but there's no standardized, validated training yet that the Maryland Standards Commission has offered. And what Senator West's bill would do is require this training, not only an in-service training, but also an entry-level training. So the training on implicit bias, once it's a validated tool and a validated training, and it's agreed on by the Standards Commission, it will be consistent training across all law enforcement agencies, and not just haphazard of sending people to different trainings from different professional organizations. So this would actually benefit consistency across all agencies once there's a validated program that the Standards Commission can actually decide on.
Thanks. Move on to page 5, line 12. It talks about.
Senator Castley, can I just throw one more thing in here? I got an email, and I knew I had seen it yesterday. I got an email from the Baltimore County Bar Association hooking me up for a webinar dealing with implicit bias. So this is an area where so many people are working now, and all we're saying in this bill is let's make sure police officers are educated also.
Senator,
and I will stop there.
There you go. I dropped you some information in the chat, direct chat from the University of Maryland. Some academic research that Rashawn Ray and others have published extensively on this, and they've worked with Prince George's Police Department and maybe Montgomery County. I'm not sure, but the Montgomery County as well. But I appreciate the uniformity. The piece that's going to be critical. So anyway, sorry.
On page 5 in line 12. We talk about the ongoing operating costs solely by the county and municipality. So my concern there is that they're not going to set the standards, and operating costs, as we've seen in the past when we talk about public information requests, these could be substantial operating costs that we're not talking 10 grand, 20 grand here. This stuff can be totally overwhelming. And if the state is basically, we can legislate ridiculous standards that are totally divorced from economic reality, that would be a bad thing. I just question why we would want to have the counties and municipalities picking up the entire thing, because the cost of warehousing and just how you operate and removing offending videotapes. I remember seeing some of the numbers for state's attorney's offices asking for increased people, police departments asking for increased people, simply to process and the operational cost of this. So, while we talk about the initial equipment cost, I think we're going to find in the long run that's we share that with the state, but that's not a really good deal for the counties. I think you're going to find that the cameras are probably the cheaper end of this, and it's these operating and maintenance and storage costs that are going to be the huge elephant in the room here.
So, Senator Castley, you are correct, and it's certainly something that I think we need to discuss. When we rolled out the cameras, we had 1,400 in Baltimore County, which is going to be one of the larger, next to, say, Baltimore City, Montgomery, and Prince George's. our one-time equipment cost for just my office was about $140,000. But I did have to hire 15 paralegals who shield and protect and get these videos ready for court and for discovery. That yearly cost is $739,000. And then storage of the videos right now is costing the county about $1,400,000 and some thousand. So you are correct. It is extremely expensive, but everybody in this county believes it's worth every penny. And in the long run, if your internal affairs complaints are going down, if you're not getting sued as many times in a civil court and paying judgments because you actually have captured what happened, I don't know if you recover all of those costs. I can't say that. But I do think that it does help a lot and strike a balance.
Scott, don't get me wrong, I'm not against the cameras. My problem is that the people, us in the General Assembly, who will be setting the standards, will have no responsibility for the cost. So if we have to bear some of the cost, I think that tends to make us a little more judicious in our standards and our requirements. And we've seen this in the past in the PIA requirements. That
I understand.
And I think just taking all responsibility from the General Assembly would just make us, we'd have no reason not to ask for the Cadillac of everything. You know, let's go for the top level of everything here. Money's no object because we're not paying for it. You know, our taxpayers are, but we're not. So that's my concern with that one. My next concern, this talks about a system to identify police officers who are at risk of engaging in excessive use of force. Maybe one of the experts there, does that system exist?
Which you're referring to?
I'm looking on page 5, line 16 through 22, especially line 18 says, we're identifying it's a system to identify police officers who are at risk of engaging in the use of excessive force. And does anyone in the panel know of such a system?
Yeah, we've had that here in Baltimore County, probably going back to 1990. Mm-hmm. So it gets modified from time to time. So the system is set up to where if an officer gets a certain amount of complaints within a time period, say 90 days, 6 months, or even a year, or maybe it's a quicker time period. So you make 3 disorderly conducts and get 1 use of force complaint in a 90-day period. That would flag it into the system for a person of a higher rank, captain or above, to take a look at it. And those are put into the system and sent down for the commanders to be notified. And initially, if the officer is identified, and we'll use the term we use here in our department, flagged for an early warning system, you'll get brought in with your commander or your lieutenant to have a conversation and look at the instances as a whole to see if it was a coincidental thing, if it was something that needs to be watched, or whether additional training would be needed. And just because you get put into this early warning system doesn't mean you stay in it forever. You might be, looked at or observed closer for another 6 months while you're in it.
I don't want to cut you short, but just in the interest of time, then perhaps this is a Baltimore County program. Perhaps this entry ought to be under the requirement for the Maryland Police Training Standards Commission to establish a program rather than each individual department. I mean, that sounds like an interesting program, but different things would mean different things to different people. My next point on the bill is again on page 5 in section 3.523. It has some very interesting language that well, first of all, it says the chiefs have to establish. It says in the law, it would say the chief has to establish the following rules. I guess this is a technical matter. If it's in the law, it's not a rule, it's a law. So I'm not sure how that just seems kind of counterintuitive there to me, that we're saying you're going to have to put out a law that says the following 6 things. I think what you're really saying is chief has to post the following law on this bulletin board or something, because these aren't rules, they're laws.
Well, Senator, I can help you with that. What we did in Baltimore County was they passed a law and said, Chief, put these in your guidelines, in the book that every officer has to follow. And the key to that is if they don't follow it, then you could be brought in for disciplinary action. So that was the intent behind all that.
I don't have any problem with that. It's just that it's not a rule, it's a law. You see, the police, we're directing the chief to put in certain rules. Our authority is to say, chief, here's the law. And he can put it out as a rule or an ordinance or whatever. So that's more of a technical side. Beyond that, in line 30, it says each law enforcement officer shall have the highest regard for the sanctity of life. Does that mean that a police officer who supports supports partial birth abortion would have to be removed from the force? Some people would say that's a gross violation, disrespect for the sanctity of life. Or does it mean that if a police officer supports, as some certain governors in this country do, that if a child survives an abortion attempt, it's okay to leave them on the operating table to die? Is that what we mean by sanctity of life, or is that defined someplace else in the bill? Would it, for example, in Baltimore City right now, we have a prosecutor who pursues policies that when she came into office, we had a murder rate of 200 a year. Now we have 350 for every year since she's been in there. Would those policies, do those display a lack of respect for the sanctity of life? I'm just trying to, we put words in these laws and they have meaning, and I just like to understand what this one means.
If you have a problem with the word sanctity, I'm sure we could come up with an.
Oh, I love it. I'm just not sure that I understand what other people mean by it.
Well,
That's all.
We could say importance of human life. I don't think
It just means we would respect all of the citizenry we come in contact with. So it's just not victims of crime and citizens, but you also have to have the highest regard and sanctity of life for lack of a better term, a suspect or a bad guy. You can't just treat people differently because of the roles they allegedly may play in life. You play in life.
I think treating people differently versus the sanctity, that's a big difference than this respecting the sanctity of life. But it's just...
and respectfully, Senator, we did put this into effect coming up on a year now. And honestly, none of these things have occurred to anyone else. So I understand that statewide, we wanna, make sure it's perfect, but this is about law enforcement and the sanctity of life when they're on duty or when they put themselves on duty. But we're certainly happy to work with all of you about making the language better.
Okay. I'm curious on the provision in the beginning of the bill about Baltimore City. I mean, I'm hoping we're recognizing that that's going to probably dramatically increase the cost of Baltimore City on the legal side, because they'll no longer have the state immunities, right? They're going to be in the same realm as Baltimore County and all the other counties. And the only reason that anybody's ever postured that I know of to keep this under, I mean, de facto, they are under city control. De facto, the state exercises zero control over Baltimore City police. And the only control element is that, unlike the rest of the jurisdictions, Baltimore City can claim the state level immunity and not the same immunity that all the counties, the much lesser immunity the counties have. So removing them, the only thing you accomplish by that is increase their liability for any sort of the cities, the taxpayers in Baltimore City, their personal liability. It will no longer be a liability on the state. It will be a liability on the city. So I guess as a state taxpayer and someone who's not going to be paying for these judgments, I don't think I have any opposition to that, but I hope that people realize that's really all we're talking about here. Because it's a practical matter, there is no other control. I'm just looking at the last piece here about the chief adopting rules, and the rule would be that law enforcement officer may use only objective, reasonable, necessary force, etc. I mean, why would we put that in a rule by each department? Because what you're going to do then is each department is going to be different. If we're going to have statewide standards on police conduct and misconduct and use of force, it seems to me it'll just be in a state law that says here is a standard. Of course, we have to be careful because who's going to, we're taking objectively reasonable force. I don't know, Mr. Schellenberg, is that the current standard in the law on the police on the allegations of police brutality? Is it, are we changing the standard when we say law enforcement officer may use only objectively reasonable force? And if so, that's determined by who? Normally, when we talk about objectively reasonable force, we talk about what the jury finds. But typically, in a police brutality case, we don't. It's not objectively reasonable force. We have experts come in to determine whether or not the force that the officer used under those circumstances was a reasonable degree of force, and if it wasn't, then the municipality or whatever has to pay a large judgment.
So to answer your first question, is this the standard in the law now? The answer is yes, that is the standard in the law. That's what the state of Maryland works off of. If an officer uses force, and the people who get to decide are 1, internal affairs, 2, a trial board, 3, potentially the state's attorney, 4, a civil jury. That's what a civil jury would be told in a jury trial. Ladies and gentlemen of the jury, the question in this case is, did the law enforcement officer use objective, reasonable, necessary, and proportional force under the circumstances? So that's what the law is now in the state of Maryland. But what we're saying is we need to put it in the book and make sure every officer sees that. And again, then if they violate, it creates all kinds of different avenues for punishment or potential civil liability. But we're not increasing anything. And all we're saying is let's put it in every policy and make sure it's very clear.
I'm not aware that you're sure that is the current civil standard as well for police brutality lawsuits?
Well, I mean, it gets more complicated than that, but that's.
Well, we just simplified it a whole lot. It's no longer I mean, my concern is we just simplified it in Maryland. It's not that complicated. We just simplified it, and this law would do that. That this bill just basically whatever the standard was under 1983 or other constitutional challenges to police misconduct, that perhaps we've just radically changed it. That's my only concern. Is that what we're intending to do, and did we in fact do that?
We did not do that. We did not intend to do that. I will locate a jury instruction for you to see so you can compare it and know that we're on point. Is that all right, Chairman?
That'd be very, very helpful, actually. Yeah.
And then finally, on the next page, on lines 3 and 4 of page 6, it says law enforcement officers are used when safe and reasonably possible de-escalation techniques. Again, reasonably possible determined by who?
Again, it's potentially a trial board. So number one, it would be internal affairs. Then it would be the whole progression.
Right, and then back to a civil jury. But a civil jury is going to determine when it's reasonably possible to de-escalate, and they're going to say we people who have never been subject to this are going to.
And what you have is you will have experts on both sides at the trial board, at the jury trial, at whatever event you are at. You'll have an expert that says, here's what they were taught in the academy. Here's what they could have done in this case. Here's the body camera video showing that they could have slammed the door of their car. Here's one showing that they couldn't have done it because they were within 5 feet and the person had a knife in their hand. All these factors are exactly what happens now. And you would bring experts in, and then the defendant would bring an expert in to say, well, he couldn't do it this way because you can lunge in within 10 feet.
Thank you. My only concern in all this is that we be careful about whether we're setting new standards and whether this has been reviewed by folks looking at it from that perspective.
Well, it's not often you have the state's attorney, the FOP, and the chiefs of police all on the same side, and also Mr. Greenberg. It's not often we have all of us all on the same side, and I will try to solve some of your concerns.
Yeah, and maybe there's somebody in your county attorney's office who's responsible for brutality complaints and federal lawsuits and stuff who can look at it and provide.
It was written this way because each individual circumstance is unique on its own. And while you can try to compare it against other incidents and similarities, each instance of a use of force and what leads up to the use of it or the not use of it.
I got all that. That's not the problem. The challenge is just whether, I'd love to hear if somebody from Mr. Schellenberger's county attorney office who deals in this area. I'm sure they probably have somebody dedicated to it, can maybe let us know how they feel about it. So,
well, since it passed the county council, I assume that the county attorney had looked at it.
I don't know.
You guys have someone that does 1983?
Yes, sir. I'll take care of it.
All right. Thank you.
All right. All right, great. Thanks. This is helpful. This is good. And thank you, Mr. Schellenberg. One other thing I would say, the Baltimore City thing, we don't have anyone from Baltimore City here on the panel, that is. But I mean, I know we have two senators. I'm just on the panel about the police department. I know you guys are working on that. And the only thing I would want to correct for the record is that I guess one difference would be that although the council and the mayor have control of the budget and hiring and firing of the chief, they don't have the ability to kind of change policy, right? Policy of the department. I think that's probably what they're looking for. So a little bit more hands-on control. Okay, we have hands raised. So Senator Sidnor, you are first.
Thank you and good afternoon. I actually just have one question. The language in 3-523, as I look at it, this looks like Baltimore County's bill. That was just, is this what that is?
Yes, Senator Sidnor, I don't think you were here for my initial presentation. I took the Baltimore County bill and simply cannibalized it and asked the Department of Legislative Services to prepare a bill for us, which would apply statewide. So it's not surprising that this looks like the Baltimore County bill.
And with that being said, why do you, and it was interesting listening to Senator Castley with his discussion about if it's a law saying that it needs to be a rule, then it's a law, not a rule. I hadn't thought about that argument before, but I look at it, it says it's supposed to be a rule, so it's a rule. My question would be, why is it more appropriate for it to be a rule rather than a state law?
Well, I think the intent was to say to every chief of police, you need to put in your rule book this rule, and to make sure it was there all across the state, which then triggers, and I'm sorry, Senator Cinder, I don't know if you were on when I was talking about this, which then triggers the ability to take action, disciplinary action within the police department, could lead to a trial board, could also be used to talk to a jury, either criminal or civil, about what standards apply to all police officers. That was my understanding of the intention.
Senator Sidnor, that's exactly right. And what the chiefs and sheriffs are asking is that there is a uniform standard use of force policy across all agencies that's promulgated by the Maryland Police and Training Standards Commission. Because right now you're going to see different use of force policies in different agencies throughout the state, and we would like it to be consistent and promulgated by the Standards Commission.
So it wouldn't necessarily have to be this particular standard if we felt that that standard was not sufficient?
Well, I'd have to see what standard you're looking at, but certainly we're willing to work with all the committee members to get to that point of what would be acceptable and the standards from the Standards Commission.
Thank you very much, Mr. Chair.
Thank you, Senator Sidnor, supporting the good alpha man right there. Senator Bailey and then Senator Jackson. Senator Bailey, you're up.
Thank you very much. And I just wanted to say I'm happy to see the FOP and the chiefs and the county all on the same page. I think it's important that everyone realizes that the majority of these standards in this bill are already in place. It just seems to me to be putting it together in one thing. Couple quick questions. On page 4, when we talked about the standards and the training annually, is that the same standard for everything that we train under Maryland Police Training Commission?
There are multiple levels of training, multiple goals, multiple standards, and some have a 1-year annual training, some are 2 years and some are 3 years. This particularly, because it's got such important topics of anti-discrimination, implicit bias, and use of force, it would be annually or yearly.
Okay, I think there's a difference between the way it's worded here annually, and I think it should be potentially yearly.
It should be yearly.
Okay, just like firearms qualification.
Correct.
Okay.
Yes, and that would be one of the technical amendments that we would be raising.
Okay, other question that I have on page 5, line 16, why are we removing confidential and non-punitive? Because if we've identified an officer that is, that needs to come forward and needs to really have help, something that is issue, why would we take that right out of the current law about the fact that it is non-punitive?
It's a good question.
Yeah, I think it is a good question. And I think what happened was the draftsman took the Baltimore County bill, and in the Baltimore County bill, those words didn't appear. And so the draftsman probably wants to take them out of state law. But I think we should consider whether or not we should leave those words in the state law. So thank you, Senator Bailey. That's a good catch.
And it's not often that I'm speechless.
Okay, I do think that's important, being a former police officer, because we're really treading on new ground here, where it is difficult for somebody in law enforcement to step forward and say, I might need some help. And that is something that I think is very important as we move forward with this. The other thing is that I was going to say on page 6, line 25, well, actually in that whole paragraph, we're talking about reports. And those of you that have dealt with police officers, one thing that they hate to do is actually write unnecessary reports. And so we talk about line 25, it says the discharge of a firearm other than training is going to require a report. And we talk about, right before that, if you've been involved where you put your hands on somebody, these are extremely detailed reports. Now, I tell you, I was natural resource police. I have driven terrible distances to get to counties that were municipal jurisdictions because they had this written in their policy. If an officer used a firearm other than training, they had to write an extremely detailed report. Now, fortunately for us, because we're in rural counties, right, if it was an animal that needed to be discharged or dispatched because it was seriously injured because of a motor vehicle accident, we could drive up there, shoot it, call it in over the radio, and it was done, right? And the fact is that I had seen police officers from numerous jurisdictions say there's absolutely no way we're discharging that firearm because we're responsible for every bullet and we've got to write a detailed response. So those animals laid there on the highway suffering for hours when they should have been dispatched. And I think that there are some situations like that that probably could be addressed as we move forward with this that just make common sense.
Sure. I'm Senator, I'll be happy to work with you to modify this. We're already going to, I hope, do some modifications at the request of the sheriffs. So there's no reason why we can't work on this particular issue for you.
We have that simplified here in Baltimore County. So when you have to use your firearm to humanely, take care of an injured deer or something on the side of the road, it used to be, just as Senator Bailey was talking about, it was an extremely long report, and we would contact other agencies such as his that didn't have to do that to actually do it. And I actually put in a request probably 15 years ago because I actually had to do it and thought it was ridiculous. And we actually knocked that down to, it's about 1.5 pages, and it's mostly check boxes because it's a different kind of firearm discharge than firing at a person.
You're saying, Mr.
Thank you very much.
That makes sense, Mr. Rowe. I mean, but just caution there. I mean, discharge of firearms is a pretty big deal. Like, is it really?
That's what we thought. We still wanted the report and the documentation of the firearm being discharged, but it didn't rise to the level of, discharging at a person.
You got it. And then Senator Bailey, you reminded me. So Senator West, I took a note on this, but just with the part that he was talking about before, the confidential and non-punitive, Senator Washington, definitely want you to get with her as we move forward, just from her bill earlier this week. There's some stuff that you guys should definitely work on moving forward, but we'll get you together.
Sure.
Thank you, Senator Bailey. Okay, Senator Jackson.
Yes, thank you, Mr. Chairman. And I just wanted to to remind or to let members know that there are 4 legislators that sit on the Maryland Police Training and Standards Commission that was created out of House Bill 1016 after the rise in Baltimore stemming from the Freddie Gray incident. So there are 2 senators and 2 delegates, and I can tell you that from that particular time period, we had the opportunity, and we were intimately involved in the crafting of the standards per se. And this committee will see this year the public safety article was reflective of that. But I'm mentioning that because of some of the questions that were posed. We have opportunities to ensure that the Training and Standards Commission for them to do in accordance with what the intent of the legislation is. So as we move forward, that's another opportunity for us. So thank you.
Fantastic, Senator Jackson. Also, Jackson, I know you were on there in the House, and if you want it, which I think you do, you can take my seat on the Senate side. All right. Seeing no further questions, that will conclude the hearing for Senate Bill 237. Thank you, Senator West, for all of your good work, and thank you to the panel. Thank you very much. See you all later. All right, well, now I see Senator Ellis is here, so we'll move on to Senate Bill 260. Senator, you've been unmuted. You have the floor. The floor is yours.
Thank you, Mr. Chairman, Vice Chair, members of the committee. It's good to see you virtually. This bill, Senate Bill 0260, the Police Officers Performance Review Board. You can call this the Driving While Black bill. We hear so much around Maryland, the country, about African Americans, particularly being stopped at disproportional rate versus other citizens. Just this past summer, I saw a report in the Washington Post, came across, talked about in, this one was Montgomery County. It talked about African Americans 3 to 4 times, African American men, 3 to 4 times more likely to be stopped by law enforcement in Montgomery County than white men. And so, we hear these issues, we hear these reports. They are, pervasive throughout Maryland, throughout the country. And I think we're like, well, we can't do anything about it. And so the thing is, in our modern era with big data, we can collect this information. We can really understand down to the officer level what is going on. And if we can collect information, that means we can attack the problem and really do quite a bit to solve the problem. I must say, I was honored this past last summer to be nominated and accepted at the UVA Legislative Leadership Program. And we did it virtually, but it was a great program. We learned a lot. And I participated in a computerized test, and it showed that I had a bias. I'm like, wait a minute, this is impossible, right? And these things are all around. It's not necessarily something we walk out and decide to do certain things. And I listened through some of the last bill testimony, talk about implicit bias, and they're there. And I think if we look at data from an officer level, from say traffic stops, we can say, hey, we show a little disproportionality here, and we can address this with that particular officer. Like I said, it's not necessarily a deliberate, intentional. It could be. So we want to just kind of look at this and how we can solve this problem is happening so much around the country. Next slide, please. So in doing the research, I know we're from, you don't have to really play this video. I just wanted there for everyone to see when you look at several legislative. Okay, thank you. So we're from all over the state, And I know I look forward to being in Annapolis. I get to see the Baltimore stations and the news and the issues affecting the Baltimore region. So I just include these news stories. When you're looking at the evidence, you can look at this to see basically what's going on. But this is a story talking about the issues with police violence and how we can deal with it. So next slide, please. The purpose for this bill is to establish the Police Officers Performance Review Board as an independent board, and also mandate that the board to require all law enforcement agencies to collect certain data on officers' encounters with citizens. Next slide, please. This board would establish standards for appropriate race-neutral behaviors and impose sanctions for racial or discriminatory behavior. And it could also go beyond racial. It could be based on gender, it could be on any various disproportional actions by officer that will be measured by collecting these data points. I must say that, being a former military officer, we have so many standards that we have to go by. I remember even my officer evaluation reports that were at first as a young lieutenant done twice a year and later on once a year. It measured a lot of these issues. It talked about relations, being able to get along with so many other different different gender and races, because the military is a vast melting pot. So everyone is measured by our ability to work on and control those things that we don't think about sometimes. And so we need to have that in an established standard here in Maryland to really make all citizens feel like we can be protected constitutionally and our rights are not, human rights, constitutional rights are not violated from time to time. And this board will conduct annual reviews of police officer performance with a push of a button. This data is collected, it's stored, and we have a Maryland data collection agency. We can use that agency to really collect this data and to analyze and to see exactly that these, say, police stops are not disproportionately geared towards one set of folks. Next slide, please. From 2015 to 2020, over a 5-year span, data shows that 85 people were killed by police in Maryland. Of those 85, 50 were Black, or 59% of all casualties. And only 22 officers out of 85 were wearing body cameras. So basically, it's he said, she said. To put this in perspective, about 50 out of 85 Blacks being killed by police from that period of time. 30% of Maryland population are African Americans, but 59% of all these casualties were at the hand of police. What is that based on? Bias? We don't know. We don't collect the data. We don't parse it, and so we don't know. Next slide, please. Last year, because of the George Floyd situation, the Baltimore Police Commissioner commented on George Floyd's death. Said if it occurred in Baltimore, he wouldn't have been able to fire the 4 officers who were involved in that situation. But Minneapolis police were able to fire them. His quote is saying that if that were to happen here, I would not be able to terminate employees because of constraints on the law enforcement officer's Bill of Rights, he said. And of course, we will address that during this section. Next slide, please. In 2021, Marylanders are still relying on policing themselves. This is wrong and undemocratic, unconstitutional, and it violates the human rights of citizens. For us to collect these data continually, the biases are there, the disproportionalities are there, but we just kind of hold our hands up and say, well, we just can't do anything about it, and we don't do anything about it. This is wrong. This is definitely a violation of our human rights in Maryland, no matter what category of people you are in. But being African Americans, this is a violation of our human rights, international rights, to be safe in our country, not to be picked on. You're driving while Black and you're just being stopped, and there's no accountability at all. This is 2021. We have data, we have big data collected, and we can get a hold of this problem. So we would like to have something in place to analyze and to really do something about this problem. Next slide, please. The Independent Review Board would decentralize police brutality and excessive force, especially for marginalized communities. It would deter individuals associated with hate groups from joining the police force. And there's a small subset, the riots and the insurrection in Washington, D.C., January 6th of this year. Unfortunately, we had individuals in law enforcement participated in that. We had, even in my county, we had an individual who's since suspended who participated in that insurrection, and members of law enforcement. You know, we need to really address these issues. And I must say, being the military background also, we had military. We had quite a few Air Force personnel and veterans participated in that insurrection. But the thing is, we have to, anyway, those military folks were promptly dealt with. I know that, you know, we are going through the process now in Charles County of analyzing exactly the participation of that public safety official in the insurrection in DC. And so these individuals make up a small percentage of the military, small, tiny percentage of police forces. But unless we have a systematic way of dealing with these things and these individuals, then they will tarnish the entire good work that we do, whether in military or law enforcement. Next slide, please. In conclusion, I talked about our democracy. You know, we as citizens, we as lawmakers, we have to make sure that we can influence the behavior of our public servants. And here in Annapolis, as a senator, legislators, we have tons of ethical guidelines, what we can and cannot do. Hey, I can't call up someone and say, hey, give me some money now. No, we're in session. That's unconstitutional. You can't have any campaign contributions during session. We have tight rules. They're continually reinforced, and we are continually held to a higher standard. And we have the mechanism to do that. And we need to make sure that when it comes to public servants who are in law enforcement, they're also held to a higher standard. So this independent board will not only improve the relationship between police and communities, but we uphold the social contract which holds our democracy together. And so I just want to thank you for allowing me to present this bill, this concept, and I ask for your favorable support for this bill.
Well, thank you, Senator Ellis, and thank you for the time and the attention you put into this slide deck and into this work and this legislation. So thank you very much for that. We will now turn to the more talented and better looking Ellis. There you go. Mr. Ellis, Miles, the floor is yours.
Thank you. Greetings, Chairman Smith, Vice Chair Wildstriker, and members of the committee. I'm honored to be here today. My name is Miles Ellis, and I'm a research scholar at Harvard University. As a young Black man, I feel vulnerable when it comes to the police. It doesn't matter that I'm the son of a state senator or a Harvard student. I'm still in danger because of the color of my skin. I'm here today to discuss the importance of Senate Bill 0260 and how big data can be used to improve the outcomes of all citizens across the state of Maryland with regard to interactions with law enforcement. As an economist in training at Harvard University, one of my research endeavors is to mathematically identify outcomes of civilian interactions with law enforcement officers. Past economics research explicitly suggests that Black Americans are more likely to have smaller stakes encounters with law enforcement. Two important factors of this finding are: one, the vastly different degrees and strategies of policing across Black and white neighborhoods, and two, racial discrimination among police officers as shown in recent past published research. These disparities are proven through earlier research conducted by economists at the University of California, Berkeley, the University of Chicago, and Harvard University, and other institutions across the country. Some of the most striking factoids in literature surrounding the effects of these disparities in policing range from financial well-being to life outcomes and economic opportunity. One instance of significant bias is evident in the finding that by Dr. Ravi Shroff at New York University that in nearly 100 million traffic stops across the country, Black drivers were about 20% more likely to be stopped than white drivers relative to their share of the residential population. This data was compiled by academicians at the Stanford Open Policing Project. Without this crucial data, there would only be anecdotal evidence, which is far from sufficient for police accountability. If you look on the Stanford Open Policing Project's website today, you will see the necessary data for accountability and racial equity in policing is unfortunately very sparse in Maryland. The state of Maryland must mandate each police department to record demographic factors such as race and other details pertinent to encounters such as police traffic stops in order to cultivate greater accountability to eliminate the life-threatening presence of racial bias in law enforcement practices. Thank you.
All right, thank you, Mr. Ellis. And we'll now move on to Pastor Ellison. You are up next. I think I hear some feedback. Is everyone muted? If you are not, if you please mute yourself. There we go. All right, Pastor, you are up next. So Pastor, hold on, we have to restart. Let's go ahead and unmute you.
Can you hear me now? Again, I give honor to God and to Senator Ellis, to all the other senators who make up this commission and this committee. I want to thank all the other delegates and pastors and police and people who have assembled. My name is Angelo Ellison. I'm pastor of the Restoration Worship Temple Church in Clinton, Maryland. I'm second vice chairman of the Clergy Committee United for Police Reform. I've lived in the Maryland area for the past 40 years. In fact, my daughter, Janine Lynn Ellison, was one of the Prince George's County District Court commissioners until she passed away in 2017. 3 of my grandchildren's mother is a police officer. I served as a civil servant with the district government for over 28 years as a facility manager. I was responsible for all the Metropolitan Police Department facilities. I was also chief engineer of engineering and maintenance for the U.S. Homeland Security headquarters. One morning while driving to work to my position at the Homeland Security headquarters, I was pulled over by a police officer And I asked the question, why was I being pulled over? And the police officer began to just query me and question me about what was in my car. So I asked him what was the reason for the stop. And he evaded the question, asked a whole bunch of other questions. I say that to say that this adds to what Senator Ellis had reported. I was just guilty of driving while black, working for Homeland Security headquarters. Another time I was just walking. I live in the Malton community where I've lived for over 40 years, just walking in the community, getting some exercise. And all of a sudden I was pulled up on by 2 police officers, told to get up against a tree. I resembled somebody, and I said, what's that? Another black man walking. I want to thank Senator Ellis for sponsoring Senate Bill number 260. I want to thank Senator Ellis for this precious privilege to come before you to pontificate our position as proponents in support of State Bill 260. As Clergy Community United for Police Reform, we support Bill number 260 because we believe that if it is signed into law, it will create a police performance review board that will hold all police officers accountable for their conduct. We are in support of this bill, and we think that it will help vet police officers that break the law that they've been sworn to uphold. The Police Performance Review Board should have members of the clergy and community, I believe, on it, and suggest using folk from other counties, municipalities, as opposed to the municipality where an offense may have been cited. We don't want proud boys on our police forces. We want policemen that are proud to serve as peace officers. Policemen and women that are full of integrity, promoting equality and justice for all. We believe that this bill will help get police officers off our backs and off our necks so that we can breathe, so that people and police at the end of the day can go home. I close with this, and I want all of you to ponder this thought. It was said that the only thing needed for evil to persist is for good men to see it, then say nothing, and then do nothing. I think we have an opportunity here to change this culture in this community, because it's going to affect our generations to come. I've got a 26-year-old son, and I wonder what's going to happen from day to day. I've got a 10-year-old grandson. I don't want them to have to live through this racial bigoted environment that I was raised in. I recall walking one day in North Carolina, just minding my own business. Wanted to go see some television because we didn't have any. And then walking home that night to have a car ride by me and call me the N-word. And it was Ku Klux Klan, and I remember the car. Then to find later the positive person or one of them driving the car may have been a police officer. I say we need today make change, be the change we want others to see and be. God bless you.
Thank you very much for your testimony, Pastor. And did you work at the NAC?
Excuse me?
Did you work at the NAC?
Yes, up in Northwest.
Yeah.
Yeah, I was a chief engineer there for them from 2012 to 2014, I believe it was.
I knew you looked familiar. Anyway.
Okay, all right.
Anyway, thank you very much for your testimony. Okay, I don't know why we have that feedback going on here, but we'll now move on to Reverend Carrie Hill. Reverend.
Good afternoon, Mr. Chairman and Mr. Vice Chairman, to all the members of the committee. My name is Reverend Dr. Kerry Hill from Camp Springs, Maryland. I am a former state delegate I represented District 26 in Prince George's County. I truly appreciate the opportunity.
Mr. Hill, sorry about that. Can you, you were accidentally muted, so if you could unmute, and then, sorry about that. And then for the staff at JPR, they could just mute the feed there. I think there's some feedback coming through. Huh? Sandy, you're live. You're one of the computers is live. If you can mute the system over there. Reverend, go ahead.
Okay, thank you again. Good afternoon, Mr. Chairman, Mr. Vice Chairman, and to all the committee members. I come to support Senate Bill 0260, Senator Ellis. For the record, my name is Dr. Kerry Hill. I serve as senior pastor of a local church in Camp Springs, Maryland. I was a former state delegate for the state of Maryland, representing District 26. I truly appreciate the legislative process and each one of you and your services to this great state of Maryland. Please note, I'll also commend all of the awesome and fine, outstanding law enforcement officers in Maryland. I commend my fellow supporters and the bill sponsors. I know that they have done awesome work in carving out this bill and researching it. And so I just thank you today for this opportunity. My position today was just be a position of encouragement for the urgency of now. Believe it or not, in 1998, I sat on the Maryland House floor with my son on my lap. And in the next 4 years, we were discussing some of these same issues. I did say 1998. I sponsored a bill as a freshman to restore the voting rights for ex-offenders in 1998. Did not make it out of subcommittee the first year. The second year, it didn't make it out of committee. The third year, it was turned into a task force. And the fourth year, it was finally passed. I just want to say we don't have the luxury to wait, because all the time that we're waiting, there could be the potential of another person killed, another person arrested unjustly, another person searched. So am I looking at the recent events, the deaths, the illegal stops and searches, the profiling, and then January the 6th, and the role of those who participated in the attack on our nation's capital. I'm very concerned about our posture now. I thank God every day I have a chance. I walk a lot. I walk the Woodrow Wilson Bridge. I see police officers. I make it my intentionality to go up to them and thank them, no matter what color they are, no matter male or female, black or white. I just want to make sure that they're being encouraged. I know their job is hard, but also I know that this state of mind, this season that we're in, we cannot continue. To Mr. Ellison, Pastor, I have a 26-year-old son also. And one of the toughest things for me is my son sat on my knee in the General Assembly when I was elected, and I felt more comfortable then for him than I do now. I had to ask him, beg him, plead with him, pull him to move back home recently, because I just wasn't comfortable with him being out on his own. I'm not living in fear. I'm living in America. I just ask you all to please consider this bill. Again, when I was in the General Assembly, we were leaders. We thought it was proud to be the first of. We led in business reform, healthcare reform, and now I'm asking you all to be leaders in this reform to make our America what she ought to be. In Maryland, the great state that she is. And so again, I ask you all to please accept this support for Senate Bill 0260. And thank you, Senator Ellis, and to all the senators, and to Senator Jackson too. Thank you all, and bless you all. Have a great day.
Thank you, Mr. Hill, and delegate, former delegate. Thank you for your service. and your testimony here today. I'm looking around the room. I don't see anyone with their hand raised. So with that, that'll conclude the hearing for Senate Bill 260. Thank you very much, Senator Ellis, and to Miles. Good luck with your studies. And thank you. All right, now we will move to Senator Carter, Senate Bill 178. Senator Carter, the floor is yours.
Good afternoon, Chairman Smith and members of the Judicial Proceedings Committee. Can you hear me okay? Just checking. So, Mr. Chair and members of the committee, I'm Senator Jill Carter from Baltimore City, and this is not the first time that I've introduced this bill or an iteration of it. In fact, between myself and other members of this body, some iteration of this bill has been introduced in prior years, going back almost 10 years, ever since the Court of Appeals made a decision in the DeShiel case that denied a victim the ability to have access to her own record regarding a complaint that she filed. And so here we are now as we move toward greater police oversight and transparency. I believe Senate Bill 178 is an essential step forward in improving public confidence in law enforcement. We have renamed this bill to caption it Anton's Law, as well as being a personnel records permissible to create permissible personnel records of law enforcement officers. Anton Milbert L. Black was a 19-year-old that was killed in police custody in Caroline County in 2018. According to the Governor's Office of Crime Control and Prevention, there were 31 in custody deaths in Maryland in that year of 2018 alone. The Black family, like the earlier person mentioned, the victim DeShiel, has been unable to gain access to the records regarding the investigation of Anton Black's case. In Maryland, members of the public are not able to access any records of misconduct against law enforcement officers, including complaints that they themselves have filed. As of 2020, Maryland is in a minority of states that make misconduct records completely inaccessible to the public. It should not require a special investigation for, such as the Department of Justice or a federal prosecution, such as in the case of the Gun Trace Task Force, for the public to learn of misconduct allegations and cover-ups within police departments. Members of the public should have certainty that their complaint will be taken seriously, and under the current law, they cannot. And so I want to briefly touch on what the bill does, because this bill does not mandate that all of these records will be disclosed. There is still some discretion on part of the agency and its custodian of records. It simply makes the allowance that it is now that the custodian of records for these agencies, police agencies still now, allow the disclosure of a record relating to an administrative or criminal investigation of misconduct by a law enforcement officer, including an internal affairs investigatory record, a hearing record, records relating to disciplinary decisions, and these will no longer be mandatorily barred as personnel records under the Maryland Public Information Act. Now, a custodian of records has the right to deny request, and these records are not disclosable under this bill if they do certain things, such as interfere with a valid and proper law enforcement proceeding, deprive another person of a right to a fair trial or an impartial adjudication, constitute an unwarranted invasion of personal privacy, disclose the identity of a confidential source, disclose an investigative technique or procedure, prejudice an investigation, or endanger the life or physical safety of an individual. Some of you may have recently met with members of the Office of the Public Defender, who I know had talked to some members of our committee And if so, you may have seen some photographs such as the one in this picture here. This happens to be a young man that was badly beaten by an officer who broke into his home while fellow officers were raiding a neighborhood apartment. This is just one example of the types of records that are not currently disclosable, not only to the complainant, but to the public. And so the Office of the Public Defender, and I thank specifically Attorney Debbie Levy for sharing this information with us and with me. And these records that are not disclosable under the current law are not only prohibited in many instances from the complainant or from the public in general, but also there are restrictions still imposed under law when it comes to criminal defendants. Just recently, the ACLU released a report analyzing 5 years of data regarding misconduct in the Baltimore Police Department. What they found was that in 6% of Baltimore police officers received 1/3 of all complaints, that only 8% of those complaints were ever sustained, which means that the department's internal investigators determined that 92% of complaints were unfounded or unjust or justifiable. In addition to the scathing data from the Baltimore Police Department and the case for which this bill is named Anton Black, this is something that has been the case in every jurisdiction in the state of Maryland. In just the last year, there were media reports of misconduct allegations in multiple counties. And in the last 10 years, there have been police misconduct allegations and findings in Anne Arundel, Baltimore City, Baltimore County, Frederick County, Howard County, Prince George's County, Wicomico County, Cecil County, Montgomery County, Washington County, and Charles County. I want to highlight one other example, a very recent one of a victim where the current law has prohibited disclosure of critical records. And actually, we believe had these records of this individual officer been disclosed previously, then there's a good chance that the victim, William Green, would not have been killed. So I'm going to share some information about the William Green situation that I received from his attorney, Malcolm Ruff. On January 27th, 2020, William H. Green, a 43-year-old Maryland resident and father of 2, was viciously murdered by Prince George's County Police Corporal Michael J. Owen. Owen shot William 6 times in his torso from point blank range, even though William was unarmed, handcuffed behind his back, and locked into Owen's police cruiser. Owen had been brutalizing citizens of Prince George's County throughout his 10-year career. Owen was a deeply troubled officer who suffered from mental health issues stemming from a shooting that occurred early in his tenure. Ultimately, William Green's death could have and should have been prevented by the leaders of the Prince George's County Police Department, because Owen should have never been allowed to remain on their force. Tragically for William Green and his family, and numerous other victims of police misconduct and brutality, law enforcement agencies in our state have never been compelled to operate under a culture of true police accountability, true public accountability. In William's case, Corporal Owen had committed several prior acts of excessive force and violence that were insufficiently investigated or ignored by the Prince George's County Police Department. In one such instance in 2016, a Black woman formally complained to the department that Owen had caused her to urinate on herself in the backseat of his squad car while handcuffed behind her back when he unjustifiably and violently choked her during a routine traffic arrest. Despite having contemporaneous evidence that corroborated her allegations of being assaulted by Owen while completely defenseless, the Prince George's County Police Department determined that they could not conclude one way or the other whether Owen had committed an act of police brutality. If the Prince George's County Police Department had earnestly investigated this claim, or if their investigation had been the subject of public scrutiny, William Green would likely still be with us today. this is but one of many junctures in Owen's career when true transparency could have spared William's life. The situation of Prince George's County Police Department and Officer Michael Owen are not unique. Sadly, this is the case routinely with the Baltimore Police Department and police departments across this state. I am going to end my testimony and defer to the witnesses on my panel. I do believe that there is a large amount of favorable testimony that we have in our written testimony that we've received, and that I was able to ascertain. I only saw 2 unfavorable testimonies from the FOP number 89 and from Scott Schellenberger. And so I think that speaks volumes, because we've come a very long way on this issue of the need for police transparency and accountability, where those would be the only opposition. And in reading those opposition, I didn't feel, and if you can see for yourself, I didn't feel that the FOP opposition specifically got at what this bill does. And so I have not seen any legitimate criticism or opposition to what this bill seeks to bring us. So thank you for your time, and I'll defer to the rest of the panel.
All right, thank you, Senator Carter, for bringing us this legislation, and thank you for your presentation. I'm just going to go down. I see David Roca is here, so David Roca will kick us off for the panel for the proponents. So, Mr. Roca, I'll unmute you here. There you go.
Thank you, Mr. Chairman and members of the committee. My name is David Roca. I'm a senior staff attorney with the ACLU of Maryland. Senate Bill 178, Anthem's Law, is one of 5 key bills that a broad coalition of more than 90 organizations throughout the state believe must be passed this session to begin addressing the real crisis in policing in this state and this country. It addresses the veil of secrecy that currently surrounds police department investigations of police misconduct, which shields departments and chiefs from accountability for the failures of that accountability system. Allowing transparency will not by itself magically fix all of the problems, but it is an absolutely necessary first step, because we can't even begin to address the causes of failures in accountability, either systemically or individually, without clear, complete, and factual information about those failures, which current law blocks us from having. Why do we have a veil of secrecy? Because of the Court of Appeals decision in DeShiel versus Maryland State Police, which held that records of police investigations into allegations of misconduct should be considered personnel records, a category of public records that is entirely prohibited from being disclosed to the public. As a result, not only are we denied the ability to see any records related to how departments hold officers accountable, departments can't say a word about any of those investigations, even to explain the results, other than, trust us, we did the right thing. Needless to say, that is not how anyone actually gains any trust. It didn't, and it doesn't have to be this way. Courts in other states, for example, Connecticut, have reached the opposite conclusion that disciplinary records should not be shielded from disclosure as personnel records. And in many more states, the open records laws explicitly permit disclosure of such records. And even in states that have, like Maryland, historically shielded such records, legislatures are acting to change that, as New York did last year, not only permitting disclosure of such records, but mandating it with limited redactions for particular information. So what does this bill do? It's extraordinarily modest. It doesn't mandate disclosure of any record. It simply moves records of investigations into police misconduct from the category of personnel records, which can't be disclosed, even if a department wants to the category of investigative records, the same category that applies to police investigations about all of us, which are discretionary denials. That means that they are not categorically shielded from disclosure, but departments retain broad discretion if disclosure is, quote, contrary to the public interest, to withhold or redact information to protect other important interests, including those that are specifically enumerated in the statute, like privacy, the integrity of investigations, confidential sources, etc. But, and this is critical, if a record or part of it will be withheld or redacted, the department actually has to have a reason. And that reason can be challenged in court if the requester thinks it's being asserted incorrectly or in bad faith. The MPIA and case law makes clear that some reasons are presumptively valid. An open investigation, release would pose a danger to a person, it would interfere with a fair trial, constitute an unwarranted invasion of privacy, etc. All of those reasons are presumptively valid. And again, this is the standard that has governed police records about you, me, and every other Marylander for decades without any problems. And the reforms that we are proposing, the reforms that we're proposing are quite popular. In a national poll conducted by u.gov, 72% of respondents said that they thought that these records should be available to the public. That was from last year. And a Goucher poll specifically of Maryland residents in October of 2020 showed that 87% supported creating a record of police misconduct cases that would be available to the public. Why is the current situation such a problem? At the individual level, if I file a complaint against an officer, the only thing that I can ever learn under current law is whether the complaint was sustained and what the punishment, if any, was. But if I want to know anything about the investigation, whether it was complete, timely, fair, etc., and if I want to know why the department reached the result it did, too bad. I can't get any of the records and the department can't tell me anything other than trust us, we did the right thing. That is not an acceptable state of affairs in a democracy. That's not an acceptable state of affairs in a democracy and not a way to create or maintain trust. The effect is precisely the opposite. Equally importantly, the public at large doesn't get to know anything about these investigations and how or whether departments are adequately performing their oversight and accountability function. Whenever there is a critical incident, the public legitimately wants to know, what did the department know about this officer before the incident happened, and could it have been prevented? But under current law, they can't know anything, and that question is unanswerable. Again, all the chief can say is, trust me, we did the right thing. That's not enough. And why don't people have trust? Because in every department for which figures have been released, at least 90% of the complaints made by the public are not sustained. Now, maybe you think that's because 90% of the complaints that the public makes are frivolous and should be dismissed. But you can't actually know that because you can't see any of the records. And when the records do get looked at, what we see is that it isn't because the complaints are frivolous, but because of systemic problems in the accountability process. For example, the United States Department of Justice looked at BPD's internal investigations, which I should add, they had trouble getting because of the very MPIA provision we're talking about now.
Mr. Roca?
And they found systemic deficiencies. They concluded for years, the department's process of investigating and adjudicating complaints has been plagued by systemic failures, including discouraging.
Hey, Ms. Your time's expired, but I guarantee you we're going to get to you with questions as the committee goes forward here. So the time expired, and so I want to move on to the next panelist, but please be assured, I'm sure we'll have a robust discussion on this bill. Next, we will have Mr. Love. You are up next.
Good afternoon, Chairman, Committee. Davon Love, Director of Public Policy, Leaders of a Beautiful Struggle. Can you all hear me? All right. There's some of this committee and some of the general public that have made the claim that given the spike in homicides in Baltimore City, that focusing on issues of police accountability are not addressing the real problem. This presents the notion of addressing police accountability and violence as issues that are at odds with each other. And what I want to spend my time talking about is the fact that this is a false notion. That if we look at the level of corruption that exists in policing in general and across the state of Maryland, I think we'll find that if we address police accountability, it will help us deal more effectively with the issue of public safety and the role that police can play in that. When we look at the 2016 Department of Justice report that found a pattern and practice of misconduct and unconstitutional policing, there are several incidences of police misconduct that were cited in that report. A lot of times we focus on the police killing and kind of the more extreme issues of brutality. I want to actually read an excerpt from that report that just gives an example of some of the more common practices of police violating the human rights of folks in community that happen more routinely. It says in September 2014, a man filed a complaint stating that an officer in the Central District of Baltimore City searched him several days in a row, including undoing his pants and searching his quote hindquarters in a public street. When the strip search did not find contraband, the officer told the man to leave the area and warned that the officer would search him again every time he returned. The man then filed a complaint with Internal Affairs and identified the officer who conducted the strip search by name. When Internal Affairs investigators pressed the man to provide a detailed description of the officer, the man recalled that the officer had a red patch with sergeant stripes on his uniform. The investigator recognized this description as patches worn by the officer in charge of a shift and confirmed that the officer named by the man was working as an officer in charge of the Central District on the dates the man alleged he was strip searched. Internal Affairs nonetheless deemed the complaint not sustained without further explanation. So this is an example of the kinds of things that were put in the unsustained category, things that were not deemed by Internal Affairs as something worthy of further investigation. This is why it's important for us to have sustained and unsustained complaints of this sort. One of the reports that recently came out is the Commission on Restoring Trust in Policing. And there are a couple of findings in it that I want to highlight. The first is that many of the things that were illuminated in the Gun Trace Task Force investigation actually were happening while the Department of Justice was conducting their review of the police department. And so it's astonishing that even the federal government investigators were not able to capture the specific kinds of misconduct that were later found in this federal trial, which means that there's the information about misconduct is a premium. I think 20 more seconds. The last thing I want to highlight from this report that I think is particularly important is that it showed a study that was conducted. Mr. Roker touched on some of this, but I just want to read briefly one of the things that this study that was conducted that is cited in this report. Community members are eager to participate in police oversight efforts. This is a report done by Johns Hopkins Center for Gun Policy. And many associate improved data transparency with increased trust. 64.5% of respondents having community members participate in police oversight with increased trust of police. So I can say this to say that we're serious about dealing with the issue of public safety, and a lot of folks that deal with public safety talk about the importance of community being involved in helping police apprehend those that are the drivers of violence. We have to address the issue of folks' trust of police, and one of the central ways to do this is to provide the public with more access to information about investigations that happen as a result of misconduct directed at community members.
Thank you, Mr. Love. Appreciate it. And just for the record, so the lead witness gets 5 minutes, and so we don't have the timer up here, but we'll actually have some more. I'm sure we'll have some more back and forth in Q&A. So just wanted to make sure folks were aware of that. But thank you both for your testimony. We'll now move on to Mr. Hansel. You're up next, and then followed by Mr. Franklin. I see you over there, so you're on deck.
Thank you, Chairman Smith and Senator Carter for sponsoring this important legislation. My name is Kerry Hansel. I'm one of the co-chairs of the Civil Rights section of the Maryland Association for Justice. We are the largest group of civil rights lawyers in the state of Maryland, and we are urging a favorable report on this bill. Police hold a sacred trust in society that includes the power of life and death that the public cedes to them in the performance of their duties. They are publicly funded, and because of this funding and this responsibility that they carry, the public has a natural right to know when they have committed or are accused of committing a misconduct. This bill will help civil rights lawyers and others stop future misconduct by making sure that those that commit it are identified and dealt with. It will also allow citizens in Maryland to better exercise their civic duties. So the civic duty of voting, the civic duty of contacting and communicating with our representatives is helped when citizens are better informed. And so this bill will permit for citizens to be better informed, to both keep an eye on their public servants in the form of individual police officers, but also to keep an eye on departments, because after all, this isn't just about problematic officers, but also about allowing citizens to see how a department deals with those officers and whether or not there is a repeat problem in particular departments and an issue with officers being dealt with. It's my sincere belief, as someone who has spent 20 years practicing civil rights law in Maryland, that the passage of this bill will save lives. As Senator Carter suggested, there are examples in the state of Maryland where if the prior record of an individual had been known and the citizenry and our leaders had an opportunity to act, that lives would be saved. On the flip side, there are very careful and measured steps being taken here. This is not throwing the door open. So for instance, the inspection of these records could be denied if they interfere with a proceeding, if they deprive someone of a fair trial, if they constitute an unwarranted invasion of privacy, if they disclose the identity of a confidential informant, if they disclose an investigative technique, if they prejudice an investigation, if they endanger life or safety. So this is not a throwing open the door of public access. Thank you, and we urge that the committee issue a favorable report.
All right, thank you very much for your testimony. Ms. Franklin, you're up.
Thank you, Chairman Smith. And members of the committee, this is a very important piece of legislation. And again, my name is Neil Franklin. I'm a 34-year police veteran from Maryland, Maryland State Police, Baltimore City, and Maryland Transit. I'm representing today the Law Enforcement Action Partnership, which is a national organization of police professionals all across the country, where many of our chiefs and sheriffs are already supporting this type of legislation. As a matter of fact, many states have already moved forward. And please take a look at my written testimony for more detail regarding that. This is about increasing the professionalism of the policing profession, and that's what we at the partnership are about. In the wake of George Floyd's death and exposing Officer Chauvin's abusive past, it should be now known that there are police officers, quite a few as a matter of fact, that have things to hide from the public. Criminal issues, use of force, truthfulness, perjury, racial bias, et cetera, et cetera. We know that many police officers not only attended the January 6th rally in DC, but took part in the insurrection at the Capitol. And we need to work to expose such behavior. It's time to expose cancerous police officers throughout the profession, and this bill can help do that in line with some of the other things that you've already have heard regarding the improving trust with our communities and the public. Many states have already moved to do so, and Maryland needs to get beyond the curve and be a leader in this regarding this piece of legislation. Police officers opposed will say that this is dangerous for police officers. In the states where such transparency is already in place, and it's been there for years, there have been no reported violence against police officers due to such policies of transparency. So the data doesn't support that claim. The police follow 9 basic policing principles in this country, known as the Peelian principles of modern policing. And principle number 2 reads as follows: to recognize always that the power of the police to fulfill their functions and duties is dependent upon public approval of their existence, actions, and behaviors, and on their ability to secure and maintain public respect. In short, the police exist because of the public, and the work that they do, okay, I'll wrap up, should be approved by the public. So in order for us to gain that trust and gain that respect, as Sheriff Popkins said earlier when he spoke about the importance of trust, community trust, and as you just heard Davon Love speak about that as relates to improving public safety, it's important that you give a favorable report for SB 178. So again, thank you for the time.
Thank you, Mr. Franklin. Thank you for your testimony, and thanks to the proponents. We'll now, Mr. Morris, Chief Morris, you're registered with favorable with amendments. So the floor is yours.
Good afternoon, Chairman Smith, Mr. Vice Chair, Wallstreicher, members of the committee. I'm Chief Morris, representing the Maryland Chiefs and Sheriffs Association. I want to thank you for the opportunity to speak briefly today. We've submitted our written testimony, so I'll just hit a couple of the highlights. Let me state without equivocation that the Maryland Chiefs and the Sheriffs Association support efforts to enhance law enforcement transparency and accountability, period. With that said, we support measures that will promote early warning and identification and intervention programs such as that was offered yesterday in Senate Bill 74, which we spoke in favor of. Under the current law, all public employees, personnel files, and investigative records are protected from public access, and is to protect the privacy of the employees and the officials. The chiefs and sheriffs seek statutory authority to be able to, with exceptions, certain exceptions, be able to speak about those situations that are the most vital interest to our communities, but to do so in a way that provides a reasonable, balanced, and fair approach. Specifically, we've worked with this committee as well as the House committee to amend the current PIA that would allow for the release of investigative files involving the discharge of firearms by a law enforcement officer, or those uses of force by a law enforcement officer that result in serious bodily injury or death, as well as sustained investigative findings in those cases involving sexual assault, dishonesty, perjury, false statements, etc., or engaged in prohibited discriminatory type of behavior in the reporting, investigation, or the prosecution of a crime. But we also recognize that it's important and frankly dangerously unfair to apply a perfect metric to our law enforcement officers when they're without recognizing that they are dealing with the imperfections of society and engaged in tense, rapidly evolving, stressful, and frankly very dangerous situations. So we have to find a reasonable approach, and we look forward to working with this committee in being able to do so, and to be able to amend this bill in such a way that it recognizes the hard work that our law enforcement officers do every day, and to also be able to be responsive to our communities. And with that, we thank you for your time.
All right, thank you, Chief Morris. Next, we will have Dr. Mara Janovic. Sophia, you there? There you are.
So my name is, my name is Dr. Sophia. I trained at NIH in Bethesda. I am of the Ocheti Shakwi tribe. I am a survivor of domestic violence and police misconduct that led me to lose my 28-month-old breastfeeding son. In 2012, I was attacked holding my 10-day-old newborn son. I called the police. This began the nightmare of dealing with domestic abusers on the police force, coordinating with abusers to dominate and control survivors. I lost custody of my son to our abuser. Officer Freddie Charles, with a history of domestic violence, is in charge of the supervised visitation unit of the Anne Arundel County Sheriff's Department. He claimed he fears for his life around me because I video record all interactions and have gotten unethical people reprimanded. In particular, psychologist by the Maryland Board of Examiners of the state of Maryland. In 2016, I got a provision in House Bill 1016 for civilians to get outcomes of investigations of our complaints about police officers. The way the bill was written leaves us unable to get the reports. My nightmare has continued since I last testified here. Anne Arundel County Sheriff's Department asked me how much money I was willing to pay to see my son. Police are considered neutral witnesses in courts despite getting paid overtime to attend court hearings. I have suffered for years, even becoming completely debilitated from pain, struggling to feel safe in my own body. I eventually became homeless and enslaved in human trafficking as a result. I've been in therapy for years trying to heal. But when the system is so unsafe, I need the system to be repaired to be safe. 40% of law enforcement are domestic abusers. 4 women by domestic violence. I demand that Senate Bill 178, that you release all disciplinary records. The whole system is complicit in keeping my son in danger in the custody of an abuser, of a civilian review board. My other demands are to abolish the police and replace the police with safer systems that are systems that are outlined in my written testimony that I've already submitted. So judges, prosecutors, public defenders, court clerks, etc., are part of a broken system systematically terrorizing the most marginalized people in Maryland. In fact, I'll wrap up. In fact, when I reported my son's disclosure of sexual abuse at his daycare in which his father had him, Ms. Brown of Maryland Child Protective Services told me that she had taken my son, who is not even 3 years old yet, into a room by himself with her, asking him direct questions. This is not appropriate procedure to investigate child sexual abuse on children under 10 years old. When I told Ms. Brown this, she scoffed that I am just going to have to get the law changed. And so that's why I'm here today. Thank you.
Thank you very much for your testimony and for taking the time out today to join us. Next, we will have Mr. Schellenberger. I see you're unmuted and you're ready to go.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I guess I have to learn how to word my documents because it says opposed with amendments as opposed to favorable with amendments. I agree with Chief David Morris. I think we do need to make progress in this area. The place where I'm concerned is mere allegations. And that is mere allegations would become public and therefore could affect an officer who's about to testify in a criminal case. And that's why in my written testimony, I point out that I think that when we're looking at things concerning dishonesty and things like that, that could be relevant to a criminal case, we should limit it to sustained findings. And if it's sustained findings, then I have no problem with them becoming public. And the thing that I worry about is if you have an officer who's involved in a very serious criminal case, you could have a friend of the defendant make a mere allegation against the officer, and that could become public and therefore could influence a jury. And that's where my concern is. And I don't really see anything in the list of exclusions there that would necessarily prevent the police department from prevent that from being disclosed. So I believe it should be sustained findings. You know, someone said to me once, well, you know, you could charge anybody with theft. And the answer to that is yes, but you have to convince a commissioner that you have probable cause signed under the penalties of perjury. And even this body, mere allegations made about ethical issues with this body are not public until after you've gone through a process. So I believe that we can take a step forward in this way. I agree with David Morris that we can do so, but I do believe we have to limit it to sustained findings. Other than that, I would support the disclosure. Thank you very much.
All right, thank you very much, Mr. Schellenberger. So that rounds out the panel for proponents and opponents, and then will now give us an opportunity to have a discussion with the committee members. So I see a couple hands raised. We'll start off with Senator Hedelman and then go to Senator Casserly. So Senator Hedelman, here you go.
Thank you, Mr. Chairman. I actually have two initial questions. One is just to follow up on what Mr. Schellenberger just said. There are lots of states that make public unsustained complaints, and I'm wondering if the things that you're fearful of have been an issue in those states.
And if that's directed to me, Senator, candidly, I have never taken a look at that. This one kind of came up pretty fast for me, but I would certainly be happy to do some research on that issue and get back to you and the committee.
Thank you. Thank you. And my second question is for Mr. Roca. Can you talk a little bit about what the problem is now, what the problems are? You said that, if you could just elaborate a little bit on how this bill fixes that. You said that whether the complaint, now we can only find out whether the complaint was sustained and what the punishment is, and kind of the importance of, what this bill would do.
Right. So thank you, Senator, for the question. What I was starting to say at the end of my testimony, I was trying to articulate why the current situation is such a problem. And what I was saying is that the lack of trust that people have in the internal affairs process is grounded in reality, because when these records do get looked at, what we see is that the complaints are not getting dismissed because they're frivolous, but because of systemic problems in that accountability process. So I talked about what the DOJ found in Baltimore City. Another recent analysis that was enabled by a lawsuit that we filed against the Prince George's County Police, which is based on court-ordered discovery into use of force records there, showed that of 6,800 use of force reports that were reviewed by supervisors from 2016 to 2019, 94% of which involved use of force against Black or Latinx people. Only 15 were flagged by supervisors as not justified and sent to internal affairs for investigation. And of those 15 that were sent for investigation, only 5 were actually investigated. And of those, only 2 were sustained, with the officers getting only a fine. And of another 237 use of force reports that had been found justified in the supervisory review that were investigated by internal affairs, only 4 were found to be sustained, including 2 which resulted in criminal convictions of the officers. So these are cases that the supervisors had said was perfectly fine, and they resulted in the officers being convicted of a crime. The other 2, again, resulted in a fine. And then I need to say something about the very recent, just utterly infuriating report that my colleague at the ACLU put out just a few days ago, which analyzed 5 years of anonymized complaint investigation data that was released by the Baltimore Police Department. That report showed that from 2015 to 2019, there were 13,392 complaints of misconduct filed against over 1,800 Baltimore City police officers, even though as of December 2017, there were only 809 officers who were actually patrolling the streets in the BPD's 9 districts. The complaints from the public made up 75% of those 13,000 plus complaints, and they were sustained 8% of the time, while internal complaints were sustained 21% of the time. A white resident's complaint against the Baltimore police officer was 61% more likely to be upheld than a Black resident's, and a complaint against a Black officer was 44% more likely to be sustained than one against a white officer. And from 2015 to 2019, there were 137 officers who were the subject of 15 or more complaints. And my colleague also painstakingly de-anonymized some of those records using other public information, which took him months to do. And in so doing, he found that among those 137 officers who were the subject of more than 15 complaints, several GTTF officers, namely Herschel, Ryan, and Jenkins, accumulated 40, 46, and 47 complaints respectively, not during that entire time, but just from 2015 until they were indicted. So before their names became household names. Another example from that report, Officer Sherrod Watson, who had 40 complaints against him in this period, lied on the witness stand by falsely claiming to have seen a defendant on a daily basis and witnessing selling drugs, even though that defendant was already in jail at the time that he was talking about. On cross-examination, he admitted that his testimony was factually impossible, and the defendant was acquitted. The Baltimore Sun reported this incident to the BPD on January 11th, 2018. On August 1st of the same year, the BPD closed their internal investigation into Watson's perjury, and they did not sustain the complaint. One more example, former Police Sergeant Joseph Donato, who left the department in 2017 and had some of the past complaints against him discussed publicly in a rare criminal proceeding in in circuit court. During that same period of time, he had 66 complaints filed against him from 2015 until his exit from the department. And during that same time, there were 40 complaints against two more officers, Officers Richard and King, that were sustained. I'm sorry, during that same time period, there were 40 complaints sustained, not filed, but sustained against Officer Richard King, including 6 for false arrest, 3 for assault, and 1 for DUI. I commend this report to you because it is full of infuriating examples like this over and over again. And many of them, if you don't want to read the entire report, are highlighted in an article from the Appeal about the report. I want to mention one other case because it I think illuminates perfectly the problem that transparency is seeking to address. There was in another trial where a reporter happened to be present, there was an internal affairs record disclosed, which showed that a BPD investigator decided not to sustain an excessive force complaint simply because, as the investigator said, there was no third-party witness to the complaint. But this was in a case where the complaint was from a third-party witness, not the victim of the excessive force, but a third-party witness who saw the incident from their window. And because there was no third party to that third party to corroborate further the events, that's why the complaint wasn't sustained. So again, you may believe that 90% of the complaints filed by members of the public are frivolous. I don't believe that. And I think the kinds of examples that I'm talking about make crystal clear that that assumption is completely unwarranted. But regardless of your assumption, let's have a debate about this based on facts. And the only way to get those facts is to remove the veil of secrecy from these records.
Thank you, Mr. Chairman.
All right, thank you, Senator Heddleman. Now, Senator Castley, do you still, I think you have questions? You're up next.
Thank you, Mr. Chairman. I got a question for Chief Morris, and I'll ask him not to use his time to just go on and, as some witnesses have, and just pontificate generally non-responsive to the question. If you could just answer the question and not lecture us that would be appreciated. Not that you've lectured us in the past, Chief Morris. You gave us examples of conduct that you, or allegations of misconduct, or actually sustained conduct that you think ought to be disclosed. Can you just, how long have you been a police officer for?
I've been a police officer for a little over 35 years. I did 26 years with Prince George's County, retired as a police commander, and I've been the chief of police in Riverdale Park for over 9 years now.
So if these, so you got a lot of experience. So if these files were disclosed, what kind of stuff would we see? What kind of misconduct allegations would we find in there that you think the public, I'm not asking you to reveal any specific persons, but you probably looked at, you've been involved in a lot of this stuff over your career. Just the kind of examples of misconduct allegations that you think the disclosure would not be in the public's interest generally.
Well, we hold our police officers to a high standard, and police officers are disciplined for all sorts of departmental violations. A police officer backs their car into a brick wall because they're not paying attention. The police officer is going to receive disciplinary action for it. Is that something that's of a significant interest to the community? I would suggest that it's not. Police officers are held to that same high standard regardless of whether they're on duty or off duty. In fact, I think it's fair to say that if you take a look at any police department general order manual rules or procedures, that there's a clause in every one of those that stipulate that officers are to represent themselves and their departments in a respectable way, regardless of their duty status. So officers that are involved in off-duty types of incidents that discredit the department or the profession would be held accountable. So an argument with your neighbor, and your neighbor knows that you're a police officer, so they file a complaint. And I'm not making these up. These are situations that I've encountered in my years as a police commander. A police officer that is arrested off duty for driving under the influence is subject to disciplinary action within the police department, in addition to the criminal sanctions that may follow depending upon the outcome of a criminal trial. So, but to the degree that officers are involved in uses of force that result in serious bodily injury or death, discharge of firearms, or those situations that go directly towards the integrity of the officer, we feel that those sustained findings, and in some cases the non-sustained findings, would be beneficial to the release of the community. So I think your question is, hopefully that answers your question, Senator. Equally important that we protect the reputations of the officers from frivolous types of complaints, which Mr. Schellenberger spoke to. And I know that this comes as a surprise to some folks, but sometimes people lie and they make things up. And then when we find that that's not the case, those cases are unfounded or non-sustained, and we need to protect the reputations of the officers from secondary dissemination, which of these types of reports.
So that's a buzzword I haven't heard before. Which you said secondary dissemination. What do you mean by that?
Once the files are released, we recognize that we can't control the secondary dissemination or dissemination beyond the parties and of interest that might receive those complaints. There's no way to control that. And I think it's fair to say with the social media that we have today, those investigations could be plastered on social media, and frankly, they could be altered as well. The findings could be altered before they're disseminated, and that brings harm to the reputation of good police officers that do this difficult job every day, and likewise endangers or poses a danger to their families as well. If you can imagine your friends or your not so friends reading something online about you that's completely false because information was disseminated in such a way that it's purported to be true. So that we can't control that secondary dissemination once the record is released.
Yeah, I mean, I sort of have this fear that I look at what we have now with the Maryland criminal record system, where I look at that, it tells me who's been charges filed against them, who's been indicted, who's been convicted. Then I compare that to Twitter and the basis allegations and the slime that goes on Twitter. I I think I share your concern that we're going to sort of Twitterize the whole allegations against police and police misconduct. Are there any? I mean, most of us have not been police officers. You know, a young police officer coming into the force. I'm sure you know, word gets around quick, but you know, if I was a young officer or a recruit or somebody coming in, and some of the maybe potential disclosures of everything personal in my life that might come out in the course of even just a 10-year career, are there any other examples you can share with us that you know, the kind of stuff that's like, wow, that's terrible from a police officer's perspective?
Well,
I'm really pushing your imagination here. I'm sorry.
That's a great question, and you know, I think sometimes we forget that our police officers are human beings, and we recruit from society, not from nowhere else. So when we recruit, while we try to narrow the gate for those individuals that we bring into this profession, and then put intervention programs in place that help to identify officers along the way so that we can salvage good careers from going astray when we notice that officers are engaged in behavior that's out of character for them. Again, I mentioned Senate Bill 74, which this committee heard yesterday, is a good police reform bill that would help those officers that find themselves subjected to the post-traumatic stress of years of exposure to some of the most inhumane situations that you can imagine. So we can't forget that we're dealing with human beings, and human beings make mistakes. We are not infallible. Police are not infallible. We want to identify those situations. We want to correct them either through discipline and or training or through mental health programs. But likewise, officers that they have family problems, they have problems with their children, they have they have their homes foreclosed upon, situations that their financial records could end up being exposed and becoming public. Their marital affairs could be exposed and become public. Officers have complaints filed against them for domestic violence that are ultimately proven to be untrue. Those files with a wholesale release would become public, and it places, it potentially harms the reputation of the officer, and again, the families as well.
And can you think of anybody else other than the police where their employees are subject to misconduct investigations for their off-duty time other than police officers?
Well, unless a member of the General Assembly is driving their authorized their government vehicle when they're engaged in some sort of misconduct, that might be something for which they perhaps would receive discipline. But then again, we wouldn't know because those records would be shielded from public view. But I think primarily police officers, perhaps correctional officers, those that are involved in that public safety arena would also be subject to investigations for off-duty misconduct. But by and large, I think it's fair to say that most employers aren't going to weigh in. They don't have a dog in the fight, so to speak.
And I see by your proposed amendments, Chief, that you're not opposed to disclosure regarding use of force resulting in serious bodily injury or death or sustained investigatory findings of complaints involving officer integrity. And I guess that's the sustained part that you're focused on there, right? That we want to not allow just sort of the prurient interest disclosure stuff of everything that's happened in this officer's personal life that might in some way possibly be considered a violation of the rules. You don't want that coming out. Is that right?
I think it's a fair statement. We're looking for something that's fair, balanced, neutral, middle of the road approach. Like Mr. Schellenberger said, that those sustained complaints are of significant interest to our community. And we want to be able, we as chiefs and sheriffs want to be able to communicate that to our communities. Right now, the law precludes us from doing it. So it gives the appearance of non-transparency simply because the law doesn't allow it. And in those cases that are of the most significant interest to our communities, those involving the use of force, particularly complaints of excessive force when they're sustained. And I think the important piece is once the department sustains the allegation, that's when we want to be able to discuss it. We don't want to have to wait for administrative hearings or adjudication in a courtroom. If we have enough evidence to support the sustained complaint, we're willing to have that conversation at that point.
Chief, do you think there's going to be I mean, if I'm one of your lower ranking officers and I'm going out to do an investigation, if I know it's going to be I mean, right now, I'm an investigator. You send me out to do an investigation. I want the chief to know all the facts. I want to know every single fact. So I'll put it in my report. I'll put a very thorough report. It'll go to you because I know as an investigator that it's just going to the chief. It's not going to be made public. I know I can tell the people that I'm investigating that, hey, this is confidentiality. You know, you're okay. Do you think there's going to be a chilling effect on investigators to fully disclose to the chief in their written reports all the nitty-gritty detail that might actually benefit the chief in effectively managing the department and in other people in confiding in the investigator if we just open all this stuff up as a matter of course?
I think, Senator, that the more chilling effect would be on witnesses to these types of incidents that may not want to cooperate with our investigators and offer the information that they may have that's relevant to the investigation for fear of the loss of anonymity that the investigation provides right now.
Okay. Thank you, Mr. Chairman. I appreciate it.
All right, thank you, Senator Castley and Chief Morris. I think we have another question. Senator Sidnor, do you still have? Here you go.
Thank you very much. And this is, I have two questions. One for Mr. Morris. With regards to the amendments and what we've been talking about, if we had maybe a Bull Connor or Sheriff Joe Arpaio, who was in charge of a police department, there have been complaints made against officers of his for what citizens viewed as being racism, yet for whatever reasons, I guess the officer's actions aligned with either of these individuals' beliefs, and the report was marked unsustained. Under your proposal, we would never see that. So these bad apples would be able to continue on in a department harassing the population. How do we get to something like that?
Senator, who'd you like to answer that question?
That was for Mr. Morris.
Got it.
Yeah, Senator, thanks for the question, and I have to admit I had a little difficulty hearing the first part of your question. But I think the importance of the early intervention systems, early warning systems, play a significant role in that. We've heard some testimony about the gun trace task force and the number of complaints. It comes down to command and control. It comes down to supervision. It comes down to policy. It comes down to process. Look, Senator, part of one of our amendments deals with the release of information when officers engage in prohibited discrimination that's directly related to the reporting, investigation, prosecution of a crime. So we have addressed that, but I think it also needs to be addressed in those early warning type programs that have been offered under other pieces of legislation.
All right. For Mr. Neil Franklin, I'm curious, do you have an opinion about the amendments from the Maryland Chiefs and Police Association?
Well, I do. I mean, I can name 12 states right off the top of my head that have already moved forward that allow once an investigation, most of them, once an investigation has been concluded, whether it's sustained or unfounded, that information is public. And none of these states, and we work with many of the chiefs in Ohio, in Arizona, in Florida. These are members of our organization, and they don't have issues of, lives being endangered, of this information going crazy on Twitter or Facebook or any other, internet networking platform. It's just not there. And I would suggest that those who are on this call, Chief Morris and others, reach out to some of those states and look at their laws and look at their policies of disclosure, and you'll see that these aren't issues. So instead of speculating, let's look at what other states have done and the successes that they've had and the improvements in police community relations that have occurred. So this isn't anything new. It's already been done, and more states are coming online as we sit here and talk because of the urgency of what's before us today. So, I mean, those are the facts. Those are the states that are out there. And I suggest that they do the research. It's there. The data's there. The information's there. It's not an issue. It's not a problem.
All right, thank you, Senator Sidnor. I'm going to move over to Senator Carter. I see you have a couple questions.
Thank you, Mr. Chair. So Chief Morris, actually, Colonel Franklin just sort of hit on what my questions were going to be, because in my testimony, I stated that our research indicates that at least 26 states disclose these records, and Colonel Franklin has shared a number of states that do. And while you have hypothetically suggested a parade of horribles, are you actually aware of any of the problems that you've brought out, your hypothetical problems that you foresee potentially, that have been the case in other states that actually do this, the majority of states that actually disclose these records?
So thank you, Senator. And we have looked at some of the other states, in particular New Orleans. And I think when you look at what they actually release, they're not a wholesale release of all of the records. The records are data driven. So I think if we're going to talk about what other states are doing, we actually have to take a look and see what they are releasing versus what they are not releasing. And I'm not going to continue to speak to anecdotal information. I'll stick to the facts and state that in 35 plus years, I've seen some of these horribles associated that I have mentioned as it relates to investigations, and that's without the wholesale release of these investigative records. So I think that we can learn from other states, but I think Maryland has a chance to do it right and get it better than other states, because I think Maryland's better than other states.
So that's something that we can agree on. So I wanted to speak to your contention that we should severely limit what is disclosable to cases where there's death or serious bodily injury, or cases where the complaints are just sustained. And I don't know if you heard my testimony that research reveals that about 92% of complaints that are made are never sustained, and that the devil, all of the abuse and all of the ugliness, is actually in that large body of unsustained complaints, because so many law enforcement agencies, when they conduct these investigations in secret, they don't have to disclose any of it. And so that's why so many complaints go unsustained. We're talking about actual horribles, not just potential horribles, such as the situation with William Green, where his life would likely have been saved had the law enforcement agency not been allowed to ignore the complaints in secrecy and actually be possibly propelled to sustain complaints because they were disclosable. And so my question to you is, when you're talking about actual human lives that we've lost, I mentioned 31 in 2018 across Maryland. The ACLU has a report that talks about upwards of 130 total. I am not certain what the floor of that is. So outside of George Floyd, which didn't happen here, Maryland has its real problems. I am curious to know, I'm getting to my question. Why, given the fact that so many complaints are unsustained, given the fact that the largest number of complaints are on the subject of harassment, followed by false imprisonment and arrest, and followed by excessive force, why you would want to limit the complaints to that tiny, minuscule number of complaint allegations when the larger number of complaints that affects the most people doesn't fall into that small category.
Senator, I want to put your mind at ease because I'll refer to our position paper, and we want to emphasize that in those complaints involving the discharge of a firearm involving a law enforcement officer and use of force that result in death or serious bodily injury, that we are in support of releasing both sustained and non-sustained complaints and no longer subjecting them to mandatory denial.
Thank you. That covers some of them, but not everything that I just mentioned, like the false arrest, false imprisonment, and harassment. But then finally, I think this is my final question. So the actual language of the bill makes it clear that there are some records that the custodian of records would not disclose even under this bill. And that would be instances where it's determined that disclosure would interfere with a valid and proper law enforcement proceeding. So you and I think Mr. Schellenberger's contention that this would just, come and just pollute someone's opportunity to have a fair trial. I think this is, would you agree that this is covered here? That is not, this bill does not permit that to just happen in a way that's very frivolous and allow anyone to do that.
I would suggest that Mr. Schellenberger more intelligently and articulated the argument there. So I would defer to his response on this from the state's attorney's perspective.
Thank you, Chief. Senator Carter, to answer your question, the interfere with a valid and proper law enforcement proceeding, the way I interpret that is, if I'm in a courtroom, the investigation is over. So I wouldn't be able to use that one. So that's where my concern is that we're pending a criminal case. It's a week before that detective is going to take the witness stand, and now an allegation has been made. And actually, I can't compress the time that much. An allegation has been made, and the investigation is over, and I'm in court, then I can't use B1 on page 3 because the investigation is over. That's what my concern is. It's not depriving the defendant of a fair trial. It's going to be hurting my witness. And that's why I wanted to delimit it to sustained findings. But I will join whatever the chiefs and sheriffs join with regard to those other things. I don't want to go any further than they do. And so, that I will stick with them on where they draw the line on which ones are just files and which ones are sustained.
So even with this bill, and I'm not sure I agree that this wouldn't cover those situations that you talk about, but even with this bill, there's still a standard by which the court determines whether or not something is disclosable, and prior allegations or bad acts are not just automatically disclosable. In fact, defense attorneys quite often have a great difficult time attempting to get access to that information for trials. And so do you not see that as another bar or another protection on what you're concerned about?
No, you are absolutely correct. I can walk into a courtroom, file a motion in limine, and say, Senator Carter can't use this. and a judge can say yes. That doesn't stop it from being on the news at 6 o'clock the night before the jury is selected. And that's where I'm concerned, is that it could potentially affect the jurors. But you are correct in your statement of the law.
Well, I would just say that, in those cases, we have some protections there too. One, we have a process of voir dire that we respect and that tends to work, and maybe it'll be extended. And we also have something called a change of venue for those situations where you can't get a clean jury pool. So I don't think that in and of itself is an issue. And then finally, I think regarding what you and possibly the chief said also, this concept that, any old frivolous allegation could be brought up because someone is facing trial or facing scrutiny. And I would just suggest that the law kind of covers that as well, because they're making false allegations is also a criminal offense, as well as protected by potential civil litigation, correct?
Correct.
But Senator, I will say that that tactic is used more frequently than what you might think. And at least in Prince George's County, it has been a practice not to prosecute individuals who knowingly make false statements and complaints about police officers, because the concern is that it would have a chilling effect on those making legitimate complaints. And so we try to find that balance. But it doesn't preclude individuals from making complaints against officers, frivolous complaints against police officers, and we see that with an increasing frequency.
And that's fairly standard across the state, if I might add.
Thank you.
All right. Thank you, Senator Carter. Senator Castley has another question.
Just please for a second, just a follow-up to Neil Franklin. And during the break, since your last testimony, I did take an opportunity to do some quick legal research, and I'm not, for specifically on Ohio, which you referenced, and I don't find that their statute is that far different from what our current one is. I mean, it's different wording, but I don't see this wholesale open up the personnel file of police allegations of police officers. There's lots of protections in there. And in fact, they have to first serve an officer personally with a request, and he gets an opportunity to object, and then it has to go into court. And there's all kind of restrictions and limitations on what can come out. So I just don't see this, I didn't have a chance to look at Arizona and Florida yet, but I just question whether any states are going to this wholesale, hey, anything about cops, flood the record, flood the zone. And some people have said Maryland wants to be in the lead. But sometimes if you're in the lead, maybe it's because you're the only one going that way, and that's nobody else is around you. There may be a mistake there, but maybe somebody can provide us with the actual statutes from some of these other states that are been so successful in just airing officers' dirty laundry across the nation that you believe is sort of this, panacea for anything that ails us in the framework, in the nature of police misconduct. Because just a limited time, I didn't find that testimony bolstered by the actual laws.
Well, and I actually wasn't portraying that it's just willy-nilly anybody's information is out there. Just like with this legislation that's being heard today, as Senator Carter referenced, there are things in place to limit and protect what can be disseminated.
Well, there were, but there wouldn't be under this.
But of course, every state has its own separate statutes. So I was just naming some states that do have processes in place where this information can be disseminated. Some is still more restrictive than others. But yes, I mean, there's a number of states that, some of which I didn't mention, Washington State, and I think we can get those pieces of legislation to you. Maine, Connecticut, Florida, Georgia, Alabama, Utah, and more. And yes, you're going to find differences, but there are processes in place much better than what we have here in Maryland. And again, this piece of legislation here does have those things in place that restrict the dissemination of certain pieces of information. So yes, you're going to find some differences. I'm just saying.
I'm always open to doing things better, and I'm not wedded to a particular Maryland process. So if you have better processes that you think are more efficient and more fair, I'd be delighted for one to take a look at them. Are you paid, or this is a volunteer you're doing on your own time?
This is all volunteer for me now. I used to get paid. I don't get paid anymore. I'm just a member of the board for the Law Enforcement Action Partnership now, but so it's all volunteer.
Well, I'd be delighted to take a look at model statutes in this area. I'm not pretending that our existing one is the be all and end all when it comes to personnel records. But I do think we, like most other states, from what I'm seeing, have an interest in providing some level of non-disclosure here and keeping some, disclosure within certain parameters. I do like what the chiefs have proposed. I think that's a great accommodation. I think that will go a long way in meeting the objectives here, but I certainly don't want to pretend that that's the only one. So please send away. I'd be love to take a look at it. And thank you for your testimony. Thank you, Mr. Chairman. I appreciate it.
Thank you, Senator Castley. And Senator Carter informs us that she does have the statutes and she can disseminate them to the committee. So we'll make sure that everyone gets them. Mr. Roca, you looked like you wanted to chime in. Was it responsive to Senator Castley's kind of line of inquiry? Go ahead. I think you're unmuted.
Thank you. So Senator Castley, with respect to Ohio, it's not a specific statutory provision, but a court decision, State X-Rail Dispatch Printing Company versus City of Columbus from 2000, saying that there was no question that the requested police disciplinary records were public records under that state's statutory definition of a public record, which is just a broad definition of public record. So it's not that there's a specific statutory provision there related to these particular kinds of records. There's a court decision saying that the disciplinary record was a public record that could be disclosed. But if you want to look at specific statutes, you could look at what New York State did last year, which was to mandate, not just permit as the bill that's before you now, but to actually mandate disclosure of all police disciplinary records with the exception of so-called technical infractions. And so technical infractions were defined as a minor rule violation by a person employed by a law enforcement agency, solely related to the enforcement of administrative departmental rules that A, do not involve interactions with members of the public, B, are not of public concern, and C, are not otherwise connected to such persons' investigative, enforcement, training, supervision, or reporting responsibilities. So in New York, it's mandated disclosure if it's not a technical infraction, with some exceptions for specific information, like some of the things that have been.
Look, I mean, and I appreciate your additional information, but look, there is an Ohio statute. I just finished reading it, and certainly that's supplemented by Ohio common law, and certainly New York has certain statutes. The thing is, we got to look at these ourselves. I'm not willing to trust your interpretation of the statutory scheme. No disrespect intended, but these are all complicated and they're in different areas. And yeah, Maryland provides certain disclosures in some part, but others in others. And you can't just read any little piece of the law in isolation from the others. You got to look at the entire statutory scheme. So rather than us debate here what somebody thinks that some law from some of the 50 states might think is that law's disclosure requirement, I think it'd be better if we just share the information we've got on what those actual statutes are. We can read them and see. I think it'd be much more effective. Thank you, Mr. Chairman.
All right, thank you, Senator Castley. Well, Mr. Roca, since you're unmuted, if I don't see any other questions from the panel here from the Senate, no more questions. So I've got a couple questions then, and Mr. Roca, since you're unmuted, I'll just ask you. And I think there's somewhat of a misconception with Senator Carter's proposal that this is kind of an automatic disclosure and that it's kind of unfettered access. And so, I mean, with the scheme that's set up here is really more of a permissive disclosure. And there are several kind of tests that you have to run through as a battery. So, I mean, I'm really just talking about simple on page 3, just lines 18 through 27. And this is really the core as to why I thought this is a more than reasonable approach. And I'm sensitive and I definitely appreciate the concerns about third-party access, and there are also another layer of complication with sustained and unsustained, which I'll ask you about in a second. But I do want to just shed more light on, if you could just walk us through. So who is the custodian of the records? what is that process? And then, the 7-part criterion that's laid out. Just can you walk us through that? Because I think there's a misconception that this is kind of an automatic disclosure, that information is just automatically going to be pushed out to the public. And so since you're unmuted, I'll ask you.
Thank you, Mr. Chairman. And yes, you're correct. In a lot of the discussion today, there's been either an explicit or implicit assumption or assertion that the bill before you mandates disclosure and simply throws all these records open. And that's simply false. I mean, it's just not true. As I said in my testimony, and as Senator Carter said in her testimony, what this bill does is moves these records from the category of cannot disclose. So in that respect, Senator Casserly is also incorrect that Maryland law currently permits some disclosure. It doesn't. It permits zero disclosure. It moves the records that we're talking about, that is records of police departments' investigations, into allegations of police misconduct by a police officer, from the category of personnel records, which simply cannot be disclosed, period, no ifs, ands, or buts, no going to court, no nothing, to the category of investigative records, which are not mandatory disclosures, but which are permissive denials. And the standard for denying access to such a record is whether the disclosure would or would not be in the public interest. That's a very broad standard. And there are specific reasons, but again, as I said, what that means is that if you're going to deny access to the record, you got to actually have a reason, and you have to be able to justify it. And if the person requesting the record thinks it's not a valid reason, or it's being asserted in bad faith, or it's doesn't apply, or whatever, then they could challenge it, and a judge decides. And there are the statute goes further in actually enumerating reasons that are presumptively valid, that the statute itself says are valid reasons. And those have been talked about over and over again now today. Interfering with a law enforcement proceeding, depriving a person of a right to a fair trial, constituting an unwarranted invasion of privacy, disclosing the identity of a confidential source, disclosing a confidential investigative technique or procedure, prejudicing an investigation. And that last one is essentially carte blanche to departments to deny access to the records while the investigation is ongoing. That's what happens now. And let me just say this more generally. All of these standards that we're talking about, these are the standards that already, currently, right now, and for decades have applied to all of the police department investigatory records about you, me, every person on this call, and every other person in Maryland. And all of these problems that are being asserted will happen if the records about investigations into police become disclosable under the same standards. All these problems that will supposedly occur, none of these problems have occurred with respect to the records that police departments have about you, me, and everyone else. They just haven't. It's not a problem. These have been the standards for decades.
Got it.
And then I think you asked me, sorry, who was the custodian of records?
Exactly right. And then I've got a couple, I see Mr. Schellenberg wants to chime in, but I'm going to ask you one more question because I think it relates to Scott's previous testimony. So I'll ask that as well. But go ahead and talk about the custodian of records, and then I'll ask you.
So the custodian of record is, in reality, it's the department, but in terms of the way the law works and sort of practicalities, every police department has to designate someone to be the actual human being who is the custodian of records. And that varies from department to department, but every department has a custodian, and that person is the one who is responsible for making the decision with advice from counsel if necessary. They may have a whole staff in larger departments. They're the ones who make the decision about what will and will not be disclosed. Just as they do now when people request records related to criminal investigations into you, me, and everyone else.
And then you touched on this before, Mr. Schellenberger also addressed this as well, but I want to just dig a little deeper on and I think Senator Carter even spoke to this, but just the sustained vice, unsustained, what is, she tossed out a couple of numbers and, it's in her testimony, but I don't remember them off the top of my head, but can you tease out the problems for if you're only going to do the sustained complaints, making those, permissible or disclosable, not personnel records. Can you explain just the problems? Can you dig a little deeper with that? Because I think it's important.
Yeah, so let me just also sort of begin by noting that the chief's proposal doesn't even disclose sustained complaints for all complaints. It only discloses sustained complaints for a tiny, narrow category of complaints. And when Chief Stawinski testified last year, he acknowledged that it would apply to only 14 cases in his department. I've talked about some of the figures from Baltimore City, where 92% of the complaints filed by members of the public are not sustained. If you go to the chief's proposal, somewhere between 2 and 7% of the total number of complaints investigated would be disclosable under the chief's proposal. So this idea of disclosing only sustained complaints, which the chief's proposal doesn't do even that, but even if we did that, that's not transparency, it's transparency theater, and it's simply a public relations exercise for chiefs. They want to be able to brag about the officers that they found accountable. Fine, I'm all in favor of that, and we applaud those successes. But if there are problems in the police accountability system, and I think there are, and they're deep and they're widespread, and I talked about that in some detail today, the problems that exist don't exist with respect to the cases where officers have been held accountable. They exist with the cases where they haven't, where the complaints have not been sustained. Those are the records that need to be disclosed in order for us to be able to have an accurate picture of what is and isn't being done. And on this idea that it's somehow unfair to the officer to disclose records if the complaint wasn't sustained, I would say that if the investigation shows that the officer didn't do something or that the act complained of wasn't a violation, then disclosing that helps the public understand the truth and exonerates the officer and shows that the department was doing what it should. And those are all good things. And as to this idea that, and if the complaint was a frivolous complaint against the officer, then having an investigation that shows that is better than leaving the frivolous allegation out there unrebutted.
So that leads me to my second level of questioning is just that when the secondary dissemination issue, but then also the tactical complaints that I want, Scott, don't worry, we're coming to you next. But the tactical, filing of the complaints, can you just speak to that? Because I mean, that's, I'm sensitive to that. I think we all are.
Yeah. I mean, with all due respect to my friend Scott Schellenberger, I think he should know better. And I think this was sort of alluded to in the discussion that he had with Senator Carter. As he knows, it is extraordinarily difficult to get prior bad acts evidence regarding a witness introduced into a trial. And if it is going to be introduced, it generally has to relate to their credibility. And if it's going to be introduced, there has to be evidence that the prior bad act occurred. And a complaint is not evidence. So the complaint itself is not what's going to be introduced. And if the complainant testifies, then it doesn't matter whether there was a complaint or not, because it's the independent testimony of the complainant that matters, not the fact that a complaint was filed. And if the concern is that the complainant will say something publicly about their complaint, they can do that whether the complaint is filed or not, disclosed or not, and the existence or non-existence of the complaint is completely irrelevant to this whole discussion. And again, as I said, if the complaint is really frivolous, then isn't it better to be able to show why that's the case rather than just saying, trust us?
This has been helpful. Thank you for this. Okay, Mr. Schellenberger, you're up.
Thank you so much. And we really aren't so far apart at this point. So my concern is, and Mr. Roca did explain the process perfectly. You may actually even put in there, they do a PIA request. So in my example of someone saying Officer Schellenberger lied in a police report in which he got me arrested, and Officer Schellenberger is a main witness in an upcoming homicide trial, okay? And all that's been done is the complaint of lying has been filed. None of these seven get me to block it. It's not interfering with a law enforcement proceeding because, you know, the investigation may be done. It's not depriving someone of a fair trial. They're going after a witness. It's not an invasion of privacy because they're just going to put the officer up there lying. They're not putting his home address up there. So we're getting close, but nobody has fixed my problem. And there's a difference between the complainant going on WJZ tonight at 6 o'clock and the PIA request in which somebody gets to hold up a police file and say the police have a file on this lying complaint. That can affect, and Mr. Roca and Senator Carter are right. I can say to the judge, it's inadmissible, and I will concede I'm going to win that 9 times out of 10, and David, maybe 99 times out of 100. So, I mean, I'm going to win that. But what I'm worried about is the effect on the citizens' opinion about that officer. So we're close, but that's the only place that hasn't gotten addressed yet. And I will stop talking no matter what happens.
No, I hear you. I appreciate it. Okay, well, we can go back and forth for a long time. I suspect this is not the end of this conversation, but yeah, I get it. Not sure we agree here, but all right. I do have one last question for Mr. Love. I see you're here. You made a comment that kind of stuck out to me. Kind of the nexus between this type of transparency and public safety. Obviously, we've had discussions on the floor for VIP funding. We've talked about gun legislation. We've kind of taken a multifaceted approach to increasing the security proposition for the city and for the state at large. And so I guess my question is, you said that there's a direct nexus between this type of transparency and public safety. I was just interested if you could expound upon that.
Yeah, so just a couple of things on that. The first is that there's now an abundance of evidence that many of the incidences of brutality and misconduct that civilians have experienced exist in the unsustained portion of the complaints. And I think it's important that those of us that support this bill have made the most compelling case that exists, and there's ample evidence, right, of many. I read an example from the DOJ report. If you read the Restoring Trust and Policing Commission's report, it gives ample examples of unsustained complaints that objectively most people would have characterized those as examples of abuse. And so I think then the people who are most familiar with that are those who have experienced those kinds of abuses. And they're not the proper mechanisms to expose to the public and to the community the fact that those forms of abuse exist. In the Restoring Trust and Policing Commission report, that I think is a very good report and I encourage people to read, one of the things it does is that many of the studies that it cites about the community's position on these issues of policy, one of the things that it says is that many of the respondents, a majority of them, had either positive or neutral beliefs of police officers in general. So these aren't people who are ideologically anti-police, right? The respondents, these aren't people who, who are desiring to slander police officers. The respondents in the studies that this report cites are folks that generally have favorable views of police. But among those that have favorable views of police, and again, I'll cite it specifically, that 52% of those surveyed thought that police officers were disrespectful in their interaction with people in the neighborhood, and that 68% of them reported seeing officers use excessive force that they felt was unwarranted. So even among those who have favorable beliefs in police officers in general, believe that police officers are untrustworthy in the trust that is necessary to be able to get folks to go to the witness stand. Because those of us that are interested in police accountability are also interested in dealing with the issue of violence and homicide in places of Baltimore City and around the state. But if you don't have the ability for the community to trust law enforcement, then it impairs the ability for community to cooperate in the ways necessary. And in fact, again, this report that is a legislatively commissioned report, it states that its respondents said that the kinds of reforms that this bill would advocate for would increase their trust in the police department. And so I just think it's important that that's something that is emphasized, because I think from the perspective of prosecutors, they see this as potentially an impediment to them getting convictions on folks that are causing homicide. And it's actually my belief that actually it's the community that is going to be the greatest resource in being able to address the issue of homicide, and that this is a step forward in creating the trust necessary to give the kind of cooperation that would actually address public safety.
No, I appreciate that. This is helpful, and I've got some additional homework to read the report, so I appreciate that. Definitely, Mr. Schellenberger and Mr. Rocco, we definitely get the conversation continues. Definitely want to speak to both of you afterwards, but I really do appreciate the dialogue, and so I appreciate it. Mr. Hansel, let me do this real quick. Senator Castley has a question. I want to make sure we get to Senator Castley, and I don't see no other committee members have hands up. So Senator Castley, let's go to you, and then Mr. Hansel.
Yeah, thank you, Mr. Chairman. So look, this has really been interesting dialogue, and I share the chairman's appreciation for the dialogue, and kind of at the end of the day, I think there's widespread support for measures that increase both police accountability, but also public confidence in the system. And I realize this, and I think Senator Carter is putting this forth in that vein to increase police accountability and public confidence in the system. The challenge I have is, I guess, sort of the bigger theoretical question is it really, is this a standalone, or can we make compromises on total, open the kimono, show everything, and recognize that this is just a piece of it, that we're going down the direction of increased police transparency for the sake of public confidence and for actual accountability, but recognizing that when you open this stuff, it's not just about the result is not just enhanced, even at best case, it's not just about enhanced police accountability. There are the negative aspects of that. And I look at the 7 criteria that are in the bill for even once you take it out of personnel records. Police officers, unlike anybody else in society, has in the public record a lot of personal stuff about their marriage, their driving habits, their all kind of stuff, because as was stated, those are matters of policing. You're 24/7. Even when you're off the dime, you're still on. And so police officers are under that intense scrutiny. And aren't there compromises that we can make? Because honestly, I appreciate where Senator Carter is going, but I think we also have to be careful of the law of unintended consequences. We open up too much, and then we find that young people don't want to come in this profession anymore, and police officers are depressed and miserable. So I would just appreciate here, I would like to see these other models, laws from the other jurisdictions as to what they're doing, not necessarily their models, but other opportunities, because I really think there's got to be some give and take on this, Mr. Chairman, on allowing openness. And I see the police, the chiefs and sheriffs have moved in that direction, and I like that. But I think there's got to be movement from the other side to recognize that their concerns are legitimate, that the police and chiefs' concerns in not embarrassing officers and not driving people from the force are legitimate, and that most police records don't relate to police are not matters that the public would find of general use in trying to combat lack of confidence in policing or police misconduct. So if we can try to move closer, I think we can achieve a decent bill. It wasn't really a question, but I just more of just a sense of where I hope we can go with this. So thank you, Mr. Chairman.
Of course, yeah, you're probably. Mr. Hansel, you had something responsive to the question.
Thank you, Mr. Chairman. I wanted to underscore the need to disclose unsustained charges. I've been a civil rights lawyer in Maryland for 20 years. I've had dozens of cases of constitutional violations. I have had many jury verdicts where a jury of our fellow citizens have found against the officer that our constitutional rights were violated, and then it was affirmed in post-trial motions by a judge, and very often upheld on appeal. So in those cases, it's many times the case that between motions practice and appeal, 4, 5, 6, 8, 10, 12, even when we go to the Court of Appeals, judges have passed on and found unconstitutional the misconduct of the officer, in addition to a jury of our fellow citizens. In only one of those cases over 20 years that I can think of sitting here today, where there's sustained findings on the part of an internal affairs investigation. What that tells me from my experience and that of the people I'm honored to represent is that there is an enormous gap between the findings of an internal affairs investigation and the misconduct that the citizens of our state who serve on juries and judges at every level have found in the cases that I've handled. And because of that, I think it's critically important that unsustained findings be made subject to this statute, which, as has been pointed out, does not release them wholesale, but includes the officer's privacy and other reasons to withhold them. But I think it's critically important that they be made available. My experience demonstrates that either the police are failing at policing themselves because juries and judges have found otherwise, or that there is more information needed in the public to build public trust that police are correctly policing themselves. Either way, this information is critical to permit to be disclosed under the very narrow definitions under this statute. And once the information runs the 7-part gauntlet for disclosure, but it's just completely critical and important to permit unsustained charges to be disclosed because the police are not reaching the same conclusions as judges and juries in Maryland. Thank you.
I appreciate that. Thank you. All right. So with that, I see no further questions from the senators from the panel here. That concludes the testimony and the hearing for Senate Bill 178. We now have Senator Carter up next again for Senate Bill 276. Senator Carter, the floor is yours.
Thank you again, Chairman Smith, and all members of our committee. Thank you for your patience and for taking time to hear this bill. I recognize that there may not be a tremendous appetite amongst some committee members to consider this bill, given the fact that in 2019, this committee voted overwhelmingly, as did the Senate, to pass the law that gave Johns Hopkins University the ability to create a private police force. However, because we are at a time where we are reevaluating policing across the state, we are reevaluating the ways that police should function, we are reevaluating accountability and transparency, I think it is time to also take a look once again at the law that we passed that allows Hopkins to create a private police force. I think so because one, in June of 2020, Hopkins itself released a statement saying that they decided to put the creation of this police force on pause, given the climate in the country and the fact that it was not the appropriate time to move forward now. But I think that it should not have required Hopkins to see the national protest in response to George Floyd to come to that conclusion, given the fact that they've had staff, residents, students overwhelmingly not in support of the police force to begin with. And so this last year, we've taken a hard look at the relationship between policing and race. Baltimore City has had to look at that relationship time and time again. Hopkins has a record of exploiting generations of persons of color in the city and the university's namesake. Johns Hopkins himself was a slave owner. Ultimately, in considering the benefit of a Hopkins police force, the community neither overwhelmingly wants this policing, and I don't posit that every single member of the community is against this police force, but I do posit that overwhelmingly we have heard from residents, staff, students, faculty that overwhelmingly don't want the police force. Generally, when we hear those that are in favor of the police force, it is usually some generalized belief that because of a high crime rate, it's only a common sense measure that we would expand policing. And if Johns Hopkins, a private police entity, so wants a police force, then why would we not give it to them? Even though we ignore by that argument for why we should just generally give them a police force if they want it, the fact that it is the privacy of that policing that is an issue, that it makes this police force that has the power under the law that we passed to police with outside of the bounds of the campus of Hopkins, but onto the streets that are adjacent to this campus, that is the public. And we are allowing these private police to have some jurisdiction over the public, over public areas in Baltimore City. I think also when we talk about, this outrageous amount of crime that some people do like to, highlight in Baltimore City, we don't take into account that the actual bill that we passed was very limited insofar as the Johns Hopkins private police force only had jurisdiction over 3 minor areas: theft, burglary, and motor vehicle taking. And so the really awful crimes that we're very concerned about, they didn't have jurisdiction under the law that we passed over those crimes anyway. And so some numbers that I'd like to highlight just for our consideration. Many of us know that when we walked out of that session, we walked out to an entire summer of students that staged a massive sit-in in response to their opposition, or to highlight their opposition to this bill. In 2019, before Hopkins finalized plans to create the police force, the Hopkins community and nearby neighborhoods organized to oppose the creation. Over 100 professors at Hopkins spoke out against creating the police force, and a student referendum indicated that 75% of the student body opposed it as well. Members of the student community led a month-long sit-in on the Hopkins campus to oppose creating the police force, which ultimately culminated in the Baltimore Police Department physically removing students from their protest. While Hopkins moved forward with plans to create the police department, the community still stands against it. In June 2020, community members from neighborhoods surrounding Hopkins started a petition against the creation of the private police force and amassed over 6,000 signatures within 3 weeks. Due to our restraints on public testimony, we are severely limited in the number of the public, members of the public, stakeholders, residents, neighbors, students, faculty that would be here to testify in opposition. But if you look at the written testimony that we've received, you'll see that overwhelmingly the testimony is in favor of this bill and in favor of repealing this private police force. The student body at Hopkins continues to organize their opposition, with 24 student groups signing on to the community petition as well. Since the summer, at least 382 professors at Johns Hopkins has publicly called for the cancellation of plans to create the Johns Hopkins private police force. The area where Hopkins police would be deployed is already very heavily policed, including over 1,000 security personnel that work for Hopkins. These security personnel also include off-duty officers from the Baltimore City Police Department. Additionally, the Hopkins administration has indicated that there is no truly pressing need for this police department when it delayed its implementation for at least 2 years. Now, the Baltimore City delegation has not had an opportunity yet to take up this bill as a delegation because it was pre-filed and we were so early in session. And so I do understand that our delegation will have an impact as to how they weigh in on this, but I can't tell you that they will fully support it, but I can tell you that, you know, the sentiments have changed somewhat amongst some of our delegation members since 2019. With that, I would love to pause and have you hear from the witnesses who are actually better testifiers than I am, because they're actual stakeholders whose lives are directly impacted from this law. And finally, I want to say that my legislation today would repeal the creation of the private police force. It would specifically not repeal any of the grant funding that would be made available to community groups under the original bill. And I think that's very important because it's always been my position that Hopkins didn't need to use having a police force as a carrot to implement or to provide the funding resources that were under the bill. If they so wanted to do that, provide seed money for organizations and other things they can do it without having the attachment or the condition of a private police force. And so with that, I will pause, listen to the panel, and be happy to answer any questions that committee members have. Thank you.
All right, thank you very much, Senator Carter. And with that, we'll move on to your panel. And first up, we have Mr. Hasek. Ethan, how are you?
I'm doing well. Thank you, Chair Smith. And thank you to Senator Carter and the whole committee for the opportunity to testify today. My name is Ethan Hasek. I'm a resident of Baltimore City District 43, and I'm a strong supporter of Senate Bill 276. I'm here representing my synagogue, Hinenu, which has more than 200 members and meets across the street from the Hopkins Homewood campus. I live in Charles Village, and approximately a third of our member households are in the neighborhood surrounding the Hopkins Homewood campus. We're a Jewish community that includes Black people and people of color, queer and trans people, and disabled folks. Just over 2 weeks ago, we watched as a white nationalist mob wrought havoc at the United States Capitol while police stood by. Not only do we believe that police do not keep us safe in moments of crisis, but we fear for our most marginalized members being the targets of police violence. This is why we have consistently rejected offers of police protection and instead sought safety and solidarity through relationships with our interfaith neighbors. We believe that everyone in Baltimore deserves safety from all forms of violence. That's a given. However, we see the Hopkins Police Department not as a public safety effort, but rather as an attempt to build even higher walls around a powerful institution. We have no interest in being part of this fortress, for it would endanger us and alienate us from the neighbors who love us and who keep us safe. Our community urges a favorable report from the committee. Thank you very much.
Thank you for your testimony. Next, we have is Dr. Gomez here? I see you there. All right.
Great. Hello, everyone.
Hi, how are you?
Can everybody hear me okay?
We can.
Great, wonderful. Good afternoon, Senator Carter, Chair, other senators, and the community, my colleagues. It's a joy and a responsibility for me to be here with you, and I thank you for this opportunity. I support overwhelmingly Senate Bill 276. I want to have a quote here. Giving an intoxicated person the keys to a car is contrary to the safety of all those in their path and to themselves. This is analogous to allowing the Johns Hopkins institutions to having police powers. So why do I say this? The Johns Hopkins conglomerate or institution's reputation is one that it exploits its neighbor to make itself rich in power and fame while throwing crumbs to them and separating themselves from their neighbors. This is well known in Baltimore and beyond. So how can we trust such an entity with police powers? I will show that there's a history, a pattern over time that makes me bring that quote into question. For them, we should not allow them any more powers because they could cause real damage. I also want to preface here that this type of institutional oppression of low-income and Black people is not special to Johns Hopkins, to Baltimore, or nation. It is unfortunately the norm. It's why white nationalists were invited in and allowed to insurrect on the nation's capital 2 weeks ago. The Johns Hopkins conglomerates or institutions' power has existed since the 1890s, when its founder, philanthropic Johns Hopkins, who made his wealth from railroad owning pieces. His wealth was accumulated then, and he became a philanthropist. His first purchase was the land that then the Baltimore City Mental Hospital sat on. It was a square block, a little less than a square block. It purchased this land from the city for less than the market rate. Fast forward to the 1980s, when it again purchased city land, then what was known as the City Hospital of Baltimore, what is known now as Baltimore Bayview Campus. Again, it purchased this land at below market rate. These two hospitals, along with its recently acquired Howard County Hospital, has ranked the third highest of the 17 Maryland hospitals in profit margin over the years, consistently. This powerful and profitable institution has benefited from strong public-private partnerships. While its tax-exempt status dictates that it provides charitable care in return, its growth in profit over the years coincides with a decrease in charitable care. Researchers within its own walls has challenged this. Quote, "The system is broken when nonprofit hospitals are raking in such high profits. The most profitable hospitals should either lower their prices or put those profits into other services within the community." Its history around urban renewal and displacement of families is renowned. Over the years, it has continuously expanded into its neighbor's home in East Baltimore, displacing families one row house at a time or in large land takings. For example, in the 1950s, when more than 1,000 resident households were displaced for a 59-acre expansion. Similarly, urban renewal style displacement in 2001, when more than 750 Black families were displaced for development of its biotech park. In the 1950s project, no return of residents were allowed. In the 2001 project, approximately 35 to 40 residents of the 750 displaced households have returned. In 2015, the Johns Hopkins conglomerate earned the reputation, quote, "the best example of what gentrification looks like," end quote, because of its displacement of more than 750 households. This was in the city paper. The university's process of accumulating power does not begin or end with this kind of uneven community development. In 2016, it boasted the highest funding from the federal government for research dollars, more than $2 million US, almost 90% of its research budget. With such power comes responsibility. Instead, the institution has been suing its low-income Black neighbors for medical debt while having no systematic process for informing them about the opportunity for them to receive charitable care when they seek care at their institution. Thus, they accumulate debt. Over the years, its responsibility to the human rights of its research subjects has been consistently lacking. Its history of doing exploitive research in its low-income Black neighbors right in East Baltimore became national news with the story of Henrietta Lacks. In the 1950s, Miss Lacks, then a resident of East Baltimore, was a patient at the hospital. Her cells were used without her knowledge or her family's knowledge for research purposes. It was only until the public outcry of such behavior has Hopkins come to terms with that and now looking to see how to compensate the family. Johns Hopkins' more recent history since the 1990s, this kind of research.
Time.
Thank you, Dr. Gomez. Just briefly conclude. Your time's expired.
Okay, thank you so much. What I want to end here with is that to say that poverty and fragmentation exists around the campus is true. To deny that the institution participated in creating this poverty and fragmentation is false. Because of this history of fragmentation, discrimination, it's created what it calls the same safety threat that it's trying to police away now with a police force. First it was with displacement, now it's with policing. And so this kind of continued exploitation of its neighbors, particularly Black and brown people who have a lot of questions about the institution's behavior, bringing policing into this kind of mix, it would not be a good thing. It would be a very unhealthy thing. And
Thank you very much, Dr. Gomez. Thank you.
We can do better. Thank you.
Thank you very much for your testimony. All right, so next we have, Ikenchukwu Imo.
Good afternoon, Chair Smith, Senator Carter. Can you all hear me?
We can, yes.
Great, thank you. I wanted to thank you for the opportunity to speak on this important bill this afternoon. My name is Ike Enemo. I'm currently a second-year medical student at the Johns Hopkins School of Medicine, a member of the Student National Medical Association, as well as an alumnus of the Johns Hopkins University. Today, I'm speaking on behalf of the Coalition Against Policing by Hopkins and on behalf of the residents of the Middle East community who deserve but do not have this platform today. As a longtime member of the Hopkins community, a resident of Baltimore City's 12th District, a future healthcare provider, and an active member of the Baltimore Redevelopment Action Coalition for Empowerment, better known as BRACE, I strongly urge you to support Senate Bill 276 for the following reasons. First and foremost, as has already been mentioned, the area the private police is set to be initially deployed, the Middle East neighborhood, is already heavily policed and maintains a prominent Hopkins security guard presence. The reasoning behind why patrolling is set to begin in this neighborhood first has yet to be clarified to Middle East residents and represents only a glimpse of the transparency that Hopkins has failed to display in this process. Secondly, over 6,000 community members stated opposition to the police force in a widely circulated petition, which has still not been acknowledged by Hopkins administration. We struggle to expect the accountability of a future JHUPD if its administration currently does not demonstrate the accountability to deeply listen to or acknowledge community members who express opposition to the force. On that note, I must mention that the American Public Health Association's recommendations regarding law enforcement violence as a public health issue include instituting robust accountability measures, as well as increased investment in promoting racial and economic equity in order to address social determinants of health. As a world-renowned leader in public health and medicine, these are guidelines that Johns Hopkins Institution has a responsibility to uphold and has failed to thus far. Over the years, JHU has made many promises to the Middle East area around the medical campus, including the Minority Inclusion Agreement, which after the displacement of 800 families promised 8,000 new jobs and a community reinvestment fund in East Baltimore. As of 2019, JHU delivered only 20% of what they promised in terms of employment. Instead of embarking on new projects like the JHUPD, the institution should implement what it is already committed to and neglected to see through in the past by honoring the Minority Inclusion Agreement. I would like to conclude by saying that during a time when organizations across the United States are beginning to reimagine the place of policing in this country, Senators, I urge you to use your imagination to consider the consequences of granting the power of an armed police force to an institution whose origins are rooted in slavery, of granting Johns Hopkins another tool of racial injustice that can be used to further uphold the plantational relationship that it already established between itself as neighbors in East Baltimore. We hope that you stand strongly with the residents of East Baltimore and on the right side of history in supporting Senate Bill 276. Thank you.
Thank you very much for your testimony and thank you for your time. Next, we have Mr. Link. Sebastian, how are you?
Hello, good afternoon. Thank you for the opportunity. Do you hear me? Perfect. Thank you for the opportunity to speak and to urge you all to support SB 276. My name is Sebastian Link Chaparro. I am currently a fourth-year grad student of sociology at Johns Hopkins. Also, I am a former member of the Student Advisory Committee for Security established in November 2018. In my participation in the advisory committee, I could see how unprepared Hopkins is for having police powers. I strongly believe that Hopkins cannot seriously fulfill the president and other authorities' commitments regarding concerns around the private police. Here, I learned that in Hopkins, the president rules, not rationality. He has structurally shattered Hopkins' rule of law and institutional capacity building. Hopkins authorities presented the Student Advisory Committee as a model to follow with the private police, but it is simply not true. That experience was a total failure. There was no continuity between the former VP for Security, Melissa Hyatt, and the current one, Connor Scott. They did not fulfill explicit commitments and transformed the committee into a mostly informative space instead of a space for advising. The committee did not meet regularly. Moreover, in February 2020, the VP for Security, Connor Scott, shut down the committee unilaterally after consistently refusing to hold an open and widely publicized meeting with neighbors, community leaders, and students. Just recently, on August 2020, Hopkins posted the Johns Hopkins University Accountability Board until further notice, and one of Hopkins' institutional members, the Director of Finance and Accountability of Homewood, resigned from the board. In addition to this experience, I could see that Hopkins doesn't know how to deal with cultures of police brutality, racism, and white supremacy already in place in its security forces. Let me give you two quotes from Facebook posts of Hopkins security officers so you can have an idea. Quote one says, "The only reason our government will want to disarm us after 243 years is because they are planning on doing something to us that we will shoot them for." The quote two is from a clearly faked screenshot of an account named Black Lives Matter posting, "We will be assassinating white families until justice is served." When informed about the situation, which involves far more quotes, the VP for Security insisted on addressing it as a problem of individual bias, as if the problem was just rooted in a misunderstanding or something individual in the head. Moreover, he refused to have an organizational and institutional perspective to evaluate how Hopkins' institutionality is enabling and could overcome the cultures of police brutality. Hopkins cannot handle, and here I end, its current security forces and a relatively simple student advisory committee. How will Hopkins handle a police force? Definitely, Hopkins cannot. They should not be trusted with a police force. We must take seriously the threat of white supremacy expressed in the recent assault of the Capitol. We must support the SB 0276 and repeal Hopkins private police. Thank you very much.
Thank you very much, Mr. Link. Next, we have Mr. Scott, Connor Scott.
Good afternoon, Mr. Chairman, Vice Chair, members of the committee. Thank you for the opportunity to testify today in opposition of Senate Bill 276. My name is Connor Scott, and I am the Interim Vice President for Security for Johns Hopkins University and Health System. The mission of the security organization is to ensure that Johns Hopkins neighbors, employees, students, and patients are safe as they live, work, and visit our campuses. Unfortunately, violent crime remains a persistent threat in the city of Baltimore. And we recognize that we have both the responsibility and the opportunity to help our city and our community address crime on and around our campuses, which includes, of course, both the Johns Hopkins Hospital, where we serve thousands of patients each day, and our Baltimore University campuses. The process in the Community Safety and Strengthening Act for establishing a small university-based department is built on a foundation of community involvement, accountability, transparency, and the principles of 21st century policing. And we plan to go above and beyond, following both the specifics and the spirit of that approach. Above all else, we agree that it's important to build a department correctly rather than build it quickly. As important as the development of a police department is, it will always be a fraction of our security operation and our overall commitment to public safety in Baltimore. Since the act was passed, we have continued to improve our existing security operations while investing in non-police approaches to public safety, like the new $6 million Johns Hopkins University Innovation Fund for Community Safety to support community-led efforts to reduce violence. Along those lines, we continue to think about how we can leverage our resources and expertise to support the city's leadership in its broader public safety agenda. And that includes examples such as providing early financial support to the effort to bring focused deterrence to the city of Baltimore, which is a nationally recognized and evidence-based model for crime reduction. We are also serving as a founding member of the Greater Baltimore Region Integrated Crisis System, which is a $45 million regional collaboration to expand behavioral health crisis support in the Baltimore region. And we are also developing a pilot effort on the university campuses to pair mental health practitioners with our security officers to respond to incidents where individuals are experiencing a behavioral health crisis. As these efforts move forward, we do remain committed to establishing a small university-based police department. Blocking the department before it has begun would abandon years of hard work by community members and legislators and would continue to burden the Baltimore Police Department while leaving Johns Hopkins without a viable solution for addressing the very serious threat of violent crime that we face today in the city. On behalf of Johns Hopkins, I urge the committee to reject Senate Bill 276. Thank you.
All right, thank you very much. Next, we will have Mr. Purnell.
Hello, Chair and Senators. My name is Leon Purnell. I've been the Executive Director here in East Baltimore for over 20 years at the Men and Family Center, formerly known as the Men's Center. I've talked to several seniors in the community, and they all side with me. I would like to bring to your attention that I've been living in this community my entire life, and many of the things that were brought up are probably true. But here and now, in this day and time, we cannot afford to not have policing wherever we can get it. One of the things that made me really consider supporting this was that they agreed to have a highest standard of training, conduct, and accountability. And we also talked about many of the students and the teachers and the instructors, community persons being on the board to make sure that this accountability was upheld. Then the unthinkable happened on the 6th. What if something like this happens at the college and university? When I supported it initially, I told people that the reason I supported was that if my child went to that school or any school, I want them to be protected. And that's what everybody should be thinking about. If something like that madness happened with the Homeland terrorists, storm the universities, what then? We're gonna sit around and say we shoulda, woulda, coulda. So right now, I ask that you support the bill and keep it intact because the seniors need it and many of the people in the community need it and the students. I have students coming here late in the evening and I want them to be protected. When they leave here, they should be protected. They shouldn't volunteer at an agency and be harassed on the way home. So, we need to put things in place that would require accountability and make sure it's done correctly. That's what I'm talking about. Thank you.
Thank you very much, Mr. Purnell. Next, we'll hear from Ms. Ifinkauche.
Hi, am I off mute?
You're good. Yep.
Good afternoon, Mr. Chairman, members of the committee. For the record, Delora Sanchez Ifinkauche with Cornerstone Government Affairs representing Johns Hopkins in opposition to Senate Bill 276. After thousands of hours of legislative and community debate, discussion, and deliberation, in 2019, this body passed legislation to provide Johns Hopkins authorization to create a small police force. If there are any concerns about due diligence, I would point out that the committees of jurisdiction spent hours in bill hearings listening to testimony. The bill was extensively debated on the floor of both chambers. The components of the bill were amended and vetted. It was passed with only 2 nay votes in the Senate and an overwhelming majority in the House. We would respectfully ask that the members of this committee trust the will of this body. When the law was passed, the legislature had the foresight to include a sunset provision. This provision requires that the Legislative Policy Committee review the effectiveness of the law prior to 2027. If it's deemed ineffective or defective in any way, there are mechanisms in place to modify the law or eliminate it entirely. Public policy needs the opportunity to be tested to see if it meets legislative intent. The university has not yet had the opportunity to implement some of the very well thought out and vetted components of the legislation that was passed just 2 years ago. Legislation that aims to create the most progressive police department in the country, embodying many of the reforms that are now being held up nationally and earlier in this committee as gold standards for policing, with bold commitments to transparency, accountability, oversight, and community engagement. Our opposition to this bill is very straightforward. We ask this committee to stick to the course it is set and allow Johns Hopkins the time and space it needs to bring this public safety initiative into fruition. For this reason, we ask the members of the committee to reject this bill. Thank you.
All right, thank you very much. We'll now move on to Mr. Cleary.
Thank you, Mr. Chairman, Vice Chairman, members of the committee. Good afternoon. I've submitted written testimony and I appreciate the opportunity to speak as well. I'm testifying today in opposition to Senate Bill 276, the effort to repeal the Community Safety and Strengthening Act of 2019. I know from firsthand experience, both professional and personal, how unsafe the neighborhoods are around the university's campus. This is a problem that cries out for a community-first solution. This is exactly the approach that Hopkins has taken by including the community in extensive deliberations about the police department. I recognize our city, state, and country are now in a moment of unique and long overdue reflection about the role of police and the efficacy of law enforcement to combat violent crime. Those conversations are important, and I enthusiastically support any of the efforts to bring greater accountability, transparency, and rigor to our law enforcement agencies. I have seen that officers and community members can work together in the fight against crime. Our city can be safer if we allow officers and residents to build the bonds that eventually will help strengthen our neighborhoods. That's why I oppose this bill. It would throw out the entire Hopkins Police Department before it has even had a chance to get started. It would eliminate years of hard work, good faith commitments, and effort on the part of the institution and neighbors. And it would prematurely prevent the university from creating a model police department that could serve as an example for what is possible. In the authorizing legislation, the state required a 10-year sunset provision, after which point the university's police department would be reviewed and evaluated, and the legislature would need to vote to reauthorize the department. That is the time to review the department, not now. Give it a chance to succeed. I urge you to vote no to Senate Bill 276. Thank you.
All right, thank you very much. With that, I think that rounds out the panel and concludes the testimony for Senate Bill 276. We'll now move on to Senator Young, Senate Bill 42. Senator Young, you are up. I'm sorry, actually, excuse me. Let me grab Senator Carter.
Thank you, Mr. Chair. I'll be brief, I promise. My first question, Mr. Scott, you began your testimony as I had anticipated the opponents would, in speaking in a general way about the violent crime and the need to do something about it. And I was wondering if you heard my testimony when I specifically noted that the legislation that was passed only gives the Hopkins Police jurisdiction over those 3 areas, none of which is violent crime. And so I wanted to know, in light of that, why would you contend that this is somehow a fix or a way to decrease the violent crime when this police force has no jurisdiction over that?
Sure. So, I wouldn't say that it's a solution to violent crime. It will always be one of many approaches that we want to address in a community-led process. But in terms of the crimes that you referenced, theft, burglary, and motor vehicle taking, you're actually looking at the part of the statute that applies to investigations. So the Johns Hopkins Police Department would be certified by the Maryland Police Standards and Training Commission. So all of our officers would have the same authority granted by the state, certified under the same process as all other law enforcement officers in the state of Maryland. So they would have the same authority to respond to and handle any type of emergency. But what you're referencing is actually the investigative capacity. So those types of investigations we would own as Johns Hopkins, really because they are more, not to say simple, but they are more baseline investigations that we as a new department would have more capabilities to investigate on our own, while more complex investigations like violent crime is something that you would want an expert agency like the Baltimore Police Department to investigate. So absolutely, we would have the authority to deal with any crime in our jurisdiction.
Thank you. And my other question is just, with the exception of Mr. Cleary, my question is really directed at the other 3 opponents. Well, with the exception of Mr. Cleary, I believe Mr. Scott, Ms. Sanchez, and Mr. Purnell, do you receive any direct or indirect current financial benefit from Hopkins? Are you on the payroll in any way, or does your program receive funding?
Not now. We were part of a collaboration with Hopkins, but it's not current.
Thank you. That concludes my questions. Thank you.
All right, thank you very much, Senator Carter. Senator Sidnor has a question. Senator Sidnor, over to you.
Thank you very much. To follow up on Senator Carter's questions, because I was under the same assumption a few years ago when I voted against this bill, that you all had a limited jurisdiction. So what I'm hearing now is that this is only limited to your investigation. So if, let's say, for example, there was some sort of drug transactions or something happening on Hopkins campus, what you're telling me is that this police department will be able to make arrests and do everything else that any other police officer will be able to do?
That's correct. The limit to our abilities to act is geographic in terms of the jurisdiction. So yes.
Do you all intend on arresting students for their drug use and ability on campus? And I'll tell you the only reason that I'm asking this question, and I always share with people, I'm a product of Baltimore City Public Schools. And it was not until I got to the undergraduate campus of Johns Hopkins that I saw more drug abuse happening there than I ever saw in my time in Baltimore City Public Schools. And so I'm curious, is there any intent on Hopkins' part to be using this particular police force against its students for these types of crimes that are happening within that jurisdiction?
Sure. So drug use, whether it's a student or someone who's unaffiliated with the university, is something that I think research has shown is better handled through restorative justice processes and getting people into programs where they're able to rid themselves of addiction. For the most part, arrests and putting people in the criminal justice system is something that has not been seen as effective. Specifically addressing our students, we do have a pretty strict conduct process, and students are held to a high level of accountability through really the student affairs department. And we have a range of disciplinary efforts that, go from warnings all the way up to things like suspension and expulsion. But for the most part, in terms of your specific question, I would say that, every aspect of the operation of this police department is going to be based on best practices in law enforcement. And, that's one area where I think for the most part, we would see arrest as really the last resort. And there are many alternatives that would be more successful in helping that individual and resolving the situation.
As a student at Hopkins, I believe it was around my senior year, I remember that there was a murder that had took place on campus. It was a student killing a fellow student. So under your interpretation, I guess the Hopkins Police Department, except for the investigations, you all would handle this particular type of a crime.
So yes, any type of complicated investigation would be led by the Baltimore police, who obviously have the expertise to deal with that. But one benefit of having a university-based police department is that they would be able to respond to those incidents probably more quickly than the Baltimore police would. They would also, of course, be trained in our campuses. They would have expert knowledge of where certain buildings were. For the most part, our students, faculty, and staff know the campus by building. But if you ask the Baltimore police, they know Homewood campus by 3400 North Charles Street. So to have a cadre of officers who are trained to the highest level of expectations, who are held accountable, who have a transparent operating system, for them to be able to be trained in the complexities of our campus would really enable them to get there more quickly and hopefully resolve issues like that before the Baltimore police get there, which can unfortunately take a large amount of time in some occasions.
I'll say this, and then it's surprising to me, and I know I paid pretty good attention when this bill came through because I don't believe that private actors should have state police powers. And that's essentially what we've given to Hopkins a few years ago. And I can't believe that I was mistaken, nor do I believe that Senator Carter was mistaken when it was brought to when this bill was brought to us, that we were told that we all would have limited abilities of dealing with certain crimes. So I appreciate you sharing that with me. I'm at a loss for words. So thank you.
Senator Carter.
Thanks, Senator Sidnor. I don't want to belabor this, but Senator Sidnor is absolutely correct, and I believed I was correct as well. The language of the legislation that we passed gives Hopkins Police the primary jurisdiction over theft, burglary, and motor vehicle taking for investigations and arrest. So it's not just investigations, it's arrest. So I think the point is, well, here's the point. Even now, 2 years later, there's still confusion over what this really means and what this would be. And that's a problem from an actual person that's representing Hopkins. This was to proceed with a memorandum of understanding between Hopkins and the police. I believe that hasn't occurred yet. But if there's confusion about what the actual intent of the bill or language of the bill does, I don't think that bodes very well for going forward, Mr. Scott. That's all. I just wanted to clarify that, Senator Sidnor is absolutely correct, as well as I thought I was as well. So I think that, at the very least, we need to go back and take a look at what this bill actually does, because there seems to be confusion on your part.
All right. Thank you, Senator Carter. Mr. Scott, did you want to respond to that, or you're okay? Oh, you're good. Okay.
So, well, I guess, just the one thing that I would want to say in terms of the concept of a private police department is that, one, if you look at the statute that was created, this is by far, certainly in Maryland, if not nationally, the most accountable, most transparent, most forthright creation of a police department that I've ever seen. And, this also would not be the first private police department. And, I say private, but really, we would fall under all the same standards, all the same laws as all Maryland police departments. Really, the only difference is that it's funded by a private institution. But this would not be the first department in Maryland that's funded by a private institution. The Ocean Pines Police Department on the Eastern Shore is a private police department. The Special Task District of Crofton operated as a private police department for a period of time. And then there are also many quasi-private departments, such as the CSX Railroad Police, which operate in Maryland. So there certainly is precedent for this type of thing.
Okay, thank you very much. All right, I'm looking around the Zoom room. No further questions. So with that, that'll conclude the testimony and the hearing for Senate Bill 276. We'll now move on. Thank you all for your time today. We'll now move on to Senate Bill 42 and Senator Young. I think you're still here. Thank you for your patience. Senator Young.
Thank you. Thank you. Wait a minute. Have I got your?
You're live.
Okay.
Your audio. We cannot.
You can hear me.
We can hear you. We cannot see you.
All right. We'll take care of that.
There you go.
Mr. Chairman, thank you. I'm going to start off with a few remarks more in general than specific to the bill, though they relate to what I was trying to accomplish. One thing that I'm sure a lot of us get questioned when we put a bill in like this, I have had 3 police forces under me in various capacities over the years, and have generally found that most of the police officers are good, hardworking people with the best of intentions, but it only takes a couple to make everyone look bad and to cause many of the problems that we are having today. When I was at DNR as deputy secretary, first thing they asked me to do was work out some racial problems on the DNR force. And I met with the Black Officers Association, and it took quite a while to win their comfort, where they felt good with me. And we were making real progress when all of a sudden a target with bullet holes in it appeared on the wall behind a Black officer's desk, and I had to start all over again. And there is just way too much of this type of thing that goes on. I know we can pass a lot of laws like a no choking law, but an officer that chokes is going to choke regardless of the law. And that's happened since those laws have been passed. So what I was looking for in this bill was to try to weed out the people that are the worst problems, knowing we'll never get them all, but we could certainly lessen it. And I put a provision in the bill for psychological screening before they got on the force and at certain times during the force. Now, a psychologist working with the police association told me that he couldn't do that and others couldn't ethically. So I don't know if we can address that part. I also had made the comment to them that there's evidence of white supremacists infiltrating law enforcement. And they asked me where. Well, there was a 2006 report from the Federal Bureau of Investigation, and I have an article here by someone, well, he didn't write the article, but he was the focus of it, someone we all know, Congressman Jamie Raskin, again, saying, let's not forget that the FBI found law enforcement has a white supremacy problem. And then as recently as 2020, an article on Homeland Security Today called Synopsis of Hidden in Plain Sight Report, where the Brennan Center for Justice in New York City, again, went into how it's existing in plain sight and very little is being done about it. So to my bill, I've never been in love with a bill. I'm in love with trying to correct the problem. And whether it's done in this bill or can be incorporated in many of the others that you're reviewing, I think we really need to vet police officers, both applying and existing, to look for connections to the KKK or white supremacy groups or other groups of that sort. And if we're generous, we could start with bias training, but if the evidence is still there, then we need to weed them out of the police force. And I think that would correct a great deal of the problem. In Hidden in Plain Sight, in the Brennan Center's report, it showed that federal, state, and local governments are doing far too little when the problem of racist officers, with the problem of racist officers within law enforcement, police and sheriff's departments and federal agencies. It's well known that from the 26 report and others, very little is being done when these things happen. And they made a series of recommendations, again, screening for and trying to eliminate people with a background like that. So what I was hoping to achieve in the bill and what I just want to see achieved in some form, whether in this bill or elsewise, as that, one, we still look for aggressive behavior through whatever form, and bias against groups, and do bias training, and if it continues to exist, to eliminate these officers from being on the police force. So again, I think the screening should take place at the beginning and at times while officers are there. just bias checks along the way and checks where possible to find if some of these officers have joined groups. We saw what went on at the Capitol building 2 weeks ago. I think the reaction would have been a lot different had that been blacks instead of whites breaking into the Capitol building in terms of the reaction. If we had the case of the young guy who killed 2 people and walked out with a semi-automatic weapon and walked right through the police and he didn't get stopped, I think he might have been shot had he been a different color. So again, I just would ask either through amendments in this bill or that is covered in others that we do everything we can to weed out this problem. And I know there are bills in to make sure that officers report others if they show these problems or demonstrate these problems. So my bill was to correct this problem. If the psychological part needs to be removed, then I would hope they would soon come up with some tools to spot aggressive behavior and these tendencies. So I will stop with that.
All right, thank you very much, Senator Young. The committee misses you, you know, I guess you miss us. I know. Good to see you again. All right.
Always good to see you.
Good to see you, likewise. With that, we'll move on to Ms. Plant. Cecilia, you were up next.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Cecilia Plant, and I'm the co-chair of the Maryland Legislative Coalition. I'm here to testify in favor of SB 42 on behalf of our coalition. We are a coalition of activists, individuals, and grassroots groups in every district in the state. We are citizen activists, and our coalition supports well over 30,000 members. Over-policing and use of force have made news headlines almost every week during the past year. Demonstrations have broken out across all 50 states. As a nation, and right here in Maryland, right now, we are facing a reckoning for giving police too much authority and too many rights that we as citizens don't have. We are now rushing to make systemic changes in how and when police officers can use force and what to do when police overstep their authority. However, one of the biggest underlying factors in over-policing and the deadly use of force is who we hire to be officers in the first place and how we retain them. We all know that both good officers and bad officers exist. And the fear that I have and that our coalition has is that even after we make sweeping changes to policing procedures and training, we will find that we still have bad officers. This bill does 2 things that we desperately need. It provides a mechanism for ensuring that we hire good officers and get rid of bad ones. Because policing puts a person in a position of power, we should have potential employees pass a psychological evaluation to determine if they have issues with aggressive or violent behavior or are biased against some of the very people they would be protecting. We should not hire anyone who can't pass the evaluation. We should also have officers get reevaluated every 5 years to catch those who have developed aggressive behaviors or biases during their tenure and allow policing organizations to offer them other positions or to terminate them if necessary. We should also terminate an officer if it is discovered that they belong to a hate group after they have been hired. The bottom line is you cannot train out hatred or bias. You cannot really legislate behavior, but you can offer solutions and tools that ensure that policing organizations are hiring the right people and terminating those who should not have a badge. We support this bill, and we recommend a favorable report in committee. Thank you.
Thank you very much, Ms. Plant. We'll now move on to Mr. Shavelin. Jared.
Good afternoon, Mr. Chair and honorable many members of the committee. Can everyone hear me?
We can hear you.
I apologize, my webcam is broken, so I hope that's not big issue. For the record, my name is Jared Shablon. I am the chair of the Lower Shore Progressive Caucus, and our position on the bill is favorable. I'm submitting this testimony in favor of Senate Bill 42 on behalf of the Lower Shore Progressive Caucus. The caucus is a political and activist organization on the Eastern Shore of Maryland, unaffiliated with any political party, committed to empowering working people by building a progressive movement. Caucus members constantly support legislation that builds towards a more perfect, just system, and legislation that promotes the highest level of transparency possible towards the greater ability of people to review the ways in which government operates. This legislation addresses many of the issues that have caused the horrific acts of brutality we saw over the summer and for years now primarily committed towards communities of color. The issue addressed is training. This issue addressed is training. This legislation ensures that all law enforcement officers are well trained and adapting to changing environments and methods of de-escalation, conflict resolution, and crime reduction. The second issue that is addressed is ensuring only individuals who can fulfill the standards and stresses of the job get hired. This is accomplished by prohibiting a law enforcement agency from employing an individual as a police officer unless the individual has undergone and achieved a satisfactory result on a certain psychological screening. By implementing this policy, we can ensure that the integrity and stability of our law enforcement agencies are upheld by preventing the hiring of unqualified and dangerous individuals unsuited for the job. The third issue is removing those who violate their oath and commit acts of brutality from duty so they can no longer pose a threat to the community. By requiring that a police officer who has been convicted of killing or causing a debilitating injury against another person be terminated from employment, we can ensure that there are tangible consequences for committing acts of brutality and prevent individuals from being repeat offenders of these horrendous crimes. It is for all these reasons that the Lower Shore Progressive Caucus supports this bill and recommends a favorable report in committee.
Thank you very much for your testimony. And now we'll move over to the opponents of the bill. We have one, Mr. McAvoy, Vince McAvoy.
Yes, can you hear me?
We can. You're off camera, off centered with the camera, and we can hear you just
Sorry,
there.
I can't get into this corner. I'm sorry.
Okay, no worries.
All right,
We can
thank
hear you.
All right, appreciate it. Thank you. And hello, committee, for the first time this season.
A
I'll
little
try,
faint, Mr. McAvoy. It's a little faint.
I'll try and keep it brief. Is that better?
Sure. If you could speak up just a little bit, though.
Okay, all right. I want to point out that Maryland is losing residents, and we're losing law enforcement in the rank and file and at the command level, at the interjection of politics into their roles in public safety. And I think that this flawed bill is an agenda piece. I think that law enforcement looks at data and facts. Placing this type of power in the role of a psychiatrist or a psychologist, both being soft, subjective sciences, is not helping Maryland, the enforcement of laws, and the safety of our communities. We have a twofold increase in murders, pretty much nationwide, and increase in the local area. Baltimore County is experiencing a massive increase in crime and murder. This bill attempts to inculcate a purity test. It has no place in the management of individuals who put their lives on the line on a daily basis. And as we've seen, these agencies listed, the FBI, CIA, DHS, are entirely corrupted and politicized. They are a shell of their former stalwarts of law enforcement, what they once were. Few can process the threats on the street, the ability and skill of law enforcement, understanding of laws and ordinances, and the other demands of keeping themselves and the public safe on their job, while giving none to these unrealistic, agendized wish lists. I urge a strong on favor, and thank you for your time.
All right. Thank you very much. And with that, I believe that rounds out the testimony and concludes the hearing for Senate Bill 42. Senator Young, always good to see you. Thank you very much. Senator Bailey, did you have a question? Senator Bailey, did you have a question?
Yes, I did. I'm sorry.
Okay, go for it.
Real quick, Senator, I have a couple real quick ones. So I'm very familiar with the fact of when you're hired as a police officer, you have to go through a polygraph and a psychological to be hired if you're going to work for the state. How many departments are you aware that don't require that?
Hold on, Senator Young, let me unmute you here.
I know of several departments that do. I don't know how many don't require it.
Okay, and so from what I'm familiar with, everyone that I'm familiar, they do require it to start with. So then 5 years on, a police officer then, under your legislation, would be required to take another psychological. And if he failed to pass that, that could be obviously by any reason or any traumatic experience that he or she had while they were working. So if they failed to pass a psychological at any time in their career, why wouldn't it be an automatic medical disability for them?
Well, my idea is if they failed it at that point, but did not have a record of abusive behavior, that they would just go in for counseling and review and not be dismissed. But I think that if we found an officer who was had been charged and a number of times or convicted, that he might be removed. But I wouldn't remove someone who had not demonstrated it. I would just, at that point, offer help.
So I would definitely say that you and I come at this from two different sides, right? And clearly you will see this in the military. If somebody does not pass a psychological, they are in a traumatic experience, they get an automatic medical disability. That should be, if you were going to put anything forward like this, that should be a guarantee in law enforcement also.
Well, I also think they could be put on desk duty.
So as far as that goes, you're either a police officer or you aren't, right? If you're not a police officer, you're going to be on desk duty, then you would be, then it'd be at that point in time be a civilian, but you should get your police retirement.
I don't know about all police departments, but we had officers on desk duty for years and they were still police officers.
So I'm not familiar that exists. You're either full duty police officer or you are in a status that you don't have authority to make arrests, right? Then, so anyway, thank you.
Thank you.
All right. Thank you, Senator Bailey. Seeing no further questions from the committee, Senator Young, thank you again very much. It's always good to see you. And with that, that'll conclude the hearing for Senate Bill 42. And we'll head into the home stretch with Senator Sidnor, the last two bills of the day. Senator Sidnor, you will start off with Senate Bill 166. So Senator Sidnor, the floor is yours.
Thank you very much. And I will be quick because I know one of my witnesses, he has a class to teach in about 7 minutes. So, and I would call him first as soon as I finish, and then Mr. Franklin, and close out with Ms. Levy. So Senate Bill 166 is called the Duty to Report Misconduct Bill. Essentially, the bill, it creates a reason or duty on officers to report 6 crimes and excessive force. If they don't do it, then they could be prosecuted and have a misdemeanor not exceeding 5 years or $10,000 fine. What we're hoping to do is by creating this avenue for police to have this particular duty, the hope is that they do the right thing. Again, one would expect that if an officer is aware that another officer has committed a crime, they would report, but it's my understanding that that's not always the case. With that, I look for this committee to provide a favorable on 166 and ask that Professor Ray, if possible, if he could go ahead and testify since he would have to leave us.
Got it. Thank you, Senator Sidnor. And Dr. Ray, you're up next. Good to see you. We just cited some of your research earlier today, so here you are.
That is always great to hear. Hopefully it was useful to you, Chair Smith, Senator Sidnor, and others in the Senate. Thank you for giving me this opportunity. As Senator Sidnor said, I do have to go teach a lecture, but I will definitely be providing my full comments here. And then of course you all can see my written comments. In addition to being a professor at the University of Maryland in the Department of Sociology, where I direct the Lab for Applied Social Science Research, we do a lot of research on policing and have worked with police departments in Maryland and throughout the country. I'm also a David M. Rubenstein Fellow at the Brookings Institution, where I do work on public and social policy. I also come from a law enforcement background. My great uncle was the first Black chief of police of my hometown. I have several other police officers in my family. My grandfather served in 2 wars, Purple Heart, Bronze Star, and my mom was admitted to West Point in the late 1970s as a Black woman. I think that legacy kind of speaks to me being here, even though it's slightly different from the reason why I do the research I do. It does help me to have a level of empathy for law enforcement. I've researched policing for over a decade, conducted bias trainings with thousands of officers, including the Department of Homeland Security and the military. And this legislation by Senator Sidnor aims to establish a statewide database for law enforcement officer misconduct and mandates that officers report bad behavior. This is an important piece of legislation, and I think that it will situate the state of Maryland in being in line with best practices to create equity, transparency, and accountability in policing, and also put the state of Maryland ahead of others, but not as much as it would have been, say last year, but definitely in line with best practices of other states that I know who are doing this work. It also aligns closely with the George Floyd Justice and Policing Act, which passed the House of Representatives in June 2020. And of course, that bill passed on what would have been Tamir Rice's 18th-year-old birthday. As you all know, Tamir Rice was the 12-year-old who was killed in a park in Cleveland playing with a toy gun. He would actually be a freshman in college this year. However, in the state of Maryland, we also have our own example, and that being 19-year-old Anton Black, about how this legislation will be protecting people. Anton Black was killed by a Greensboro police officer, Thomas Webster, who came across state lines from Delaware, where he had left the department for excessive use of force. And I tend to think that Tamir Rice, similar to Anton Black, will probably still be alive had they not encountered these officers and had this particular legislation been in place. The duty to report misconduct bill will ensure that officers who engage in misconduct cannot simply resign or be fired and go back to work for another law enforcement agency, which I see a lot. And I hear a lot of police chiefs say, okay, I'll conclude in 10 seconds. I hear a lot of police chiefs say that is something that they actually want to be able to deal with. And my research further shows that this bill will protect good officers who continue to work and not necessarily want to work beside officers not suitable for the profession. So thank you for your time.
All right, thank you, Dr. Ray. I know you've got to go, so appreciate you taking the time to testify and appreciate all your work and research. It's great. It's one of your class. All right, so next we will go to Ms. Levy. Deborah, I see you over there. You are up next.
See, unmute. All right. Chairman Smith, Vice Chairman Waldstreicher, it's nice to be here today. Senator Sidnor, thank you so much for this opportunity to speak today on this important piece of legislation. I know everybody's been so patient and it's been a long day, so I'm going to try to stick very closely to my time and go through it as quickly as possible. Mark Twain said that it is curious that physical courage should be so common in the world and moral courage so rare. The duty to report misconduct codifies the duty to live with a higher moral code while policing in Maryland. The concept, I'm sorry for my puppy, a duty to report is not new to certain professions. There was no political controversy that I am aware of when Rule 8.3 was established, which created the duty to report misconduct amongst lawyers and judges. The rule in its entirety is titled Reporting Professional Misconduct, Maintaining the Integrity of the Profession. As a young lawyer having to pass the professional responsibility exam, it was deeply ingrained in me from the beginning of my professional experience that I have an affirmative duty to report a lawyer or a judge who engages in misconduct in front of me. This duty relieves me of the guilt, fear, or hesitation that might otherwise derail the moral requirement that I report someone more senior than me or someone with more authority than I have. I know firsthand the importance of this requirement, that this requirement had on me when I summoned the courage to report judicial misconduct against a longtime judge. As one of the newest lawyers in my jurisdiction, it was the most courageous act I could take on to report a veteran judge on the bench for his humiliating acts of misconduct that most clearly interfered with the administration of justice during a homicide trial. I knew that to do so could create enemies, injure my career, and result in negative backlash, but my moral compass encouraged it and my professional duty empowered it. Without that obligation, the affirmative duty to report, and the consequences that could be imposed by my failure to do so, there is likely no way I would have summoned the courage as a new lawyer in Maryland to complain about the conduct of a senior chief judge on the bench. My bravery was supported by the rules and the laws of my profession. It enabled me to take action against someone more senior than me, more powerful than me, and with far more authority than I might ever have. And while the Commission on Judicial Disabilities ended up agreeing with me, I did not know at the time I summoned the courage to make the report. The misconduct that this law, Senate Bill 166, is aimed at preventing is far more insidious than words in a courtroom hurled by a judge. The misconduct that this law aims to eliminate is most often violence and sometimes tragically death. There is a sad and unfortunate truth that our country is reconciling with right now, that police are not always good, and that policing gone wrong can have disastrous effects on people and our communities, and Maryland everywhere is no exception. While we are familiar with stories in our state's history that have ended tragically at the hands of police violence, including Anton Black and William Green, there are other less known instances that happen regularly, born out of a strong code of silence that law enforcement officers all too often afford each other. And anyone who tells you otherwise, that there is no code of silence amongst law enforcement officers, is simply not telling you the truth. In fact, in acknowledgement of this truth, the strong and historical code of silence that police departments across the country have embraced, new trainings aimed at dismantling it. Yet they realize in order to do so, they must change their culture. But changing culture takes time and courage. Teaching young officers they are empowered to report and intervene on a more senior officer's acts of misconduct is not something that is going to happen overnight, but it is something that the legislature, and most particularly this committee, has the power to assist with. In Baltimore and in New York and jurisdictions across the country, police departments are implementing the ABLE training, active bystandership for law enforcement, which is aimed specifically at preventing and stopping harmful behavior by a fellow police officer. Imposing a criminal sanction on the failure to report misconduct only bolsters the officer's courage to report and will directly help change the culture of law enforcement, from one that worked in the past to cover things up to one that works to stop things from happening before they do. As Baltimore Police Commissioner Michael Harrison said on NPR in July of 2020, this type of police training shifts loyalty from after a bad event happens to its proper place before the event takes place, and it helps officers hold each other accountable. It's a sad and unfortunate reality that the courage to report misconduct is not often compelled by law enforcement, but the opposite reality is that you have the power to make it so, to pass a law that gives a younger, less senior, and less experienced officer the duty and the responsibility to report the misconduct they observe, so that they can enjoy the privilege of holding on to their role of their profession while maintaining its integrity. As a result, I respectfully ask for a favorable recommendation for Senate Bill 166 in its entirety. Thank you very much.
All right, thank you very much. And now we'll round out the proponents with Mr. Franklin. You are up.
Thank you, Chairman Smith. And again, I represent the Law Enforcement Action Partnership, national organization of police and prosecutors and others who are working to improve the professionalism and within the policing community, among other things. Ms. Levy just made my job a whole lot easier here, as I intend to speak to the culture here. 3 main areas, so I'll be brief. training, policy, and now we're talking about law regarding the duty to report these lists of infractions here in Senate Bill 166, which we support and are requesting a favorable report from the committee. Let me just say that we do train our police officers. As a head of training for the Maryland State Police in the past and the head of training for Baltimore City, I know for a fact that we do train our police officers to report such issues of misconduct and illegality being committed by our police officers. We also have policy in place to do the same. So some may ask, why is it then that we need a law for this? The culture of policing is very, very strong. And we know, we've heard that it needs to change. The thin blue line, the secrecy that's already been spoken about. It's very difficult for police officers to come forward to abide by their training and by policy. Very quickly, I testified in the Freddie Gray trial, and we had police officers take the stand to testify that policy is just a guide. It's something that police can follow if they want to or not. So with a law in place, this is very good for police officers, and it gives those police officers that protection. Hey, I have to report this misconduct. It's not something I can decide to do or not to do, which is very important, very instrumental in changing the culture within policing. This law is very important. And again, much, much stronger than policy. And it gives police officers who want to do the right thing an out. It gives them that courage. I have to do this. I am not going to jail to defend or attempt to defend or hide something that you did, which is illegal or improper. So it would also go a long way in improving the profession, go a very long way in improving the relationships between police and community, which we've spoken about earlier today. So again, the Law Enforcement Action Partnership, as well as I, strongly support this piece of legislation and hope and pray that you, the committee, give a favorable report for it. Thank you very much.
All right, thank you very much, Mr. Franklin. We will now move on to the opponents, and we'll start off with Mr. McAvoy.
Hello? Can you hear me?
We can.
Great, thank you so much. I apologize. I have two separate computers. I'm in House Judiciary too. So I'm switching between testimony. Let me just be brief. This bill, I believe, was set officer against officer. Police departments already have internal affairs departments. I know in Baltimore City, we had a consultant come from North Carolina to help out there where there were issues that they didn't feel they could handle locally. There's a vast number of police retirements, including in our area, and understaffed police departments are the problem. Failure to solve crimes are the problem. Slow response time due to increasing crime is the problem. Unsolved murders are the problem. Creating a bill that is duplicative at best and antagonistic at worst is not solving the problem. It's a continuing assault on law enforcement, and I urge an unfavorable. Thank you so much.
All right, thank you, Mr. McAvoy, and good luck in the House Judiciary Committee. All right, now we'll switch over to, we'll round out with Mr. Schellenberger. You are up next.
They just gave me the unmute. Once again, I apologize. I probably didn't word my caption very well. So I'm not opposed to the underpinnings of this bill. There's just one part of it that I'm opposed to, so please take a look at my written testimony. I actually do not have a problem with making this a crime. I was particularly impressed with the requirement that actual knowledge be established, and therefore I accept the majority of the bill. The thing that I have a problem with is that the crimes that there is a duty to report, and it could be a crime if you do not report, there are 7 of them. 6 of them are very enumerated crimes that are well known and found in the criminal code. And so number one, homicide, all officers know what that is. Number three, sex crimes, theft, perjury, fraud, tampering. All of those are very easy for officers to be able to report. And I think they should, because those are things that I need to know about. And I think I agree with Ms. Levy, if she's still on, that sometimes putting a law into effect lessens the burden of guilt. What I do have a problem with is B2, and that is adding excessive force. Once again, that is a standard, not a law. And therefore, I think there needs to be a difference between reporting standards and reporting law. Now, there are other bills that talk about reporting excessive force and possibly being disciplinary action. So what I would suggest, and we can do this with what we were discussing earlier today, what I would suggest is Senate Bill 166. If we take out B2, excessive force, we can pass that, and I will be in favor of that. We take that excessive force part out and put it in those sections under police reform that would require you to report, but it would be subject to disciplinary action if you don't. I think that's a more fair and balanced approach. And with that one subtraction, I can support SB 166. Charles, I did not mean to shock you.
We get a thumbs up from the senator. There you go.
Okay.
All right. All right. I'm looking around the room. Questions from the committee?
Great.
All right. Seeing none, that'll conclude the hearing for Senate Bill 166. And we'll move along to our final bill of the day, Senator Sidnor with Senate Bill 71. Senator Sidnor, the floor is yours.
Thank you very much, Mr. Chair and committee. This bill, the presumption of inadmissibility, is in response to what we've not only seen around the country, but we've seen and actually in both of my jurisdictions within the written report that, or written testimony that you all have. It speaks of an incident where one of our officers didn't activate his body camera, and just earlier last week I had received an email with regards to an allegation that this is also happening in Baltimore County with someone who intentionally did not activate the camera. So the question is, if the state and if localities have put out all of this money to ensure that their body camera programs were working properly, how should you respond to it when an officer takes it upon themselves, not purposefully, not to activate the camera? I can remember when we first introduced body camera legislation, there were conversations around criminalizing that action. We did not go that route, but as time has progressed, we've seen that it has become a problem. This bill is an answer or response to that. And what would happen is if an officer knowingly and willfully did not turn their camera on, that information could then not be used in a trial. It would be you would have a rebuttable presumption that would then be made, and we thought that this was most appropriate way of handling this, and for reasons that you'll hear from some of my more expert witnesses, I will. Actually, before I turn the mic over, just when I looked at some of the opposition, where they were I think Maryland Chiefs and Police Association, as well as the Fraternal Order of Police, the incidents that they're talking about are things that are happening instantaneously and an officer kind of jumping in the duty to do something. I would posit that this is not what this legislation is about. This legislation is about officers purposefully not turning their cameras on when they should be turning their cameras on. It's not about critical incidents erupting with no warning and an officer hopping into action. I think a judge will be able to look at that and realize that that's not what this bill is about. So I just wanted to make certain that I said that on the record. And with that, I rest and look for favorable from the committee.
All right, thank you, Senator Sidnor. We will move on to your panel, and we'll start off with Mr. Franklin.
Thank you, Chairman Smith. Here I am again. So I'll skip the introduction. I think everyone knows who I am and who I represent. Look, police officers have always been given the benefit of the doubt when it comes to testimony in court, due to the nature of their job, the oath that they've taken, have been viewed as being creditable in a court of law. But unfortunately, there's a lot of evidence out there that we are now seeing, partly because of the introduction of body cams being worn by police officers. The fact that just about everyone has access to video police-citizen interaction with their cell phones today, and other things. We're now seeing that, unfortunately, police officers are not, generally speaking, as truthful as we would like them to be. We've seen cases where police officers have actually attempted to manipulate the use of their body cams to stage things, the finding and collection of evidence with their body cams. We've seen cases where officers didn't realize that prior to turning on their body cams that, it's already recording, is just no audio. We've seen cases and evidence of police officers turning off their body cams at certain times so that things are not heard and things are not viewed that are critical to a particular case. So basically what I'm saying is the evidence is there, and we've seen it to indicate that unfortunately police officers are not as truthful at large as we'd like them to be. So again, this law that's being suggested here, this bill, which we support, the Law Enforcement Action Partnership supports Senate Bill 71. We're asking for a favorable report on it. It is not a bill that's going to sanction police officers with being prosecuted in jail time. It's just relative to their testimony in court. And, again, if the evidence is there to clearly show that a police officer has either willingly failed to activate their body cam, has manipulated it in some sort of way, in a malicious way, then that testimony may not be admissible in court. And I think that's fair. And I think that's important. And I think that it is extremely important as it relates to cases that police officers bring on citizens who are subjected to being charged, prosecuted, convicted, and then sent to prison to do time. So thanks again.
Thank you, Mr. Franklin, for your testimony, for, spending so much of your day with us today. So much appreciated. We'll now go to Mr. Frazier. You were up next. I saw you earlier.
I'm here.
Oh, here you go.
Thank you. Evidence which derives so immediately from an unlawful officer's action is no less the fruit of an official illegality than the more common tangible fruits of the unwarranted intrusion. That's from the Supreme Court, Wong Sun v. U.S. in a 1963 decision. I'd like to thank the chair, Chair Smith, for having me today and the panelists today, and want to say good afternoon. I'm a public defender in Prince George's County with our Government Affairs Division. And every day in criminal cases across Maryland, and defendants have the right against unwarranted searches and seizures. That right is protected by the US Constitution as well as the Maryland Declaration of Rights. The exclusionary rule not only gives gives judges the opportunity to exclude evidence that was obtained unconstitutionally. But under the fruit of the poisonous tree doctrine, a court can even exclude evidence from trial, my apologies, stuff that is derived from an illegal search. And this proposed bill, adds a similar exclusionary rule for body cam evidence. And just like the Fourth Amendment protects people's rights, and the exclusionary rule gives consequences, which incentivizes rights and officers to uphold people's Fourth Amendment rights, this bill, right, will provide consequences and incentivize officers to utilize their body cams. Throughout today, we've heard about transparency and accountability. And what this bill does is add a little bit of teeth in order to encourage more transparency and accountability, because the officers and the state's attorneys that work with them are going to seek to try to introduce this evidence at trial. We've had members from FOP, we've had state's attorneys talk about the importance, how useful body cams have been to them. And this will ensure that the body cam's usefulness will also be given to the citizens of Prince George's County, as well as the rest of Maryland.
All right, thank you very much. Good to see you again. Next, we'll have Ms. Headley. Andrea, you're up.
Thank you, Chair Smith and Senator Sidnor, for bringing me here to speak. My name is Dr. Andrea Headley. I'm an assistant professor of public policy at Georgetown, and I'm also a visiting scholar of race, policing, and crime at the National Police Foundation. Today, I'm going to speak on Senate Bill 71 on the presumption of inadmissibility. One of the most important factors for the success of body-worn camera programs broadly is determining how they are implemented or used. In my own research, a colleague and I spent time conducting and analyzing qualitative interviews with DC residents on body cameras. And in this research, we found that community members generally believe that cameras could improve police officers' behaviors and increase their legitimacy. They largely felt that interactions with officers who had cameras turned on would be improved because officers would be more cognizant of what they were doing, they behave better when they're watched, and they're less likely to do things considered quote unquote wrong. However, in order for these statements to be realized or come to fruition, then ensuring that the cameras are turned on unless otherwise unable to for valid reasons is essential. Research suggests that departments with more restrictive discretion and activation policies often have greater reductions in use of force and can have greater reductions in complaints as well. Further, concerns exist with regards to selective recording, which can open up potential for misuse of camera technology. Irrespective of whether the following actions are intentional or unintentional, there have been reported instances of officers turning cameras on and off throughout a single incident or encounter, cameras not working at all in key enforcement encounters, and camera footage disappearing after incidents have occurred. In the United States, whether we agree or not about the utility of our current criminal justice system, it's clear that we designed our systems around deterrence models, which is why there are consequences and punishments in place for breaking rules and laws. And if deterrence and punishment models applies to the public at large, then it also applies to criminal justice actors and their professional capabilities. There should be repercussions in place for violating established rules and policies, particularly with regard to willful negligence. As written, the proposed legislation is applicable only when an officer is required to use a body camera and with proof of knowing and willful failure to activate by the officer. That said, policy violations of non-compliance, non-activation as a result of ensuring public safety, responding to imminent threats, reacting to crimes in progress, or those that are truly innocent mistakes should be thoroughly evaluated and given special consideration or exception. In closing, this legislation can signal the importance of activating one's camera. It can encourage compliance with organizational policies, and it can increase proper use. As such, the intent and spirit of these bills remain important, and I applaud efforts to increase transparency and promote accountability in policing. Thank you.
Thank you, Ms. Headley. Good to see you again. We have next Mr. Greenberg.
Thank you, Chairman, Vice Chair, Senator Sidnor. We are urging on behalf of Maryland Association for Justice a favorable report with an amendment to Senate Bill 71. As I've been sitting here all day waiting for this bill to be heard and listening to others, including Mr. Schellenberger, who called me out on agreeing on the same thing, I will tell you, I heard him say body cams was the best thing or the best money he ever spent. And it made me think about the esteemed words of George Michael, the lead singer of Wham, and I had to look that up. But if you're going to do it right. I will tell you that if citizens want police in their communities to wear body cameras, they should demand strong policies and institutional practices to make those cameras effective. They should demand that departments will or can effectively be compelled to actually comply and enforce good policies and practices that will ensure that the cameras provide transparency and oversight. As I personally represent not only civil cases, I also represent criminal. I've had cases where, at least on one occasion I can think of, an officer purposely turned off his camera not once but twice. And they conspired, thinking they were off camera, conspired to create a set of facts and narrative against my client. The truth did come out in that while Senate Bill 71 takes a step forward to ensure that such policies will occur, we request an amendment to expand the requested presumption into civil cases, not just criminal. It's the same thing. It sounds like everybody here today, including Mr. Franklin, are saying the same thing. We want better policing, more transparency, more trust in, by the public in the police force. And by accepting this amendment, I think I heard Mr. Frazier say incentivize. That's exactly what happens. You're incentivizing the police to do the right thing that we all want them to do. So Senator Sidnor, we hope that you not only accept our amendment, but we do stand behind Senate Bill 71. Thank you.
All right, thank you, Mr. Greenberg. Good to see you. And then we're gonna, the most frequent flyer today, Mr. Schellenberger. You've been in your seat longer than some of the senators have. Okay, all right, Mr. Schellenberger, you're up next.
Well, thank you so much, and thank you all for being so patient today. Just so you know, the reason you have me all day is because my colleagues are over dealing with the House, we decided to torture you with me. So I'm going to remain calm. I come to you and say body cameras are the greatest thing we've ever done. I have touted them all over the state. I have come here today with Senate Bill 237 and said, please impose body cameras on every state jurisdiction in this state, make everybody do it. It's the greatest thing we ever did. And now you're going to punish me because somebody's sitting in their truck and forgets to turn it on or doesn't have time to turn it on? I mean, that's what you're doing. You're not punishing the officer. You're not punishing the department. You're punishing me, the ability for me to put the best possible witness on the witness stand. And I see my friend, Senator Wallstreicher, smiling, but it's true. I mean, you're now going to say that an officer for the last 200 years can walk into a courtroom and say what they saw and heard. Now we put a body camera on them that 99% of the time gives you even better evidence than we've ever given. And suddenly now the officer's untrustworthy and he can't be trusted. And you put a presumption in here. And the only way I see me being able to rebut this presumption is if I can prove there was a malfunction in that camera. I mean, if I were all those other jurisdictions that, hasn't bought body cameras and you don't pass that other law, they're going to say to me, Schellenberger, you idiot, look what you did to us. Now I can't put testimony on. An officer walks up to two people and someone confesses to a crime and the officer doesn't have the time to put his body camera on. He can't testify, but if a convicted perjurer is standing next to him, he can testify. I mean, I understand that there are people who sometimes evade and don't do the things they're supposed to do. We do try to catch them, and we often catch them with that prior 30 seconds. So the body camera, as soon as you hit it to go on, it saves the prior 30 seconds. And that's what happened in that case that I think Mr. Greenberg was referring to in Baltimore City, where the person pretended to find the drugs. and then went back and reenacted it, they got caught with the body camera. Please don't take away the best tool we have by imposing a punishment on state's attorneys and on criminal cases that shouldn't exist when we're trying to move forward. Thank you so much. I said I would calm down, and I didn't.
Well, we appreciate it. Thanks. All right. Now for our final witness of the day, Mr. Kroll, good to see you. You are up next. I think you're unmuted.
Thank you, Senator Smith. And I have been here the longest, and I could be at the House where they're still going on. So thank you, Mr. Schellenberger, for letting me stay at the Senate. But I've been listening all day patiently, but I want to add to it. My name is Stephen Kroll. This is the State's Attorney Coordinator from Maryland and the Executive Director of the Maryland State's Attorneys Association. I apologize. I've been on the Zoom since 10 o'clock very patiently, but I do have something to say. Mr. Schellenberger said, and he's right, it affects us as prosecutors, but a malfunction or a problem with any body camera affects victims of crime. They're the ones that would suffer because of this. Mr. Greenberg, Mr. Frazier, and my good friend, Mr. Franklin, did not take into consideration the victims of crime. They're the ones that suffer because of something, a technicality that happens that's beyond their belief. Do not forget the victims of crime. And none of them spoke about it. And I can only tell them they should speak to victims of crime who don't deserve to be punished because of the technicality. And so all Mr. Schellenberger pointed out is a technicality. There's a jury instruction, and every single good defense attorney like Mr. Greenberg, who I have cases with his firm many times, that instruction says the following: it's the credibility of the officer. The trier of fact takes that into consideration. They take into consideration that the body camera wasn't on, and they can judge it based on that. And Mr. Greenberg and Mr. Frazier and any other good defense counsel could argue why it wasn't on at that time. And that goes to the trier of fact. That's the argument they make, and that's the punishment that's there. And then we have to argue it from there. So there is a punishment that they get to argue that, and that's the credibility argument from there. But as Mr. Schellenberger pointed out, you can let a perjurer testify, but not an officer who saw something at that time. Do not blame the victims for someone else's fault. This is a bad law, and the State's Attorneys Association and the 641 people that we represent asking for an unfavorable report. Thank you very much. And I apologize because I've been sitting here since 10 o'clock.
Thank you very much, Mr. Kroll. It's good to see you. And
thank you.
Thanks for hanging tight with us. And with that, so we have a question from Senator Castley, I see.
I'm still here. Thank you, Mr. Chairman. So, Mr. Kroll, I think you clarified, maybe you've answered my key question here, and that was just, I don't do criminal trials, and I know Mr. Greenberg's here also, and Mr. Schellenberger, but I mean, it's my understanding that if I'm an officer and I get up and I testify and I say, here's what happened, and I forgot to turn my camera on, then on cross-examination, the defense attorney is going to say, now you got this camera, we spent $1 million to get you this camera, it's all here to remove, so that we wouldn't have to sit here because the facts would all be before you. And now, because you didn't turn your camera on, we're now here to determine whether my client should go to jail. Had you turned it on, we wouldn't have any doubt, we would know. Can those kind of arguments be made, Scott, Mr. Schellenberger?
Thank you. In fact, those arguments can be made even better. And that is,
Sorry, I'm not as good as you are.
Here's a cross. Officer, isn't it true you were wearing a body camera that day? Yes. And isn't it true you didn't turn it on? Yes. And isn't it true in these departmental guidelines that the Baltimore County Police Department put out and published tell you that you have to put it on? It's a mandatory reason to put it on under these circumstances. Isn't that what your department tells you? Yes. And therefore you violated department guidelines, didn't you? Yes. And it just so happens, officer, that the moment you violated guidelines, the moment you didn't turn it on, the moment that you forgot to activate it, you say my client confessed. And I'm sure there are defense attorneys who can do that better than I can. And so that will come out. And I think you will be able to ask the judge for a jury instruction to say about what Mr. Kroll said, credibility of witnesses. And I think you can put that departmental policy in evidence and argue that in closing. So I think this is all going to be fleshed out in the way we've always fleshed things out. And that is through the facts, the judges, and the jury, and not make it a blanket, can't do it because somebody forgot to hit a button. Or more importantly, as I mentioned in my written testimony, you remember I mentioned in the fall when we talked, the case out west, I think it was California, where two officers are just sitting in their car eating lunch, and somebody walks up and shoots one of them. They had body cameras. They didn't activate them. Do you mean they can't testify to what they saw and heard because they didn't hit that button? So I see Mr. Franklin shaking his head. I don't see an exception for that in this statute.
So I think what they're pointing at, what they're getting at on that is that it does say a knowing and willful failure. They're saying those cops wouldn't have a knowing and willful failure. But to that, if I can shift on, and Scott, I don't do criminal law, so the exclusionary rule kind of something I left behind not long after law school. But tell me if my understanding is correct here. That so under the exclusionary rule, which is normally applied by the courts, it's that the contention is that a state actor, i.e. a cop, deprived a defendant of their constitutional right. And it didn't matter that they were maybe later determined guilty or that they were actually not a nice person. They have those constitutional rights, whether they're a nice person or not. And when the police officer violated those rules, the Supreme Court has said those constitutional rights are so important that I'm going to let you can't even bring that evidence in, and that guy might walk. And that guilty person who was a murderer or a rapist or an arson gets to literally walk out of the courthouse. And because they can walk out, the people who really suffer is going to be that guy's next victim. It's not the police officer that suffers. It's not the state's attorney. It's not the state. It's the next victim that suffers. But we have said, but those constitutional rights are so important that, yes, it's important that we let that murderer, that rapist or robber go free and inflict harm because the constitutional rights are so important. But then we have to look on this side. There's no constitutional right to have your officer wear a body camera. That if I'm a defendant, the fact that the police officer didn't have their body camera on, he didn't deprive me of a constitutional right. He didn't deprive my liberty or anything. He doesn't have a camera on. There was no deprivation at that point. And so does it make sense then to go for the extreme remedy of depriving the testimony, which would put the murderer, the rapist, the arsonist in jail, and inflict and then go out, deprive that testimony. So now they're going to go out and inflict their heinous acts on the next victim because we think it's so important to force cops to have their body camera on. Am I mistaken? I mean, you do this stuff. Tell me where I'm missing on the constitutional law aspect of this.
No, you're absolutely right. We have determined that there are certain rights in this country that are so important that when you violate them, there's suppression of evidence. So suddenly we have new technology that makes most of our cases better, the vast majority of our cases better, and we're going to tell people to use it. And now we're going to pass a law in 237 that makes people use it, but now we're going to punish them because they can't turn it on in time, forget to turn it on, or I can't prove that it's malfunctioning. That doesn't make any sense, particularly when that testimony has been admissible for hundreds of years. And suddenly now when we're trying to do things better, we're punishing the state's attorneys and the state.
Thank you. And Mr. Chairman, can I just really conclude, because there was a remark made, I'm not going to attribute to anybody, that police officers are generally having a difficulty in telling the truth. And I really don't think anybody on this call believes that. And I hope that was just a misstatement. But what we see in this modern day where every single instance of a bad cop gets played over and over and over on the nightly news, 24/7, 365, it can leave the impression in all of us that every cop is a lying SOB. And it's just not true, because we don't hear the reports over and over and over about the cops helping and all the good stuff they do. So I'm sure that was not it, but I just want to make, because I don't want the folks listening to think that we're accepting an unrebutted suggestion that the police are not generally awesome people who tell the truth and do a good job, that we're here talking about bad actors. Thank you, Mr. Chairman. I appreciate my time.
No, appreciate it. Thank you, Senator Casserly. And obviously we're here to address systemic issues, not to cast aspersions on the profession or individual officers who go to work and work hard and render good public service every single day. Senator Sidnor, you're up.
Thank you very much. for, and this could be either, and for Mr. Crow or Mr. Schellenberger. And good to see you. I haven't seen Mr. Crow in some time. So the question is this, you don't like the bill. How then should officers be held accountable for not turning on their cameras for nefarious purposes?
So in Baltimore County, we adopted procedures for how when the officer has to turn it on, when they can turn it on, when they shouldn't turn it on. If you're in a hospital room and you're guarding someone, shouldn't turn it on if people are unclothed, and that happens a lot. So we have all these rules and regulations that we wrote, and they are in police department policy. And if you violate police department policy, you can be disciplined. So if you were an individual as a defendant, and you claim that the officer's lying and he didn't turn his body camera on, and the policy requires that he did, you could file an internal affairs complaint, and it would have to go through that disciplinary process that we discussed earlier with those other bills. So there would be or could be a sanction, but not such a severe sanction that would suppress any testimony from coming into a criminal case.
And then how would the public know that this officer who had nefarious purposes, that they were disciplined?
Well, if we go with what I discussed, if the prior bill was sustained findings, then that would be public. As long as they were sustained, that would be public. But I have agreed to, work with the ACLU about maybe tweaking that a little bit. So we can weave all this together, and I think there's a way to get there.
Is it fair to characterize this bill as something that would hurt officers who just forgot, rather than who knowingly and willfully failed and violated departmental policy?
Well, my problem is the presumption.
No, but is that a fair characterization?
I agree that you have knowingly and willfully, but that creates a presumption against me. And the way I'm reading this is the only way I can rebut that presumption is if I can show there was a malfunction, not if there was human error. So that's how I'm reading this. I read it much stronger than I think you are right now.
So if we were to amend the bill to address that type of situation, would that end your opposition?
Candidly, Senator,
you don't like the bill?
I don't. I candidly do not. I can't see how, because we've asked police departments to spend all this money getting the best possible evidence, now we're going to punish them if somebody doesn't turn their camera on. And there can be a multitude of reasons why they don't.
And one last question, and this is for Mr. Franklin. Why did you shake your head earlier?
I shouldn't have done that. I shouldn't have said that. Good move.
I shook my head earlier because of what you were just discussing. It doesn't say knowing or willful. I mean, it says knowing and willfully, and to me, it reads that there's nefarious activity. There's some maliciousness here. They're trying to hide something or cover up something or not have something show up on video. And I know that's the intent of this bill, Senator. I know what that's about. But that's why I was shaking my head. And to also responding here to answer Senator Cassidy's response. And yeah, maybe I did speak in a way that it was misunderstood when I said the term generally. What I meant to say is that there's enough evidence out there to show that this is a problem, with the misuse of these body cams across the nation. There's enough for us to do something about it. And I'd also like to say that when it comes, and I get it what you're saying about the victims and what about the victims of crime and so on. But this is a country that, I hope that we truly believe that a person is innocent until proven guilty, and that we are a country that is about evidence, and the importance of evidence. So I just wanted to say that there are times when the person who is interacting with the police officer, who we consider maybe a suspect, there are times when they're also innocent too. So just to have policies and laws and things in place to protect as many of us as we can, all of us. Again, if a police officer is abiding by training, abiding by policy, and what we instill in them and what we want them to be, then they're going to do the right thing. Whether it's a body cam, whether it's how they interact with one of our citizens out there in the public, this is about improving the profession. This is about weeding out those who don't deserve to wear the badge. And we have to continue that daunting task of doing that. And this is a piece of that. Thank you.
Thank you very much, Mr. Chair.
All right, I think Senator Jackson, I'll get you, and then we'll go back to Senator Castley. As a gentle reminder to the committee, we do have a voting session that follows our hearing here today.
Thank you. Thank you, Mr. Chair. And two things, well, three things. Senator Castley, I'm glad you spoke. You made your statement. I was trying to digest the statement. And Neil, I'm glad you rethought that statement. I know what you meant. But the public and the folks who are providing this service, that both you and I have enjoyed and learned a lot, and know that there are a lot of things we need to improve. We don't want anyone to get the wrong impression. And look, I'm new, a little over a week in JPR, but certainly not new to this environment. And I can tell you that I'm looking forward to this trek and bringing about accountability when necessary, and weighing that with all the stakeholders, because I think what our public and our all of our constituents are going to see, I'm hoping that they're going to see us look at accountability at all levels of law enforcement, and then eventually we get into the rest of our criminal justice system, because I certainly don't want the men and women who served with me, who I was a member, who I was a union president of, who I was a sheriff for, and who I worked with agencies throughout the state, leadership development for public safety, to believe that it's only the officers, because accountability, is a systemic the systemic challenges with this profession are the things that we're trying to address. And, we're only at the beginning. That's what I like to say. So thank you for the time, Mr. Chairman.
Thank you, Senator Jackson. Again, we're so pleased to have you on board as we go through this process, especially. So glad to have your expertise at the ready. All right, Senator Castley, floor is yours.
Yeah, just briefly, the knowing and willful language, just focusing on that for a second, and as I know Senator Sidnor did, and it made me just question whether the necessity of the bill at all, because I just can't imagine a criminal trial where we're going to come in and say the officer, with the intent to hide the evidence, turned his camera off, and that defendant's not walking. I just can't. I'm not sure what the bill does then, because once it comes out that the court concludes that, yes, the officers, he didn't turn it on because his intent was to hide the evidence, then it seems to me it's over and the bill's not necessary. But I think, Mr. Schellenberg's looking at sort of a lower standard of that would say, well, we know it's knowing and willful because you were sitting in your car, you were relaxed, you had the call come on, you were told to turn it on, and you didn't turn it on, that's close enough to knowing and willful for us, because there was no exigent circumstance, for example. Nobody was shooting at you. You got a calm call, go investigate this. So anyway, I'll shut up from there. Thank you.
All right, thank you, Senator Castley. And with that, I think that concludes the testimony and the hearing for Senate Bill 166, or 71 rather. And that then concludes the hearings for the day. So thank you all for being here.
Thank you all for your patience with me.
Senator Sidner, good to see you.
Good to see you, likewise. And for the senators here, we have a voting session. We have 13 bills on the list. And so if you could come down to the committee room in 10 minutes. Remember, we only have 2 hours to complete the voting. So we can only be in the room for 2 hours at a time. So let's be as efficient as possible. But look forward to seeing you all down here in 10 minutes. All right, see you all later.